Yeah. All circuit court, on the judge David Williams preside.
Please bow your head for a moment of silence, please. Please bow your head for a moment of silence, please.
Thank you. Yeah. Where's he? Yeah. So we go to Vegas, we got that. He's not scared. Yeah, he's had all the stuff. Yeah, right.
Yeah, sorry about that.
Go back.
They were like this, we didn't know. I started just figured out.
Scott Barlow,
Yeah, so, yeah.
Bring him out.
bring him out.
Okay.
Commonwealth versus Scott Barlow, 25 CR 0016. Are you Scott Barlow? Good morning. Were you born in 1971?
Yes, sir.
Last four digits, social security number 1542.
Yes, sir.
Okay. What does the Commonwealth have in this case?
We're ready for a trial. That's what we did.
Yes.
What's charged?
Fail to receive a utility trailer and the tools. Over 10,000. Probably a day.
Pardon?
A day would be.
You don't have any witnesses out of town or any, no expert witnesses? Let's look on the 13th and 14th of May. We already have trial scheduled that day. Just tell me if you're gonna go.
As of right now, they're both gone.
Okay, one of them is Moles
Yes,
and the other one is Shaw.
that's correct.
We can have one, we can have it on May the 23rd.
That's fine with me.
Your Honor, my wife is pregnant and her due
You
date's my wife is pregnant right now and her due date's,
Congratulations.
thank you. Her due date's the 27th, so. I mean, I could do the 23rd if necessary, but. I'm not sure.
Well, you won't, you wouldn't be sure if we did it next week. I got
That's true.
news, I got news kind of for you. We'll just go ahead and schedule it. And if you needed to get it off, that seems like pretty good,
Okay,
excuse.
thank you, Your Honor.
It is.
I'm sorry.
Please see it out.
Okay. Commonwealth versus Sherry Cordia.
didn't look at that.
I have, yeah.
We just done the paperwork this morning on that case, we can pass it.
Pass over that, we'll come right back to it. We'll come right back to your case. I got some paperwork they want to go over, okay?
Get full of credit.
Eric Crabtree. Commonwealth versus Eric Crabtree, 25 CR 00014. Are you Eric Crabtree?
Yes, sir.
Good morning. Were you born in 2006?
Yes, sir.
Last four digits, social security number 5726. We have a pretrial conference. What's the Commonwealth have to say?
We're also doing paperwork on this one this morning. There you go.
Okay. We just, they'll have some paperwork they want to go over with you in a few minutes, so you'll
Yes, sir.
step back there. Oscar Farley.
That's all you want to. That's all you do. Okay.
Oscar Farley. Commonwealth versus Oscar Farley, 24 CR 0054. You Oscar Farley,
Yes, sir.
good morning.
More.
You 1992,
Yes,
last four digits, social security number 5643.
yes.
Okay, what does the Commonwealth have in this case?
Felony plea.
Okay. As you just heard, Mr. Farley, I've been informed that you wish to enter a plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this free and voluntarily given?
Yeah,
Same person we just identified in 24 CR 0054. Is that correct?
Yeah.
Is your judgment impaired today anyway?
no,
Have you discussed this matter with your attorney and are you satisfied with his advice?
yes, sir.
When you read the evidence Commonwealth has against you, feel like you're fully informed about your case.
Yes, sir.
You have certain rights under the Kentucky United States Constitution. Before I accept the plea, I need to know that you understand those rights. I'm going to go down through the rights and then I'm going to ask you to understand. If any time that you need to talk to your attorney, step away from the podium, any time to do that, okay? You have a right not to testify against yourself. No one can make you say anything, right to speak trial by a jury. Right to be represented by counsel at your jury trial, the right to confront, cross-examine all witnesses called to testify against you, right to produce evidence, right to call witnesses in your favor. The right to appeal this matter to higher court if you lose, and the right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charge against you. Understand that by entering a plea of guilty, you give up all those rights. You understand that?
Yes, sir.
Okay, now I may consider the Commonwealth's recommendation, but I may apply any range of sentence around the law. I don't have to accept the recommendation. Prior to accepting the recommendation, I always pre-sentence investigation report from probation. In the event that I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea of guilty and proceed to trial. You understand that?
Yes, sir.
Okay, Ms. Gordon Anderson, what is the Commonwealth's recommendation?
Yes, Your Honor. Upon a plea of guilty to possession of a controlled substance first degree, the defendant shall receive a sentence of 1 year to serve. The defendant shall receive credit for time served. This 1 year sentence shall run consecutively to Cumberland indictment number 19 CR 89. The Commonwealth opposes probation and shock probation. The defendant agrees to have any and all contraband and controlled substances disposed of in accordance with the laws of the Commonwealth and the holding agency.
What are you pleading guilty to?
It's a possession of a controlled substance first degree.
Is that your understanding of the Commonwealth's recommendation?
Yes, sir.
Has anyone, including your attorney, threatened you to do this?
No,
Are you pleading guilty because you did commit the acts charged in the indictment as amended?
yes, sir.
You do so of your own free will.
Yes.
Knowing your constitutional rights, that explains to your desire to proceed with the guilty plea and allow the court to fix your punishments with the law.
Yes, sir.
And you understand that by entering this guilty plea, if you have future conviction of felonies, this could be used to enhance the range of penalty on a persistent felony offender law. You understand that? Is that your signature on the document?
Yeah.
I'll accept the agreement order pre-sentence investigation report and schedule sentencing for May the 12th.
Your Honor, Mr. Farley also wanted to know if it would be possible to waive final sentencing.
He's a state prisoner now? Has he been since this has been going on? Is it possible to do it?
I believe so, Your Honor.
Okay, we'll do that. We'll impose the sentence.
Thank you, Your Honor.
Okay. Jeremiah Fulton. Shoot. South. Are you Jeremiah Fulton?
Yes, sir.
Okay, this is, good morning. This is 25 CR 0015. Cumberland Circuit Court, you born in 2006.
Yes, sir.
Last four digits of your social security, 1424.
Yes, sir.
Here for pretrial conference, West Commonwealth.
Your Honor, he's a co-defendant with Mr. Crabtree, and we're working on paperwork for both of these cases.
Okay, Cody Stinson. We'll bring you back out in a minute when I get the paper. Cody Stinson.
And same on Mr. Stinson, we had prepared paperwork earlier, but we're amending that, so
Cody Stinson.
we'll have him say.
Okay, we're ready for Thomas O'Donnell. Commonwealth versus Thomas O'Donnell, 22 CR 00103. You are Thomas O'Donnell?
Yes.
Good morning.
Morning.
We're here on motions, a motion of the Commonwealth to set trial, and we have two other motions that have been filed by the defense counsel. One of the motions has about the formation of the jury. I'll hear that first.
Your Honor, that's our motion to attend juror orientation. So we're asking the court to enter an order that the defense be notified of when orientation will take place.
What day is it? I can tell you right now what day it is.
It is, June 26th.
June 26th. Okay.
At 9 a.m. 2 p.m. Okay. And we're asking the court to allow us to attend that and observe.
It's open to the public, but I'll put it in order. I'll tell you something else to get on the record I'm doing. Because of the nature of the action, I'm going to do all the jury excuses myself. Usually we delegate it to clerks and they do a fine job, but we need to make sure the pool is large and is varied. And I think that, I will probably restrict the number of excuses we do in the past. It makes the jury pool more random. The fewer excuses you have, it becomes more random and it lets the computer pick those. So I'll do that and that way you can inspect all the excuses that we have and the reason for which you'll want to do also.
Yes, Judge, thank you.
Okay, now what's your other motion?
Our other motion is just for disclosure of the Commonwealth's expert witnesses under RCR 7.24.
Well, I think we have a reciprocal order in place in this.
We should have, and I don't have any objection to as long as the order tracks the language of 7.24, I would object to the proposed order because I think it's overly broad. Because it requires all prior reports, which I have no problem with, statements or recordings of the expert related to the subject matter. I don't know, when you use the word statements, that's so overly broad. I couldn't tell you what statements I've made today in court. I don't understand where you're going with that.
Just draft the order to reflect the rule. That's what the Commonwealth's saying.
Yes.
I'll
We
sign
can do
the
that.
order.
Yeah.
I'll sign the order to
Thank you.
get through. And I would assume that on that orientation day, I'll direct the clerk to make copies of for the Commonwealth and for defense of any people that have been excused, so that you might be able to look at those. Hopefully the defendants.
Thank you, Judge.
Thank you very much.
Then we have the motion set for trial.
Yeah, well,
And we have, I think, a date in mind if the court's available. And because of Ms. Searcher's schedule, Ms. Costello's schedule, we were looking at the last week of October, I believe. Is that right? The 27th?
That's correct.
And I need some time ahead because I have witnesses that'll be
now let me look at our.
from all over the country.
Well, the last week in October, the full week we have in October starts on the 20th, 21st and
So
22nd.
that would be fine with me. I don't
Well,
know.
but that's the judicial college that's
Oh.
mandatory that I have to attend.
Okay.
Okay, the next day we have, the next week has come the motion day. So we don't have a full week on that. And I don't want to set the jury and then let them go over the weekend without keeping them together.
Could we do the week of the 27th and kick the Cumberland Motion Day over to November and I guess that'd be October 31st. Let's see, October, no? No, it wouldn't kick it over to the Clinton Motion Day on the 6th. That wouldn't work. So. we couldn't do
We've
that.
got the,
We could do it on the 2nd, 3rd or 4th of November if you want to take the Cumberland Motion Day.
Just that the 4th is election day is the only issue. That's fine. with me,
Anybody,
but-
I don't think there's election.
Oh, and irrelevant.
when is Thanksgiving?
The 27th, Judge.
So that takes that week there, 24th, 25th, 26th, 27th. Okay, let's bump the rule day to the 23rd. That's the day after the judicial college.
Oh, that'll work.
Yeah.
And all the way into the next Thursday.
So we start on the 27th. What was it, yes? 24. What was it?
That's
27th.
Yeah, that's next.
Yeah, it's got, this thing, what it is, covers the calendar up when I'm making changes. Twenty-seventh through the 31st. Okay.
Thank you, Judge.
Thank
Cody, did we have, Cody Stinson was another one. Wait. No, take him on. Don't bring anybody else. And do you have anybody else that's that is incarcerated that's ready? Mr. Stockton?
No, we missing.
So you got Cora, Crabtree, Fulton, and Stinson. Is that correct?
That's correct.
Okay.
It's coordinated.
Okay, let's go,
We're ready on jury. Yeah.
Poirier, bring Jerry Poirier.
Jury.
Cromwell versus Jerry 48, 25 CR 009. Mr. Corey, we're ready for you this time. They weren't ready last time. This is, you were born in 1990?
Yes.
Last 4 digits, social security number 3148.
Yes.
What does the Commonwealth have to say about this?
Felony plea, Your Honor.
A motion is just been tendered that says you wish to enter guilty plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes.
The person, you speak up just a little, okay, the person that we just identified in 25 CR 009, that's you, correct?
Yes, sir.
Is your judgment impaired today in any way?
No,
Have
sir.
you discussed this matter with your attorney? Are you satisfied with his advice?
Yes, sir.
And you, the evidence the Commonwealth has against you, believe you're fully informed about your case.
Yes.
You understand that you do not have to enter a guilty plea. You have certain rights under Kentucky and the United States Constitution. Before I can accept the guilty plea, I know that I need to know you understand those rights. You have a right not to testify against yourself. No one can make the same thing. Right to speed trial by jury, right to be represented by counsel at your jury trial, right to confirm and cross-examine all witnesses called to testify against you, right to produce evidence, right to call witnesses in your favor, right to appeal this matter to a higher court if you lose, and right to acquire the Commonwealth proof on reasonable doubt that you're guilty of the charges. That you understand that by any guilty plea, they will give up those charges.
Yes, sir.
I may consider Commonwealth's recommendation, but I may apply language sense private law. I don't have to accept your recommendation. Prior to accepting the recommendation, I will wait to pre-sentence investigation. Report done by probation and parole. In the event that we do not accept the Commonwealth's recommendation, you decide to impose a harsher sentence, you have to withdraw your plea of guilty and proceed to trial. You understand that?
Yes, sir.
Ms. Gordon Anderson, what's the Commonwealth's recommendation in this case?
Yes, Your Honor. Upon a plea of guilty to possession of controlled substance, first degree, the defendant shall receive a sentence of 3 years, serve 180 days, balance probated for 5 years. Probation is to be supervised. The defendant shall pay court costs at the discretion of the court. The defendant agrees to be assessed by the social services clinician and follow any recommendations. The defendant agrees to forfeit the Taurus 38 special revolver and high point serial number P10140734, including all ammo in said case, to the Burkesville Police Department to be disposed of in accordance with the Commonwealth of Kentucky. The defendant shall obtain gainful employment or do 30 hours per week of community service until gainful employment is obtained. The defendant shall remain on active supervision until any and all fines and court costs are paid in full and until further request of probation.
What's he pleading to again?
It would be to possession of a controlled substance first degree. The sentence would be 3 years, serve 180 days, and it's probated for 5 years.
That's a firearm.
He's forfeiting it.
Was he charged with the firearm?
No, he was not. It was 3.5 grams of methamphetamine, and the guns looked like the gun was located in the passenger floorboard. He was the driver.
Is that your understanding of the Commonwealth's recommendation?
Yes, sir.
Are you pleading guilty because you did commit the acts charged in the indictment?
Yes, sir.
Are you doing so of your own free will?
Yes, sir.
Knowing your constitutional rights have explained that it's still your desire to give up those rights by entering a plea of guilty to the charges and allow the court to fix your punishment and range permitted by law.
Yes, sir.
You understand that after entering this plea today, any future convictions could enhance the range of penalty.
Yes, sir.
Is that your signature on the motion and offer?
Yes, sir.
I'll accept it, order pre-sentence investigation report to be done by probation and parole and schedule sentencing on May the 12th.
Yeah, thank you, Your Honor.
Good one. I was looking at the wrong list. May 22nd. Looking at the district court, let's set some bigger print. May 22nd. So I don't think we've informed anybody else that would affect. When is your negotiation day, May?
May the 16th, 9 a.m.
May 16th. Do you have any other ready as far as the in custody votes?
No, we can wait a few minutes.
Okay, Angela Allen. This is active warrant. Angela Allen. She's what?
She's in jail.
You got a holder on her? Timothy Boggs, or Raymond, Timothy Boggs. Good morning. Are you Timothy Boggs? Were you born in 1999?
Yeah.
The last four digits, social security number 4290.
Yes.
You're on 25 CR 0021 for arraignment. Do you have an attorney? Where is your attorney? You come on. You're here for the purpose of arraignment. You have a right to remain silent. The grand jury of Cumberland County has returned an indictment charging you with trafficking in controlled substance in the first degree and possession of drug paraphernalia. You understand what those charges are? Counsel, do you acknowledge the identity of your client, receive the indictment, waive formal reading and arraignment, enter a plea of not guilty, reserving all pretrial motions?
Yes, sir.
Negotiation day is May the 16th. At what time did you say? 9 a.m. And your next court date is May the 22nd at 9 a.m. Both of those are conditioned to your bond. I'm signing a reciprocal discovery order here that requires the Commonwealth to give you return information they have to help you prepare for your case. Okay? Thank you. Thomas Bradshaw. That's just a motion for destruction of evidence. Thomas Bradshaw here. What is the evidence? Sure.
We had a very commons.
What is it? Baggy.
Yes.
So there's no objection to submit the order. William Brooks. Commonwealth versus William Brooks, 25 CR 0065. Are you William Brooks?
Yes, sir.
Good morning. Were you born in 1983?
Yes, sir.
Last four digits of your social security number 7291.
Yes, sir.
And what does the Commonwealth have to say about Mr. Brooks?
Pretrial diversion.
I've just been informed that you filed a motion. Motion's been tendered. Did you wish to enter a plea today? Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
You're the same person that we just identified as 25 CR 0005, correct?
Yes, sir.
Have you discussed this matter with your attorney and are you satisfied with his advice?
Yes, sir.
Is your judgment impaired today in this law?
No, sir.
Are you satisfied with the, have you reviewed the evidence the Commonwealth has against you? You believe you're fully informed about your case?
Yes, sir.
You understand that you do not have to enter a guilty plea today. You have certain rights under Kentucky and the United States Constitution. Before I can accept the plea, I need to know that you understand those rights. I'm going to go over them and then at the end of them, I'm going to ask you, okay?
Right.
You have a right not to testify against yourself. No one can make you say anything. You have a right to speak trial by jury. You have a right to be represented by counsel at your jury trial. You have a right to confront and cross-examine all witnesses called to testify against you. You have a right to produce evidence, a right to call witnesses. You have a right to go this matter to higher court if you lose. You have a right to require the Commonwealth to be unreasonable doubt that you're guilty of charge against you. Understand that by entering a plea of guilty, you give up all those rights. You understand that?
Yes, sir.
Now, I may consider the Commonwealth's recommendation, but I may have an evidentiary sentence allowed by law. I don't have to accept the recommendation. In the event I don't accept the Commonwealth's recommendation, decide that, we get a harsher sentence, you have the right to withdraw your plea and proceed to trial. Do you understand that?
Yes, sir.
I want to ask you some qualifying questions. Have you previously been diverted in the last 5 years?
No, sir.
Have you had any felonies in the past 10 years?
No, sir.
Are you currently on probation?
No, sir.
You understand that if you fully complete the diversion agreement, the charges could be dismissed and your record could be expunged. You understand that?
Yes, sir.
Do you understand that if you not fully complete the diversion program, if you're brought back in front of me and schedule a hearing, I revoke the pretrial diversion, you be a convicted felon, and I would sentence you up and have a report on that probation parole investigation. What is the Commonwealth's recommendation?
Judge found a plea of guilty to forgery in the second degree. The defendant shall receive a sentence of 5 years, pretrial diverted for 5 years, with the diversion to be supervised.
Is that what you agreed to?
Yes, sir.
And
I'll go ahead.
the defendant agrees to enroll and complete the Cumberland County Specialty Program, shall receive credit for time served, shall be released at orientation for the Cumberland County Specialty Program. Additionally, the defendant agrees to pay restitution in the amount of $175 to the Citizens Bank of Cumberland County, payable to the circuit court clerk to be paid in full within 90 days from the entry of this plea. Defendant shall obtain gainful employment or do 30 hours per week community service until gainful employment is obtained. Yeah.
Swing back to your fence. Are you pleading guilty because you committed acts charged in the indictment?
Yes, sir.
Did you plead guilty of your own free will because you are guilty for no other reason?
Yes, sir.
Know your constitutional rights that explain to you that still your desire, give up those rights, enter guilty plea, and allow the court to fix your punishments for the law.
Yes, sir.
Okay, now you know if you get revoked and sentence you as a felon, that can be used against you in the future, you know that?
Yes, sir.
Okay. I accept the agreement. I will sign the diversion order. Has he been voted? Has he been voted in yet, Mr. Hunter?
I think so. You not say it's you can. No, he went to be voted in. I can say it's.
Do I believe on the same bond?
That's fine, come on.
We're on the same bond. And you need to make sure that you check with Mr. Murphy to find out when our probation poll officer's right there, and you need to talk to him. Caleb Day. Caleb Day.
Stepped out of the record.
Mr. Brooks, that is your signature on the document, right? You signed the document? Okay, thank you.
Thank you.
Michael Diamond, says active warrant out.
It's the gas. I'm putting on right before we get ordered.
Okay, Alfredo D. Gaz, active warrant out.
We put in NCIC also in Boston.
Caleb Day. Caleb Day. Commonwealth versus Caleb Day, 25 CR 0013. Are you Caleb Day?
Yes, sir.
Good morning. Were you born in 2006?
Yes, sir.
Last four digits social security are 7613.
Yes, sir.
What does the Commonwealth have in store for Mr. Day?
Pre-trial burden.
Mr. Day, a motion has been tendered, as you heard, that says that you wish to enter a plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
The same person that we just identified in 25 CR 0013. 0013, is that correct?
Yes, sir.
Is your judgment impaired today in any way?
No, sir.
Have you discussed these charges with your attorney, and are you satisfied with his advice?
Yes, sir.
Have you used the evidence the Commonwealth has against you, believe you're fully informed about your case?
Yes.
You understand that you do not have to enter guilty plea today. You have certain rights under the Kentucky and United States Constitution. I need to know that you fully understand those rights. I need to go down through the rights, and then I'll ask you, okay? You have a right not to testify against yourself. No one can make you say anything. Right to speedy trial, right to be represented by counsel at your jury trial, right to confirm, cross examine all witnesses called to testify against you, right to produce evidence, right to call witnesses in your favor, right to appeal this matter to higher court if you lose, and right to comply with the Commonwealth proving on a reasonable doubt that you guilty charge against you. You understand? Anyway, guilty plea today, you give up all those rights. You understand that?
Yes, sir.
I may consider the Commonwealth's recommendation, but I may apply any range of sentence for the law. I don't have to accept the recommendation. In the event that I don't accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have a right to withdraw today and proceed to trial. You understand that?
Yes, sir.
I have some qualifying questions I need to ask you. Have you previously been diverted in the last 5 years?
No, sir.
Have any felonies in the past 10 years?
No, sir.
Are you currently on probation?
No, sir.
You understand that if you fully complete the diversion agreement, the charges could be dismissed. However, and your record expunged. Do you understand that?
Yes, sir.
Okay, however, if you do not complete the diversion program, and brought back and forth in front of me, and I revoked the pretrial diversion or a pre-sentence investigation court. You'll be sentenced at a sentencing hearing, and you'll be a convicted felon, and that can be used against you in the future. You understand that?
Yes, sir.
What is the Commonwealth's recommendation, Ms. Gordon Anderson?
Upon a plea of guilty to wanton endangerment first degree, one count, and criminal mischief first degree, the defendant shall receive a sentence of 5 years on each charge to run concurrently for a total of 5 years, pretrial diverted for 5 years. Diversion is to be supervised. The defendant agrees to serve 90 days home incarceration. The defendant shall have work release. The defendant agrees to have no contact with the victim. The defendant shall pay a fine and court costs at the discretion of the court. The defendant agrees to be assessed by social services clinician and will follow any recommendations. The defendant agrees to enroll in complete anger management classes. The defendant shall pay a reasonable storage fee and total bill to obtain said vehicle, a 2012 Ford Focus VIN 1FAHP 3F20CL226055 from impound lot. The defendant shall obtain gainful employment every 3 hours per week of community service until gainful employment is obtained. The defendant shall remain on active supervision until any and all fines and court costs are paid in full and until further request of probation and parole.
What was your, give me a little background on this. What did you do?
Ran into a car going 20 miles an hour.
You ran into somebody.
Yep. This is important, but they, otherwise we wouldn't be good. I was probably harder.
It's all right, you know, I just want to know what it was. Is that your understanding of the agreement you made with Commonwealth?
Yes, sir.
Okay. Are you pleading guilty because you did commit the acts charged in the indictment?
Yes, sir.
You so your own free will?
Yes, sir.
You know, your constitutional rights explain to the state you desire to give up those rights, enter guilty plea and allow the court to fix your punishment and arrangement with the law.
Yes, sir.
Is that your signature on the document?
Yes, sir.
Except for your, what are the court costs?
$220.
$220. You need some time to pay that.
Yes, sir. I can make payments on it.
Okay, we pay the first payment, 30 days from maybe $30 and $30 a month. You need to meet your obligation on that. And then you got restitution to make. How much a month is that?
It's in the restitution ownership.
What is it, you know what, the restitution?
I don't know if there were restitution with this.
No, there was zero. There was damage, but the insurance must pay. I thought there would be restitution, but there's not.
How much damage was done?
I think it's like $1,200.
So that means the rest of us, our insurance goes up because this guy rammed somebody.
That's right.
My insurance is enough without your help. You know, I don't know how I really feel about it.
Well, I understand I can't recover for you.
I understand that.
Yeah.
I understand.
Your Honor, he also was wondering, he has a custody arrangement with an ex, not the victim in this case, but he sees his child, I think, every Sunday. Would it be okay for him to continue with that while under the home incarceration?
You gonna have an ankle bracelet on?
Yeah.
Do they bring, where do you visit your child?
Hill Street,
You what?
right up the street.
Right up the street.
Yeah, I don't know the name of the street.
Where do you live?
On
Down the
South
street?
61.
You where?
On South 61.
Yeah. And so you usually visit at someone's home?
Yes, sir.
I have no objection to him visiting the child in the home. You go straight there and straight back. You understand what I'm saying? No reason to punish your child. Okay. You meet the probation and parole officer right there.
Thank you, Your Honor.
Randy Franklin. Commonwealth versus Brandy Franklin, 25 CR 0012. Are you Brandy Franklin?
Yes, sir.
Born in 1983. Last four digits, social security number 0412. We're here for a pretrial conference. So you have signature.
I have a misdemeanor plea on possession of drug paraphernalia.
A motion been made that says you wish to enter guilty plea today. Is that correct? Are you currently under the influence of drugs or alcohol?
No, you're.
This is plea freely and voluntarily given. You the same person that we just identified in 25 CR 001-2?
Yes.
Is your judgment impaired in any way today? Have you discussed these charges with your attorney? Are you satisfied with his advice?
Yes, sir.
As you view the evidence Commonwealth has against you, understand that, and feel like you're fully informed about the case. You understand you don't have to enter a guilty plea today. You have certain rights under the Kentucky United States Constitution. Before I accept a plea, I need to know that you understand those rights. You're right, not to testify against yourself. No one can make the same thing right to speedy trial. Jury right to be represented by counsel at your jury trial, the right to confront and cross them and all witnesses call and testify against your right to give evidence, right to call witnesses, you can pay the process issue, compel their attendance. You have a right to appeal this matter to higher court. If you lose, right to try to Commonwealth, prove your unreasonable efforts, your guilty charges against you, understand that any guilty plea, that you give up those rights. I know that Sarah Commonwealth's recommendation, but I may apply the range of sentence by law, I don't have to accept it. And even if I do not accept Commonwealth's recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea. You understand that and proceed to trial. Mr. Stockton.
Your Honor, Ms. Franklin will plead guilty possession of drug paraphernalia, receive a sentence of 12 months, probated for 2 years. Probation is to be unsupervised. She would pay a fine of $200, pay court costs of discretion of the court, maintain gainful employment, and have no violations of the law.
Is that what you read to?
Yes, your honor.
What's the court cost?
Hers is $420, that's including the fine.
It's not a DUI, $420. You need some time to pay that?
I do.
Okay, you need to pay it $40 a month, first payment, 30 days from today. Are you pleading guilty because you did the amended indictment, because you are guilty of the acts of the charge? Is that correct?
Yes, your honor.
Know your constitutional rights to explain to you as it's city you reside, to proceed on all the court to fix your punishment in the range of the law. That's your signature in the document.
Yes, your honor.
I'll accept these. Now, I want to tell you something. This, you know, you're not getting a felony conviction. But if you violate, you'll be serving 12 months in county jail, which in a way is more time than you have to serve on 2-year felony. But you understand that. So you and I are clear about this. You're gonna live at the foot, right?
Yes, your honor.
Okay. Meet the probation and parole officer. Thomas Hoff. Public advocacy, I think, represented you in the district court, is that right?
Yes, sir.
How do you say your last name? Is Hoff correct? Yeah.
Like hit you with it.
Yeah. Commonwealth versus Thomas Hoff. This is one of yours,
Yes, Your Honor.
25 CR 0022. Mr. Hoff, were you born in 1974? This is the last 4 digits of social security number 1620. You're here today for the purpose of arraignment. You have a right to remain silent. If you have any questions, you can step away from the podium and ask your attorney. The grand jury of Cumberland County has charged you with possession of methamphetamine, extra degree, possession of drug paraphernalia, speeding, and improper display of registration plates. Counselor, do you acknowledge the identity of your client, receipt of the indictment, waive formal reading and arraignment, enter pleas not guilty, reserving all pretrial motions?
Yes, Your Honor.
Mr. Hoff, I'm signing a reciprocal discovery order that requires the Commonwealth to give your attorney all the evidence that they have at this junction to help you prepare for your defense. You'll be here for a negotiation day on May the 16th at 9 a.m. and your next court date is May the 22nd. Negotiation day allows you to have time with your attorney to go over the charges, that sort of stuff, and meet with the Commonwealth, see what y'all can. So both the 16th and 22nd at 9 a.m. are conditions of your bond, okay? Thank you very much. Billy Huddleston. Billy Huddleston. Are you Billy Huddleston?
Yes, sir.
Good morning. We usually have public advocates in district court. You're on 25 CR 0025. 25 CR 0025. Mr. Huddleston, were you born in 1962?
Yes, sir.
Last four digits, social security number 3418.
Yes, sir.
You hear with perfect related, you have a right to remain silent. Grand jury of Cumberland County has returned to indictment charging you possession of controlled substance first degree mental impairment and possession of drug paraphernalia. Do you understand those charges?
Yes, sir.
Counselor, do you acknowledge the identity of your client, receive the indictment, wait formal reading, and enter plea not guilty, reserving all pretrial motion?
Yes, sir.
Mr. Huddleston, you're to be here on May the 16th at 9 a.m. for negotiations with your attorney. And May 22nd is your next court date. Both of those are conditions of your bond. Understand that?
Yes, sir.
Okay, thank you very much. Please go. Eric Lundy. Commonwealth versus Eric Mundy, 25 CR 0010. Are you Eric Mundy?
Yes, sir.
Good morning, Mr. Mundy. Were you born in 1984?
Yes, sir.
Last four digits, social security number 9334.
Yes, sir.
You're on a pretrial conference. What does the Commonwealth have to say?
The felony plea, Your Honor.
Okay. Mr. Mundy, as you just heard, a motion, Commonwealth says a motion's been tendered, says you wish to plead guilty. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
Are you the same person we just identified in 25 CR 0010?
Yes, sir.
Is your judgment impaired today in any way? I'm here to discuss this matter with your attorney. Are you satisfied with his advice?
Sir.
Have you reviewed the evidence the Commonwealth has against you to believe that you are fully informed about your case?
Yes, sir.
You understand that you do not have to enter guilty plea today. You have certain rights. Under the Kentucky and the United States Constitution, before I can accept the guilty, I need to know that you understand those rights.
Yes,
You
sir.
have a right to, you have a right not to testify against yourself. No one can make you that. So you have a right to speak out of the jury. Right to be represented by counsel at your jury trial. The right to confirm false examine all witnesses called to testify against you. The right to produce evidence. The right to call witnesses in your favor. The right to have process issue and compel attendance. You have a right to cross matter higher court if you lose. You have a right to Commonwealth to be done reasonable after you go to charge. Once you understand that any of the guilty, then you have all those rights. You understand that?
Yes, sir.
When they consider the Commonwealth's recommendation, when they apply major sentence without law, don't accept the recommendation. Prior to accepting the recommendation, I'll roll the pre-sentence investigation report number probation and parole. In the event that I do not accept the recommendation and decide to impose a harsher penalty on you, you have a right to withdraw your plea. You have to proceed to trial. Do you understand that?
Yes, sir.
Mr. Gordon Anderson, what is the Commonwealth's recommendation?
Yes, Your Honor. Upon a plea of guilty to possession of a controlled substance first degree, the defendant shall receive a sentence of 2 years, probated for 4 years. Probation is to be supervised. The defendant shall pay a fine and court costs at the discretion of the court. The defendant agrees to be assessed by the social services clinician and will follow any recommendations. The defendant shall obtain gainful employment or do 30 hours per week of community service until gainful employment is obtained. The defendant shall remain on active supervision until any and all fines and court costs are paid in full and until further request of probation and parole.
Since how long again?
2 years probated for 4.
And what did the court cost this year?
Yeah, it's 245.
How much?
245.
245. Okay, is that what your agreement is with the Commonwealth?
Yes, sir.
Are you pleading guilty because you did commit the acts charged in the amended indictment?
Yes, sir.
Then so you're on free will.
Yes, sir.
One of your constitutional rights is 2 years out of pursuit allow me in court to fix your punishment. Okay. You understand that any of this guilty for any future convictions can be enhanced under persistent felony offense law. You understand that?
Yes, sir.
Is that your signature on the offer?
Yes, sir.
Okay, Alex, accept the agreement, order pre-sentence investigation for, have you come back here on May the 22nd for sentencing. You need to meet with the probation officer there.
Sir.
Joseph Harlan. Commonwealth versus Joseph Parham. Parham 21 CR 0012. Did you say Parham or Parent?
Harlem,
Parham, okay. Mr. Parham, were you born in 1993?
yes, sir.
Last four digits, social security number are 6766.
Yes, sir.
You're on probation, revocation, what's the Commonwealth have to say?
Your Honor, the Commonwealth filed this motion to revoke probation. He had a no insurance charge. And when I looked at that, he was showing he hadn't worked in the last year in the computer system. I corresponded with his probation officer. He got back with me late yesterday or this morning. He's got the no insurance taken care of and he's working at the healing place. So the Commonwealth's willing to withdraw this motion if that's all right for the court.
Be on your way rejoicing.
Okay.
Yes, Your Honor.
Thank you, Your Honor.
Danny Pippen. Are you Danny Pippen?
Yes, sir.
Did you have a public defender in?
Yes, sir.
This is 25 CR 0017, Mr. Pippen. You born in 1980? Yes, sir. Last four digits, social security number 8968. Here today for purpose of arraignment. You have the right to remain silent. If you have any questions, step away from the podium, ask your turn quietly. Ranger Cumberland County has returned indictment for you possession of controlled substance, first degree. Possession of drug paraphernalia, failure to signal, obstructed vision or windshield. You understand what those charges are?
Sir.
Counselor, you acknowledge the identity of client receiving that away form where you can interpret not guilty as already on pretrial motion.
Yes, Your Honor.
Mr. Pippen, you are to be here on May 16th at 9 a.m. for negotiation day. And May the 22nd at 9 a.m. your next court day. Both those are conditions of your bond. You decide what? Okay. You need to come over here and give us some information for the trial. It's okay. Robert Redmond, it's evidently it's a Dare County case. Robert Redmond. Sentencing. You're Robert Redmond.
Yes, sir.
17 CR 006 at Air Circuit Court, meeting by agreement in Cumberland County. Were you born in 1951?
Yes, sir.
Last four digits, social security number 3070.
Yes, sir.
You're here today for sentencing. Have you had an opportunity to look at the pre-sentence investigation,
Yes, sir.
report number, probation, and parole? Is it substantially correct?
Is it, I think, for? Yes, it is.
Okay. Is there any reason this gentleman should not be sentenced?
No, Your Honor.
Who's handling the prosecution?
I'm Brian Wright. He's online.
Mr. Ryder, you there? I understand that the agreement was 2 years, probated for 2 years. Is that correct?
That is correct, Judge.
Okay. So I'll send you 2 years. And what's the court cost of this? Can you give us the approximate now? Mr. Wright, you know what court cost on regular felony usually is?
I have no idea, Judge.
Well, I'm gonna do it $215 and probably more than that. That's what we get here. You can pay, can you pay that now or you need some time? Okay, you can pay the clerk's office downstairs here. In the Dare County, go to the Dare County clerk's office and pay $215 within 10 days. Now you'll need to meet with the probation and parole officer. When can he do that?
He can come to office on Monday in Columbia, Your Honor.
Okay. Well, on Monday, you know where the probation and parole office is up there. Go there on Monday by 10 o'clock, okay? Okay, and you're gonna inform me it's coming? That is your signature on there?
I just.
Okay,
Just kind of approach.
sure.
I've got gout at my right foot.
What are you taking?
I just took it and I just sent this morning.
Senate parole, Oh, it's old road.
Okay. Thank you.
Colchicine is what I mean, Colchicine. Yeah.
Sorry. Thank you, Judge.
Yeah. James Riley. For sentencing. Boyle and Hart County, we just got two more people. You're on, it's Hart, we'll be right with you. They're both of you scheduled at 10 o'clock. Commonwealth versus James Riley, 24 CR 0094. You are James Riley,
Sir.
born in 1959. Last four digits, social security number 8554. You're in 24 CR 0094. You had an opportunity to look at the pre-sentence investigation for government probation parole. Is it substantially correct? Not sure there's any reason this gentleman should not be sentenced.
No, Your Honor.
Plead guilty to possession of controlled substance, first degree defendant shall receive a sentence of 3 years, probated for 5 years with the conditions. What is the court cost in this case?
$160.
$160. If you need some time to pay that,
Absolutely.
okay, you can pay it today, then the probation pro officer's there and you can meet with him, okay? Okay. It's right over there in the corner. Jamie Scott. Moreno. Commonwealth versus Jamie Scott, 25 CR 0018. Are you Jamie Scott? You born in 1985. That's 4 digits. Your social security number is 9033.
Sir.
Did you have public defender in district court? Got it. You on the appointment. You have a right to remain silent. If you have any questions, step away from the podium there. Okay, and ask your attorney. The grand jury of Cumberland County has attorney indictment shall be in possession of controlled substance in the first 2 days. Possession of drug paraphernalia. You understand those charges? You understand those charges?
Yes, sir.
We have a voice activated microphone. Then pick up nods, okay? You are to be here on May 16th at 9 a.m. for negotiations. And May the 22nd at 9 a.m. for your next court date. Do you understand that? Both of those conditions to your bond.
Yes.
Sign a reciprocal discovery order that requires the Commonwealth to give your attorney all the evidence they have to prepare your defense. Okay? Jeremy Spears says active warrant.
Yeah, well, that, this guy's in here.
Okay. You're Jeremy Spears here?
Yes.
Hey, where have you been, Jeremy?
At home.
Yeah. Take him into custody, let him be processed. Go with him. Jamie Stearns. Jamie Stearns. How about Kentucky versus Jamie Stearns, 23 CR 0098, 23 CR 00105, and 25 CR 0001. It says for sentencing. Are the other cases wrapped up with the sentencing?
We'll enter order in other revocations. If that's all right.
All I have to do is the sentencing and y'all take care of it.
We'll submit those.
Okay. You had an opportunity to look at the pre-sentence investigation report done by probation parole.
Yes,
Is it substantially correct?
yes.
Is there any reason someone should not be sentenced to that?
No, Your Honor.
Upon plea of guilty, possession of controlled substance, first degree, 2 counts of offense to receive sentence of 3 years on each charge to run concurrently for a total of 3 years. Sentences to run consecutively to the circuit court case 23 CRs 00105 and 23 CRs 0098. A 5-year sentence for a total of 8 years, probated for 5 years, probation supervised. You see in the drug court, you're in the drug court.
Yes, tomorrow's orientation.
What are the fines and court costs?
You wait once. Like you have medical conditions.
Yeah,
The other 2 cases that he has, he's still owe money on that, even if you wait over.
how much is you owe those others?
$550,000 on one, and then 100 is out on.
Are they restitution or court costs? Yeah, I'll waive it on this one. We'll let those others out. I haven't some time to pay it, maybe with probation pro officer, okay? As Boyle County, are you on the line? Boyle County, what?
Now, they said they might be just a little late, but he, you know,
Y'all kind of watch the screen to see when they come up. Hart County Detention, Hart County, are you on the line?
Yes, Your Honor, I'm here.
Thank you very much. This is Commonwealth of Kentucky versus John Metz, 22 CR 00109. Are you John Metz?
Yes, sir. Birthday, May 31st, 94, 8287.
Okay. What does the Commonwealth have to say on this probation revocation?
Your Honor, he has 3 years on a possession of a controlled substance, first degree. And basically the allegations are he and another individual were in a drunken stupor and went to a man's house and punched him in the face. He's got a new misdemeanor arrest based on that.
What does the defense have to say? A hearing?
I mean, I'd like to, if possible, wait to see what happens in district court with the assault charge.
Okay. And also, according to Mr. Garner, he's been absconded for 13 months.
We'll stipulate, Your Honor.
Stipulate to absconding. I'll take no action on the underlying misdemeanor since it hasn't been determined yet. If he's absconded, then I'll go ahead and stipulate with revoke probation and post sentence, okay?
Thank you, Your Honor.
Thank you, Mr. Metz. You're excused.
Thank you.
Yeah. Okay, we aren't supposed to be in Adair County till 10:30. Do you have Eric Crabtree or Jeremiah Fulton finished?
I can work on it right now.
We give all the paperwork, we get that button on.
Okay, well, let's go off the record here. If we can come to stand. Three of you back there, right?
Oh, three, you're correct.
Eric, Jeremiah, and Cody. Mr. Huntley?
Yeah.
You and Mr. Doctor, you have your
Can y'all see and hear me in Cumberland County?
Can you hear me now?
Yes, Judge, I can hear you now.
Okay, we have James Hurst there.
Yes, sir. Here he is, Judge.
This is 20 CR 0013 and 22 CR 0038. You are James Hurst, is that correct?
Yes, sir.
Okay, you were born in 1970, Mr. Hurst?
Yes, sir.
The last four digits of your social security are 2119. Get the public
Yes, sir.
advocate back out here. You're represented by Office of Public Advocacy. I have been brought out here. Hey, we're on the record. Y'all are keying the microphone. We have Mr. James Hurst. You can see me, you represent Mr. Hurst. Is that
Yes,
correct? Well, he's already identified himself. I've called the cases. We're here today on two probation revocations. What does the Commonwealth have to say?
Looks like this is our
Get
third
behind the
motion.
microphone.
Yeah, this looks like it's our third motion to revoke. Most recent violations, looks like the use of controlled substance,
Can you
methamphetamine.
speak up a little?
The use of controlled substance, methamphetamine, on April the 21st of 25. That's the basis.
Yeah, and Mr. Hurst, he just wanted to stipulate to that. He just would like to have the opportunity to address his substance abuse problems at a long-term care rehabilitation facility.
What's he being held in jail on? Okay.
I don't have any charges, sir.
Just these charges here, sir.
Pardon?
He's just being held on the Cumberland County charge. We're just waiting on
We got a hold
somebody
on.
coming
You don't
in.
have, you don't have any local charges on him, right?
No, sir.
Okay. So what's the Commonwealth will to do? What's probation parole have to say about this?
Your Honor, he was being supervised by Stacy Garlow, who is unavailable today. In her notes here, she has said that 4/21, he was on-site positive, admitted to use of methamphetamine. That was the basis for her request. She states graduated sanctions are inappropriate this time due to continued use of illicit and illegal substances. Officer requests a violation supervision report being addendum to the motion filed already to revoke.
That officer wants revocation.
Yes. Let's see.
Has he been in long-term treatment before?
No, sir. Is there any way I could have drug court, sir?
Yes, he's been an outpatient. And he's also attended IOP,
I haven't.
and both of them were closed. It's very complete those.
Your Honor, I never started IOP. I went to the hospital and I found out I had cancer in my neck. And then the lady at IOP told me not to start until I got done with my medical problem.
Y'all listen to him? Say that again.
I never,
Raise
I went to-
raise your right hand. You swear the testimony you're about to give is the truth, whole truth, and nothing but the truth.
yes, sir.
Tell us what your story is.
I went to the hospital and I found out I had cancer in my neck. And they was giving me treatments, right? Well, as I was doing these treatments, I was supposed to start the IOP. The IOP was never started because the lady told me a miss was worse than starting late. And that's why I hadn't started out.
You've been to long-term treatment.
I went. No, sir, I went to Revive for 38 days and then I was released. And, when I got out, that's when I went to the hospital and I had the cancer and I was supposed to start IOP.
Are you wanting to go to the penitentiary, Mr. Hurst?
No, sir.
Okay, well, here's the deal. This probation parole officer couldn't be here today, but they say that you repeatedly violated the terms of your probation by taking substances. I'm gonna give
Judge,
you one more chance. I'm gonna
just
find,
one more thing that we found in the report, he's also absconded in February from supervision. So that was also one of the reasons why it's not just the controlled substance use, it's also him
where's
not
he been
reporting.
since February?
He failed to report on February the 3rd, the 18th, the 25th. He's not reported to officers since January the 13th of 25. It's
I
just
didn't
that.
know about, what's the story about that, sir? Why did you take off?
Well, I had called Cumberland County and they said that they said on January the 30th, she got me for absconding, but I reported in January and I thought, well, heck, what? I'm trying to take care of my father and I'm trying to go back and forth to the hospital. I mean, that's all I can say.
Tested positive.
And when they picked you up, you tested positive.
No, sir, I admitted to using 4 days prior.
Yeah.
I don't want to go back to the penitentiary, sir. I'd like to, if y'all could give me like a drug report or IOP, I will get into it today. If you give me one more chance, sir.
I'm inclined to give this guy, I don't know why. I don't know why. You've done everything that you should do to deserve to get sent to the penitentiary. I'm gonna ask the public defender's office to find an appropriate treatment situation for you. And I would think that, a long-term treatment would be all right. Is your father still living?
Yes, sir. I'm trying to take care of him. He's 93 years old, sir. He lives right next door to me.
Well, let's see if you can find something close to this guy. I'm gonna tell you. If you don't report, there's no more excuses. There's no more the dog ate my homework. You understand what I'm saying?
Yes, sir.
You stay off that stuff. If you care for your father and want to be there for him, you stay off that stuff, or or he might die alone.
I don't want that, sir.
Well, I don't want it for you either. Nobody does. Okay, well, they'll be the public defender's office will arrange something and get the approval of Commonwealth Attorney's office. And I tell you what, you apologize to your probation and parole officer for causing problems. They've got enough problems without somebody giving them more headaches. You understand what I'm saying?
Yes, sir.
Okay, thank you very much. Boyle County, y'all are excused. Thank you very much for your cooperation. I know you're busy today.
Okay, thank you, Judge. Have a blessed day.
Yeah. Okay. We've still got a few minutes here before Adair County. Y'all have any of these in-house people, Crabtree, Fulton, or Stinson ready?
We've got an issue on Stenson, we can probably pick up.
Well, I made an agreement in this case based on.
Where is Mr. Stinson? Let's bring him.
I need to get him.
Mr. Cody Stinson.
Oh.
Caldwell versus Cody Stinson, 24 CR 0044 and 24 CR 0085. Are you Cody Stinson?
Yes, Ron.
Good morning. Were you born in 2004?
Yes,
The
Ron.
last four digits, social security number 8596. Okay, let's come on the website.
Your Honor, Mr. Rutherford and I made an agreement. I think he had an original agreement of 11 or 12 years. I can't remember. I have to go back and file. Mr. Stinson said he was going to take that and then he didn't. Well, I reduced the amount to 10 years and I don't know if he's executed the agreement or not.
We have.
Okay. But one of the victim's fathers here, he's objecting to that. All I had in my file was notes that said a prison time. And I thought that would be all right with the victims. According to him, Miss Rich had never communicated the number of years to him, and that may well be true, but she don't have her notes here with her. So I don't know that I can proceed with this.
What's the charge?
He's got one case with rape and sodomy, and he's got another case with sexual abuse and rape statutory.
All the same victim?
No, we got three different victims. We got the original case with the one victim, and that young lady's father's here. He's the one objecting to the number of years. And then we've got another case where the victims, I don't want to say too much in public, but I think they're fine with that because of some reasons about court testimony. So that's where we are. And so I don't know, without Ms. Rich being able to go back and look at her notes, whether we've properly
Let's
advised.
continue the case until May the 22nd. And that will give you opportunity to talk to the victim's family and
Okay.
let them, give them a full outline of what the situation.
And I've told him basically under Workman, once I've made an agreement, I have to stand by it, but he can always raise his objection with the court, so.
Well, the thing about it is under the Constitution now, I can.
Under Marcy's law,
You know, because they have, the victims have a larger right to be informed in the process, and it appears that through no fault of your own, that this is falling through, so I'm gonna reject that plea agreement that was done because the family was not included, the victims were included.
Thank you.
And we'll bring it back here on May the 22nd, okay? Thank you very much. Eric Crabtree.
Still working on it.
Eric Crabtree.
No, I'm still going. Excellent. Mr. Crabtree and Mr. Bolton.
Okay, let's go off the record. There's something here that needs to be turned off too.
You can mute it.
Okay, we're back on the record. Commonwealth of Kentucky versus Eric Crabtree. Commonwealth Church versus Eric Crabtree. Adair County will be with you shortly. Commonwealth of Kentucky versus Eric Crabtree, 25 for Crabtree.
Yes, sir.
Good morning. You born in 26, last four digits in social security number 5726.
Yes, sir.
What does the Commonwealth have to say?
Your Honor, I thought we were going to do a pretrial diversion plea, but probably a convicted felon out of Tennessee, and we can't do that. And then he's got new charges in Adair County. I think it's just best we pass him a month to make sure we get everything correct.
May the 22nd, and let's have a negotiation day on May the 16th. That way you could go and you can maybe find out what's going on up there. Okay. Thank you. Bring Jeremiah Fulton out. Commonwealth of Kentucky versus Jeremiah Fulton, 25 CR 0015. Are you Jeremiah Fulton?
Yes, sir.
Good morning. Were you born in 2006?
Yes, sir.
Last four digits of social security number 1424.
Yes, sir.
We're here today. You're represented by counsel. What does Commonwealth have to say?
We have a diversion plea.
Mr. Fulton, as you just heard, I've been informed that a motion has been tendered to allow you to enter plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
It's plea freely and voluntarily given.
Yes, sir.
Are you the same person we just identified, 25 CR 0015?
Yes, sir.
Is your judgment impaired today in any way?
No, sir.
Have you discussed this matter with your attorney? Are you satisfied with his advice?
Yes, sir.
Have you viewed the evidence Commonwealth has against you?
Yes, sir.
Believe you're fully informed?
Yes, sir.
You understand that you do not have to enter a guilty plea, that you have certain rights under the Kentucky United States Constitution. Before I can accept a plea, I need to know that you understand those rights.
Yes, sir.
You have the right to not testify against yourself. No one can make you say anything. Right to speedy trial by jury, right to be represented by counsel at your jury trial. Right to confront and cross-examine all witnesses called to testify against you. The right to produce evidence, have process issued to compel their attendance. Right to call witnesses in your favor. Right to appeal this matter to the higher court if you lose, and right to require a Commonwealth prove on the reason without you're guilty of charge. If you understand it, by entering guilty plea, that you give up those rights.
Yes, sir.
Now, I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided below. I don't have to accept the recommendation. In the event that I do not accept the Commonwealth's recommendation, decide to impose a harsher sentence, you have the right to withdraw your plea and proceed to trial. I'm gonna ask you some qualifying questions. Have you previously been diverted in the last 5 years?
No.
Any felonies in the last 10 years, or are you currently on probation?
I had failed. So, basically, I'm
You have
still,
felonies in the last 10 years?
I'm still going, I'll go to court. Still, Tennessee.
But there's a pending charge in Tennessee.
Yes, sir.
Have you ever been convicted of any felonies
No,
yet?
sir.
There you go. What's he got pending?
They said,
Uh,
we don't have.
in Tennessee?
Yeah, I didn't know what he had. Since they were in custody, I didn't run any NCI support of under the month. That's clear on the state, please.
It's a pending charge for theft by unlawful taking.
And we need to go back to the drawing board on this.
Yeah. we'll hear this after further investigation. We'll come back on May 22nd. Okay,
Thank you, Your Honor.
thank you. Okay. Dare County, if you'll turn us on up there. Commonwealth versus Sherry. Oh, hey, I never know how to say that. Cody, excuse me. Commonwealth versus Sherry Cody. 20 CR 0041 for sentencing. Ms. Cody, have you had an opportunity to look at the pre-sentence investigation report done by probation parole?
Yes,
Is it substantially correct?
yes, sir.
Is there any reason to say you should not be sentenced?
No, Your Honor.
Yes, sir.
She had 3 years pre-trial diverted for a period of 5 years. The verdict was voided on 3/7/2025. So we will sentence you to 3 years, okay?
Thank you, Your Honor.
Thank you, man. Mark Cruz. Mark Cruz. Commonwealth versus Mark Cruz. 24 CR 0014. Are you Mark Cruz?
Yes,
Okay, were you born in 1960?
yes,
Last 4 digits, social security number 3369. You're on
Yes.
probation revocation. What does the Commonwealth have to say?
Your Honor, Mr. Cruz has a 3-year sentence on possession of a controlled substance, first degree. I have Officer Ryan Taylor Bazoon to testify. And basically, the problem's been since December the 12th, he has refused to give a drug test. He admitted on the 12th of December, but any subsequent efforts, he's refused basically to produce a sample on at least 3 different occasions, I believe.
Officer, raise your right hand. Swear the testimony about to give us the truth, whole truth, and nothing but the truth.
Yes, Your Honor.
Mr. Taylor, you work for probation parole, is that correct?
I do.
And have you been supervising or attempting to supervise Mr. Cruz?
I do.
And I'd ask you to start around December the 11th and December the 12th and tell the court what problems you've had with Mr. Cruz as far as him failure to test.
Okay, on December the 12th, let me get to my notes here. On December the 12th, he had admitted to using methamphetamine after he had failed to submit to a drug screen with probation and parole. He had signed graduated sanctions on that date. And in lieu of us requesting revocation, we had requested that there be an increase in drug testing for the next 6 months and for that to be done monthly. So, and then he was to continue with the SAP IOP that he was previously recommended to in August of 2024. This was his first positive drug screen at that time, or his first admission to using controlled substances at that time. So he was going to be able to continue with the SAP IOP. After that time, we had attempted to drug test him on February 13th of 25. He had reported to the office after completing SAP IOP that day at around 3 o'clock or a little after. I wanted to get a drug screen from him. He advised that he had already submitted to a drug screen on the 12th of February and said that he wouldn't be able to go to the restroom because he had already gone about an hour before. Now, during the time that he had failed to submit to a drug screen in December, he had advised me that he had prostate issues, that was why he couldn't go to the restroom. However, he did not provide any medical documentation to me. In February the 13th, around 4 o'clock, we advised him after he had told me he wouldn't be able to go to do a drug screen. I told him to come back in on the 14th of February, which was that Friday, at 8 o'clock for the drug screen. So he was aware that he was going to have to come back in. He expressed understanding. He did not come back in on the 14th of February. He showed back up on on the 18th of February at 8 o'clock for a drug screen. On that day, he did not submit to a drug screen. He advised me that he wouldn't be able to complete the drug screen. And he was given 1 cup of water during that time. He never asked for any more. At around 10 o'clock, he said he didn't want to waste anyone's time. He wouldn't be able to go to the bathroom to complete a drug screen. I told him he could leave at 10, which was a 2-hour window, or he could continue to try until 11. And at around 10:30, he advised me again that he wouldn't be able to go and that he would not want to waste anyone's time. So at that time, he asked me when the court date would be, because I'd advised him that this officer would be requesting revocation in this matter. I told him I didn't know when the court date was. And at that point, that's when he left the office and without completing the drug screen.
Officer, did he ever provide any medical information to you from a doctor about his prostate problems?
I have not received any medical information from him as far as any prostate problems.
Okay, so the way I understand your testimony, then he wouldn't produce for a drug screen on February the 13th. Is that correct?
That's correct. That is correct.
And you told him to report then on February the 14th, and he didn't report.
That is correct.
And then he reported on the 18th. Was that just unannounced, or did he call in and get an appointment?
He came in on the 18th. I suspect that he wasn't going to come back in after not coming in on the 14th. And he advised that he had something going on the 14th. I believe he said he couldn't get a ride, and then said the next time he could come in was on the 18th.
Okay, and then he failed to produce on the 18th.
That is correct.
Okay, I have nothing further, Your Honor.
You'd like to inquire?
No, Your Honor.
No questions. This officer be excused.
Yes, Your Honor.
Do you have any other witnesses?
I do not.
Do you have any witnesses you'd like to go on?
No, Your Honor.
The defendant want to go on?
Mr. Cruz, would you like to testify?
So to say, I never was asked to produce any medical information on the prostate problem and the kidney stones.
Wait a second. That's all. You raise your right hand. You swear the testimony about to give us the truth, whole truth, and nothing but the truth.
Yes.
Okay. You want to ask him a question?
Yes, Your Honor. Mr. Cruz, will you tell us what happened in February
On which day, sir?
with the first drug
Yeah, but
screen?
just tell him his side of the story.
Yeah, just tell your side of the story, Mr. Cruz.
Where would you like for me to start?
In February with that initial drug screening.
In February. Okay, yeah, I admitted to not having using methamphetamines on that day, and I didn't figure there's use of taking a drug screen if I was admitting to it. And there's a reason I didn't submit one. And then of course, like he said, he recommended IOP. And the next 2.5 months, they dropped me once a week, and all those were clean. Like I said, I wasn't asked to produce any medical information on my prostate problem or the kidney stone problem. I mean, if he would have told me I needed to, I could have easily produced it. I'm taking medication for that right now. And then, like I said, my last 10 was clean, and I just wonder why. I was doing good. I thought I was doing good, and one time I couldn't. I couldn't drop on the last occasion. So I mean, that's pretty much the end of the story. I mean, I just keep drop on command.
How long have you been in jail?
This time,
Yeah,
2 months. 2 months.
I'm gonna give you a section.
Okay.
I'm gonna let you out of jail, man.
Thank you very
Not
much,
gonna-
sir.
Not gonna revoke you.
Okay, thank you.
These 2 months are sanctioned. I want you to go over there, the probation parole officer. I want you to
Okay.
cooperate with him.
Yes, sir.
I want you to give him a urine sample. And
Okay.
If you've been using, you admit up front. that sort of thing, and I don't want you to give me any more problems. We got a shortage of time with probation and parole officers. You don't seem like you're a bad hombre of any kind. You've had a drug problem.
Yeah. Let's try not to be anyway.
You go over there and cooperate, and I'll send you a release to get you out of jail today. Don't let me down, okay?
Okay,
Okay, thank you very much.
thank you. And I've got to hold her now. Grace County.
Buddy Dyer. Are you Buddy Dyer?
Yes, sir.
21 CR 00135. Good morning. We're here. Were you born in 1987?
Yes, sir.
Last four digits, social security number 6887.
Yes, sir.
And you're on a probation revocation. What does the Commonwealth have to say?
Your Honor, Mr. Dyer was in the Cumberland County Specialty Court Program. He's got a 10-year sentence. He's been in there quite some time. September of last year, he had been to rehab and then had a positive test, so he agreed to start over. And then in March of this year, he brought in fake urine to Alfred test, and he was terminated from the drug court program.
Again, we're willing to stipulate on it. I know Mr. Dyer had talked about going to the healing place and entering in their 9-month program. He says, he knows he has a problem. He just wants to do something to try to recover.
Well, this is a motion to revoke probation. It's not a diversion. We could look at it on shock, but I'm asking if he just terminated from drug court on a fake test that he be revoked.
We cannot allow people to bring fake urine into the drug court.
Yeah.
It would destroy the program and credibility of it. Just cannot happen. So I'm going to revoke Mr. Dyer and impose his sentence, and then we'll take a look at shock probation, Mr. Dyer, to see if there's some kind of treatment possibilities or whatever.
He's got a lot of time in. Once they classify him, he may not be that long to get paroled.
Yeah, that's correct. Might be better for you to see when you're going to be parole eligible, to tell you the truth. Okay, thank you very much.
All right, you're welcome.
Angel Kington.
Good. So, man.
Commonwealth versus Angel Kington. 25 CR 0019. Are you Angel Kington?
Yes, sir.
Were you born in 1996?
Yep.
The last four digits, social security number 5901. You're here for the
Yes.
purpose of arraignment. She has not been served with her warrant yet, but she can go ahead, enter an appearance here without service, I believe is a possibility, but if we'll get one served on her anyway, I think. You have a right to remain silent. Your attorney is here present. Say something so your microphone.
Hey, how are you?
I'm good.
Grand jury, you have a right to remain silent. The grand jury of Cumberland County has returned an indictment charging you with possession of controlled substance, methamphetamine, possession of drug paraphernalia, and public intoxication. Mr. Bailiff. Counselor, do you acknowledge the identity of your client, receive indictment, waive formal reading and arraignment, enter a plea of not guilty, reserving all pretrial motions?
Yes, Your Honor.
Okay, now, Ms. Kington, you should be present at 9 a.m. on May 16th for negotiation, and May 22nd at 9 a.m. for your next court date. Both of those are conditions of the bond. Is she being held on something else?
I don't believe so. I think this is it.
What is her bond?
I don't know how she could be meeting this, she'd have to have something else if she's not concerned with.
Yeah.
I don't see how she's there. She isn't.
She probably still let her district hold.
Oh,
Yeah.
How long have you been in jail, Miss Kington?
Since January 9th.
Jeez.
Should have a that's another commission on the district holder. When she had failed to appear for arraignment, had $1,000 cash gone, and they served that warrant on her. January 13th, and she's never made $1,000. Back when she was invited to show. That's a something not one yet.
Let them know she's got a Clay County holder on her. I was fixing that.
Yeah, what?
She has a Clay County holder in Tennessee on her.
That's okay. That's the deal, man. Okay. Y'all have the warrant to serve on the Kentucky warrant, Cumberland County warrant to serve on her there. Y'all have a copy of it. We need to send you another copy of it.
You may have to send us another copy.
We'll send another copy up there and y'all serve that on her and then we'll go ahead. She's already arraigned herself. I'm not sure it's necessary to have it served on her after she's made an appearance and in an appearance here, but we'll do it. I'm sending a reciprocal discovery order, Ms. Kingdom. What
Thank you.
is, just out of, you know what the holder from Clay County, Tennessee is for?
Apparently it's fraud or like breaking into abandoned buildings and something like that, but I didn't do nothing like that.
Okay. Okay, well, thank you very much.
quick.
Your attorney will be up there. Y'all will go up and see your attorney will be up to see you. Okay. Nathan Martin, thank you. Commonwealth versus Nathan Martin, 24 CR 007. Are you Nathan Martin?
Yes, sir.
Born in 2001.
Yes, sir.
Last four digits, social security number 8057.
Yes, sir.
You're here today for probation application. What's the Commonwealth have to say?
Your Honor, Mr. Martin has 12 months on a misdemeanor assault fourth. He has supposed to have no contact with victim, attend anger management classes. Since January of this year, he's just been on kind of a traffic spree. January 22nd, 2025, he had a speeding, careless driving, no operator's license. He was doing 62 and a 35. Then on February the 4th, he had another no operators, failure to maintain insurance, improper display of registration plates. And I think there was another one. And then according to the probation officer, he's not doing his MRT training like he's supposed to. So that's the violations. I got the officer on to testify if I need to.
You know what stipulate?
We'll stipulate to that.
Stipulating to the violations. What kind of time did he have?
It's 12 months on misdemeanor. I don't know how much time credit he would have.
I think he has quite a bit of time in right now.
Officer Burton, is that what you're on here about his case?
Yes.
Yes, Your Honor.
How much time does he have in, you know?
Looks like we arrested him on your bench warrant back in, give me just a second to read my notes here.
April the 1st.
Arrested on the 1st.
First of what?
April.
He's been here for 23 days.
Do you have any time in before that?
How many days before that?
I don't
I
have
do.
that information.
I do. I have about 5 months.
Wait a second, sir. Where can you find that information?
I can verify that on Justice Exchange, Your Honor.
Yeah, give us just a second to look.
I think about 5 months in. Yeah. I don't care if he has a 729 way back.
That's fine.
How much time do you think he has in?
But Mr. Rutherford thinks 5 months. If he does his 729 like we normally do, I'd be ready to lay him out. It's very just a year on felony. You're not supposed to what we did.
You 5 months on it?
We've already got 5 in.
How much you want?
What is it, 729 that we usually do on misdemeanor?
I don't understand what you
That
want.
was 143 days previously. 144 days? 143. 143, I'm sorry, previous.
So he's almost got 5 months. He wants
So
to
you
do two more months.
Okay. Well, the Commonwealth has recommended we allow you just to serve the time that you would have if you've been on a Class D felony.
Yeah, then like 210 days, if that's all right.
210 days, and you got 144 days in, so I'll sign a release from that. And that will be that will show him served out, is that right? You'll be off probation. You won't be on probation or anything if you do that, okay? So we'll send a note.
Plus the 23. Your Honor,
Yes.
I've been told he has served 144 days previously, plus another 23 that he's currently with us.
Okay, that's 166,
66,
and you're gonna have him serve how many?
210, so he's almost
Two
back.
hundred and ten, so we'll send a release of him up there once you, looks like to me that that's about a
44 days.
44.
Yeah.
44 more days, and you'll be out, you'll be finished with this, okay? Okay, thank you very much.
Thank you.
Cameron McCoy. Cameron McCoy.
Whenever you give me your number.
Commonwealth versus Tamara McCoy. 24 CR 0051. You are Tamara McCoy. Born in 1990. Last four digits social security number 0591. Is that correct?
Yes.
Okay, we're on probation revocation. What do you have? What's the Commonwealth have?
Your Honor, Ms. McCoy had a 5-year sentence on criminal abuse, first degree. As part of her plea agreement, she was to go in and enter and complete the Cumberland County Specialty Court Program. And she had the following violations: not reporting to drug court office in a timely manner, continued use, controlled substances, not keeping caseworker informed of her decisions, and not being honest with caseworker. I've got Mr. Murphy here to testify if necessary.
You want to stipulate?
We'll stipulate to it. This is again, just, I would like to get her into a long-term rehab facility.
I'll look at it shop, but since it's drug court, and that's part of the plea agreement, she wasn't in there 3 months, was she, Mr. Murphy?
Okay, I'm gonna revoke the probation. And then if you have any issues like that, you can bring it up on a shock probation motion, okay? And have some detail that you give to the Commonwealth before we come here that day. I don't want to come here on that date when you file a shock probation and speculate on what you might do, okay? Thank you very much. Gene Parrish. Commonwealth versus Gene Parrish. 25 CR 0001. Mr. Parrish, you have an attorney?
No.
Yeah, I'm gonna appoint public advocacy. You're incarcerated. Can you afford an attorney?
No.
Okay, well, we'll get an affidavit signed on it a little later. Somebody take one. You're here for the purpose of arraignment. You have a right to remain silent. Your attorney is standing here. Say something to voice activate their case.
Hello, Mr. Parrish.
Hey, how you doing?
Okay, that didn't really do it. I don't know why it didn't. Say something again.
Hello, Mr. Parrish.
There you go. You have a right to remain silent. The grand jury of Cumberland County has returned an indictment charging you in possession of controlled substance in first degree, third or greater offense. You understand what that charge is, don't you? I don't want to say what you did, right? You understand what the charge is?
Yes, sir.
Okay, Mr. Bailiff. Count three, you acknowledge the identity of your client received indictment, wait formal reading and arraignment, and plead not guilty, reserving all pretrial motions.
Yes, Your Honor.
I'm signing a reciprocal discovery order so that part of the Commonwealth to give you your attorney the information to help prepare for your defense. You are to be present on May the 16th at 9 a.m. for a negotiation, and May 22nd is your next court date. Now, what's Mr. Parrish's bond?
He has charged with possession of controlled substance, first degree. He was the co-defendant with Miss Brandy Franklin this morning. And basically they found a pipe with meth residue in the console, and then the marijuana joint butt was at her feet. That's the reason I pled to her plea for misdemeanor.
What's his bond? What, we got 25,000?
Probably based on his criminal history, say he's probably what they're doing.
The 8 was FDA's or what?
I will say this: if the court lowers his bond and lets him out, he needs to keep a low profile, because I hardly ever get community complaints on anybody from Cumberland County, but I get community complaints on Mr. Parrish.
Here's the record does not indicate that he's a good risk not to reoffend or that sort of thing. So we'll make sure your attorney will be up to see you soon. You'll be here on the for a negotiation day on the 16th and then on May 22nd. And this charge might not be one of the more serious
It's
charges Mr. Parrish has been, so maybe you can resolve it that day, Mr. Parrish. You understand what I'm saying when you come back to these days. Thank you very much. Dorothy Poland. Are you Dorothy Poland?
Yes, sir.
Good morning. This is Commonwealth Kentucky versus Dorothy Poland, 23 CR 0088. Ms. Poland, are you born in 1985?
Yes, sir.
Last four digits associate your social security number 6826.
Yes, sir.
Okay, what's the Commonwealth had to say?
We made an offer of a diversion in this case. I don't know if she's going to accept it.
Yeah, she brought to light some new information to me. We could have just one more negotiation day.
Okay,
Sir.
negotiation day on May 16th, the next court date, May 22nd. Both of them are conditions of the bond. Okay, your attorney will be up to see. When are you gonna come up to see her?
This weekend.
Weekend?
Weekend, yes, sir.
He'll be up in a couple of days to see you then, explain stuff. Okay, thank you very much. Johnny Riley, Raymond. Commonwealth versus Johnny Riley, 25 CR 0023. Commonwealth Kentucky versus Johnny Riley. Mr. Riley, do you have an attorney?
No, sir.
Can you afford an attorney?
No, sir.
Yeah, I will take you at your word because you're a frequent flyer here. Point of public advocacy. You've been indicted. I'm gonna read the indictment. The grand jury of Cumberland County, the attorney indictment charged you possession of controlled substance, purchase of methamphetamine, possession of drug paraphernalia. You understand what those charges are?
Yes, sir.
Okay, Mr. Mr. Public Defender, do you acknowledge the identity of Mr. Riley, received indictment, wait formal reading, or an interplea not guilty, reserved all pre-trial motions?
Yes, Your Honor.
Okay, I'm gonna sign a reciprocal discovery order here. Requiring the Commonwealth to provide you with the information they have to help prepare you for your defense. You'll be back here at 9 AM on the 16th for negotiation and 9 AM on the 22nd for your next court appearance. What's his bond? Yeah, you got a $15,000 surety bond. That's pretty low. Slow as I can say it. So all somebody's got to do is come down to the clerk's office, prove they've got 15,000, they can sign you out, okay?
Any way I can get an OR out? I got nobody to sign me out, to be honest with you.
I can't do it when we make sure the charge is right now, okay? We'll review it on the next time you're up here. Okay, thank you very much. Sorry. Jennifer Robinson.
Your Honor, she is currently in Warren County.
Okay.
I called them this morning. I don't get it.
Yeah, she's in Warren County and they refuse to cooperate. Not unusual, so we'll schedule her again. Is she gonna be coming back to your place or is she down
She's
there?
supposed to be coming back to us, but when that is, I do not know.
Okay, we'll schedule her again for for the next real day we have, which is May 22nd. Is she a state prisoner down there?
She is.
So she's not costing us any money, so we'll schedule her for May 22nd, when we can get her back, okay? Thank you. Maggie Scott. Harwell versus Maggie Scott, 24 CR 0056, 24 CR 0088. Are you Maggie Scott?
Yes, sir.
You're here, were you born in 1984?
Yes, sir.
Last four digits, social security number 3307. Pre-trial diversion revocations will proceed.
Yes, Your Honor. She has 5 years to serve, 5 years on 2 possession of controlled substance first. One was in Clinton County, one was in Cumberland County. And she's been terminated from the specialty court for driving on a suspended license and continued to use controlled substances and missing therapy opponents. Mr. Prowse represents.
Y'all gonna stipulate
Your Honor, I spoke with Ms. Scott yesterday, and I think we will stipulate, I would request an opportunity for her to go into a long-term rehab. I think she would really benefit from that, and she's earnest in her.
Revoke the pretrial diversion, order pre-sentence investigation report, and sentence you on May the 22nd, and making arguments you have at there, and maybe have some preparation.
Thank
Okay?
you, Your Honor.
Very much. Johnny C. Commonwealth versus Johnny C. 24 CR 0067. Good morning, Mr. C.
How you doing, sir?
Good. You born in 1959?
Yes, sir.
4-digit social security number 8001. What's the Commonwealth have on
Yes,
this?
sir.
Your Honor, on January 24th, Mr. C admitted was positive for using meth of this year. He was met with the SSC. He was to enroll and complete IOP. On March the 6th, 2025, he was on site positive for methamphetamine again. He admitted that he used on March the 1st. On March the 11th, the SSC recommended that he enter and complete a 6-month rehab. He was directed to the healing place. He went to a healing place and stayed 4 days and then left. He was reported then back to the Columbia Probation Office. He was again on site positive for meth on March the 23rd. They wanted to send him back to rehab for long-term treatment. He would not agree to go.
We'll stipulate. I think his time being incarcerated has helped clear his mind a little bit, and he wants to go to long-term treatment now.
Okay, I revoke the probation. Well, I don't know whether he's eligible for shock probation.
He would.
You look into and continue to talk to Mr. C. We'll take a look at shock probation. Thank you, Mr. C. Wesley Smith, your attorney will be up to talk to you. Wesley Smith. For sentencing. Commonwealth Kentucky versus Wesley Smith, 25 CR 007 and 24 CR 0072. You're represented by Mr. Strack here today. Here for sentencing. You had an opportunity to look at the pre-sentence investigation report done by probation parole.
Yes.
Substantially correct.
It is just, there is one correction that we would make, the very last block above the signatures. Mr. Smith does have a high school diploma.
If you'll note that and make a correction. Okay. Is there any reason we shouldn't be sentenced today?
No, Your Honor.
Both pleaded guilty to trafficking controlled substance first degree. Case number 24 CR 0072. The defendant shall receive a sentence of 7.5 years. And I'm going to wait, it's because of the length of the sentence, I'm going to waive the court call.
Thank you, Judge.
Okay. Thank you very much. Dennis Spears. Dennis Spears. Are you Dennis Spears?
Yes, sir.
Good morning.
Good morning.
You're here today for sentencing in 24 CR 0088. Were you born in 2002, Mr. Spears?
Yes, sir.
Last 4 digits, social security number 5424.
Yes, sir.
If you had the opportunity to look at the pre-sentence investigation report done by probation and parole.
Yes, sir.
Substantially correct.
Yes, sir.
Any reason why this gentleman should not be sentenced today?
No, Your Honor.
Upon plea of guilty assault second, you should receive a sentence of 10 years. Serve 9 months, balance probated for 5 years. How much time do you have in now?
I believe he's scheduled to be released in July, early July.
Court costs, what are the court costs?
$190.
$190 court costs. You can pay that at $30 a month, 30 days after you get out, okay?
Yes, sir.
Okay. The probation and parole will be up to see about when you to report to them when you get out, okay?
All right. Yes, sir.
Thank you very much.
You too. Have a good one.
Yeah. Seth Staley. Seth Staley. Yourself, Staley,
Yes, sir.
24 CR 0083. Were you born in 1977?
Yes, sir.
Last four digits, social security number 7119.
Yes, sir.
This is motion for sharp probation.
Yes, Your Honor. The initial conviction really revolved around mental health issues with him. He was put on medication. He was taking it regularly while he was incarcerated, doing a lot better. But unfortunately, due to his incarceration, he's unable to continue the medication. He's losing his insurance for it. So we would like to shock him out, allow him to continue the medication, and then he would enroll in some type of dual treatment program for both substance abuse and any kind of mental health issues.
What was the underlying charge?
Your Honor, 21 CR 50, he had a trafficking charge, was 3 years. He was on diversion. Then he had guns while he was on diversion. He got indicted for that. He got 2 years on possession of a firearm, convicted felon. So he's got 5 years over his head. But now he's up for parole June of this year. And I would ask that the court just hold this in abeyance and see if he makes parole. If he doesn't make parole, I'd probably be amenable to shot.
Schedule this for June 26th. Mr. Staley, they believe that it would be better off for you to be on parole than probation. It's less strict. So
Okay.
if they don't parole you, we're going to take your shock probation back up on the 26th of June. Okay.
All right. Thank you.
Thank you. Joseph Willett. Joseph Willett.
Yes, sir.
Cromwell versus Joseph Willett, 22 CR 004. Are you Joseph Willett?
I am.
Good morning. You're here today for sentencing. Were you born in 1984?
Yes, sir.
Last four digits, your social security number is 1455.
That's correct.
Have you had an opportunity to look at the pre-sentence investigation report?
Yes.
About probation and parole?
Mhm.
Is it substantially correct?
Yes, sir.
Let me get a copy of it here. Let's bring it out.
What's the status of his case in Washington?
What's that?
The status of his case in Washington.
Here you go. Is there any reason why this gentleman should not be sentenced?
No, Your Honor.
He was granted pretrial diversion on June the 23rd, and it was voided on March 27th. Sentenced to 3 years. 3 years to serve. What was the underlying?
You know, this is a case where Mr. Willett was on diversion and then he had the DUI and was unruly and the officer had to kind of fight him to get him under control. We had the hearing on it.
Yeah, I remember.
And then I don't know if his charges in Washington County are still pending. Once he gets those resolved, if he has a plan on shock, I'll look at it, but that's kind of where I'm at.
I don't think it. Maybe not.
Maybe or maybe not.
Okay, we'll send make the state prison. Is there anybody else up there in Adair County that is waiting to talk to us that might have slipped through the docket? Thank you, Mr. Willett. You can go. Is there anyone else up there that you have in Adair County that might have overlooked?
Not that I'm aware of, Your Honor.
Well, thank you. Y'all may be released.
Thank you.
And that concludes the criminal docket except for suppression. Okay. Okay, let's get ready for that. Y'all ready for the suppression motion? How are you? Don't let me fight it. Commonwealth of Kentucky versus Brandon and Holston, 24 CR 0050. It's a motion to suppress. You want to put your proof on, Mr. Hunley?
Will, Your Honor. Call Sergeant Kenny Brown of the Kentucky State Police. Also have, Your Honor, if it's necessary, Officer Bobby Carey and a couple of state police troopers.
Okay, well, we'll impose a rule. You can designate one person to stay with you. Who you designate?
Designate Sergeant Brown to stay with us.
Okay, those other officers will. Sergeant Brandon, you raise your right hand. You swear the testimony about to give us the truth, whole truth, nothing but the truth.
Yes, sir.
Okay. Wait.
State your name for the record, please.
Kenny Brown.
And what is your occupation?
Yes, I'm a Kentucky State Trooper. I'm a sergeant at a Post 15 club.
What is the duties of a sergeant in the Kentucky State Police?
We have a lot of duties, day to day, scheduling, making sure that units are doing what they're supposed to be doing. Use of force, accidents, responding to calls with them.
In addition to your administrative duties, do you also serve as an officer in the field when it's necessary?
Yes, sir. I do.
I want to call your attention to December 26th of last year. You recall the date, the time that you and Officer Bobby Carey went to the home of the defendant Brandon Polson.
Yes, sir.
What was the purpose of you going to Mr. Polson's apartment?
Looking for Mr. Dewey McCoy on a felony arrest warrant.
Did you have a felony arrest warrant on Dewey McCoy in your possession?
Yes, we did.
Tell the court what you did when you got to Mr. Polson's apartment.
I didn't know exactly what the apartment number was. Officer Bobby Carey did, went up to the door and
Mr. Carey accompanied you?
Yes, sir, and knocked on the door.
And did somebody respond to the door?
Yes, he said something. I can't remember what he said. It's some kind of a curse word or something. He obviously thought I was somebody else.
He opened the door?
He opened
Who opened the door?
Mr. Brandon Polson.
What was his reaction when he saw that it was a Kentucky State Police officer?
He was obviously shocked. He thought it was, I think he even said he thought it was a neighbor or something else that was coming over.
Now, when Mr. Polson opened the door to his apartment, what could you see?
Saw to the left, Dewey McCoy sitting on the couch. Mr. Brandon Polson standing there, and then some guy that ran through, obviously trying to hide back in like the kitchen area.
Was Mr. McCoy present?
He was.
Where was he in relation to the other individual?
4 feet in the door to the left, sitting on a couch.
Did you recognize him to be the one that you were looking for?
Yes, sir.
In addition to finding Mr. McCoy, what action did you and the officers take? And why did you take any further action?
Well, immediately, wanted to find out who it was that ran into the room back here. It turned out to be a Mr. Riley. Finding out what he was doing, you could see drug paraphernalia and stuff around the house. It was an apartment, very small, tiny apartment. There was stuff scattered around everywhere, but you could see drug paraphernalia everywhere in plain view.
So photograph here, Your Honor, we should get it pulled up.
that, there was a trooper standing at the front door.
Did Mr. McCoy stand up or come forward at any point, or was he arrested on the couch, sitting down?
I told him to stand up.
And you said you saw a bag of meth in plain view on the couch where Dewey McCoy had been sitting?
Yes,
Could you see that bag of meth before you stood up?
I can't remember. I don't know.
That photograph that we saw earlier, do you know if it was taken from somewhere inside the apartment?
The one they just had there?
Yes.
Yeah, that was his, it looked like it, what looked to be his apartment. I'm assuming that's probably a still from a body cam.
Okay, but my question is, do you know if the photographer or the person wearing the body cam at that point was in the apartment or was outside of the apartment?
I don't know.
When Mr. Polston gave consent to search, were you there at the time?
No, sir, I wasn't.
No further questions for this witness.
I have no further questions. Yeah.
Sergeant, you can take a seat at the count. Yes, sir. We'll call you next witness.
I don't know that I need a next witness, Your Honor.
Okay. We'll call any witnesses, the officers can come back in. Do you have any witnesses?
No, Judge.
Mr. Hunley, you are the proponent, opposition, suppression. What do you have to say?
Your Honor, this is really a very simple matter. The Commonwealth agrees with the defendant's definition of a plain view search. And that is that the officers were lawfully in a place where objects of drug activity could plainly be seen. No question, they were lawfully at Mr. Polston's apartment because they understood that Mr. McCoy may be there. When the door was open, the first thing he saw after an unidentified male ran through and went to the back, he saw Mr. McCoy 4 feet from him. He has in his possession a felony arrest warrant for Mr. McCoy. He can then, there's no rule in the world that he has to wait for Mr. McCoy to come outside that apartment before he can take custody of him. That warrant gives him the absolute right to be there, the absolute right to arrest Mr. McCoy. In the course of being where he could be, he observes all the paraphernalia that he's described of illegal drug use and a big bag of methamphetamine. Now, even if Mr. McCoy hadn't been there, the fact that Mr. Riley, they didn't know it was Mr. Riley at the moment. But when Mr. Riley ran through and went into the back, they had a right, maybe a duty right then, to make sure, one, that he wasn't going to secure a firearm, or that he wasn't going back there to destroy additional evidence. So in either way you look at it, these officers had a right to be there. They saw what they saw. The warrant gave them the express right to take Mr. McCoy wherever they found him.
We'll come up and make your argument. Yes.
Your Honor, the facts as they were known to the defense at the time definitely supported the idea that there may have been issues with the plain view, with the perspective of the officers. Given the testimony of Sergeant Brown, it's harder to make that argument now. I do still believe there is an outstanding question of the retroactive consent to the search that Brandon Polston gave.
I don't understand the retroactive. He signed a consent statement later.
He did.
I don't think they need to consent. So.
Well, I don't know.
I think it's an extra layer of protection to protect their search. Let's go ahead and make your argument.
My concern would be if they are allowed to to see various evidence in plain view and sees that evidence and obviously arrest Mr. Dewey McCoy. If at some point, if the consent is no longer valid and there are aspects of that search that rely on that
What consent are you talking?
the consent that Mr. Bolston gave, the form that he signed.
Well, of course, their argument is they didn't need the consent. They knock on the door, looking for a fugitive. They see the fugitive. Someone else is in the room and makes himself absent, and not quite, and the officer said that where he was standing, he could see drug paraphernalia and drugs laying in there. He had the right to go in and effectuate that arrest. If he couldn't see it from where he was standing in the door, when he went over to grab Mr. McCoy, he could have seen it then, and he would still have been in his right to do that. And anytime you go into a place like this where you see that sort of activity, surely you can't say that an officer doesn't have a right to even enter another room to see who fled and what they had, like Mr. Huntley said. You can't wait till they come out blazing. So and as far as any consent that was later searched, I think that's just another layer of security that officers get. He consented. Now, if the retroactive aspect of the search, if they searched and then asked him consent after the search, I would understand the thing, but I think they have plenty of grounds to have to view what was in plain sight. Plenty of reasons to go inside the apartment. The door was voluntarily open, so I'll make a written finding to security.
Thank you, Judge.
Okay, is there any other case on the docket for today? What happens to show cause? No show cause today, so we are in recess until 1 o'clock. Okay, bring him back. Bring
Your Honor, we need to set this for. You set this in for the pre-trial. Maybe 6 months for negotiation.
Yes, we'll go ahead and
Next court.
set this for.
I wanted to mention that I've got circuit court in Marion County all day on the 22nd. If I understand that this court's next day.
16 on the 22nd.
Yeah, that may be the best way. That sounds good.
16 to 22nd, you might have to pair those in. I understand that.
All right.
Okay,
Thank
thank you
you.
very much.
Did you not
Let's go off the record.
you take your bond?
I thought, I gotta make sense of this.
Circuit Court, on Judge David Williams presiding.
Thank you. Everybody have a seat here. Child support docket. Severe versus severe.
Judge asking that that matter be reviewed, the 31st of July.
Okay. Shelton versus Shelton.
Asking that that matter be reviewed the 31st day of July.
Okay. Long versus Long.
31st of July for review, please.
Norris versus Norris.
31st of July, please.
Cooper versus Cooper.
Asking for a review date of the 31st of July.
Commonwealth versus Nicholas
Raisin, Judge, he is paying well, asking that the court review this matter on the 31st day of July.
Hey, second.
Everything, Judge, I'll tell the court all of those orders were prepared by the newest member of my staff, Ms. Watson.
We'll closely scrutinize these.
But the ones that are e-filed, I messed up. She corrected them. And those are all correct. We tender just
closely scrutinize them.
thank you.
Okay, the Pulaski Circuit Court, in special session by agreement here in Cumberland County will come to order. Parties here. Who's representing the other side?
Jim Ridings.
Is he here?
I have not seen him as yet. I can wait for a bit, Your if you want to go to.
Well, we need to go ahead and see about it. Is Mr. Ridings in one of those side rooms back there? Is there an attorney in a side room?
I'm sick of it.
You guys sign on to 115, let's see. So, okay.
Not very often.
Look at that, send that tape.
Are any of the parties here on the regular Cumberland Circuit Court civil docket? Yeah, they didn't come up. It's still 10 minutes before it's recorded. Kurowski versus Kurowski or
Well, it's our guys. I stumbled on the name like this.
I
I never know how to say it.
how do you say it?
You did a good job.
Yeah.
Judge, we're going to try to sit down for a few minutes and see if we can explore settlement on this. I'm sure you would encourage us to do that anyway, so we're going to, if Nick's not busy, we're going to retire and try to help your doctor out, okay?
Okay. Barn Grover versus Marion. Parties here.
One thing we got here is that.
Can you identify yourself, please?
Danielle Marion. Karen Nicholson.
You have an attorney?
No, sir.
Wanda White still in this case?
No, sir. No, sir.
James Farringer, is he still in this case?
No, sir. Nurse.
Okay.
I would like to return custody back to their mother.
Do what?
I said I'd like for you to return custody back to their mother.
Wait a second.
She's out there. He's in another state.
Okay, you're the grandmother.
Yes,
All
sir.
right. And you received custody for a while because of allegations against the biological father.
Yes, they were substantiated.
Well, substantiate,
Yes.
which is a word that I've learned has broad parameters as for this, what substantiation means. So now you were in jail, were you?
Yes, sir.
What were you in jail for?
For the crime that I committed back in 2012.
What was that?
Assault in the second, robbery in the first, and burglary in the first.
And why is it that you want to transfer your custody back up to her?
Because originally, when she had given me custody of the kids, I told her that if she got out and kept her life in order, that I could return them back to her.
Well, I'm not really comfortable doing that without taking testimony or knowing something. I'm just not comfortable with that. It might very well be the thing to do. But I would like for y'all, how old are the children? One child?
There's two.
Two, I thought two.
11 and 9.
Okay, I'm gonna appoint a guardian ad litem for, who is a guardian ad litem? Mr. Carter.
And Coleman Hurt.
And Coleman Hurt. Previously been. Do
Yes.
you remember anything about this case, Mr. Carter?
Sorry, Your Honor, not sure.
It's been a while. I'm gonna reappoint you as a guardian ad litem for both of these children. Okay, and let him interview the children, investigate, give a report. Okay, not saying that it shouldn't be done, I'm just saying that out of abundance of caution, I want to get somebody involved since neither one of you are represented and the children are. You step out of the courtroom there and let Mr. Carter get the information from you, okay?
All right, sir.
Herschel versus Hirsch, Herschel. What do you got here?
Judge, this is my motion asking for the biological mother's mother to be allowed to intervene in this custody action. I think this is a case that was originally transferred from Warren County. And the biological mother has some disabilities, and she's been in the home of Miss Karen Anderson and James Whitlow. And she has also signed affidavits asking that they be allowed to intervene. And then also we would like to set a hearing for sole custody as well. And I noticed the father back on March the 18th. I've not had anything returned, and I don't think you all have had any contact or anything from him.
His name's Michael Jeremy Hersey, is that how you say the name?
Herschel.
Herschel. This is the grandmother here that's wanting to intervene.
Judge.
Well, I don't know whether I've ever seen that happen or not. Have you ever done it before?
I have in a couple of instances. I've had instances where both parents were in agreement with it, and then I've had it where we've had a hearing that was contested and the court ruled as well.
Me?
No, not in this court.
You could have convinced me that I had maybe 10 years ago. Do you have any authority for it?
Well, I think she could actually qualify as a de facto custodian at this point
That's
because
what
she's,
usually is how, of course, you got an abandonment by the father.
that's correct.
And is there anything in the de facto custodian law that says if you've got a disability, if you're providing, they all live in the same home, do they?
They're living in the same home.
What about that? Is there anything in de facto that would allow her to be de
If
facto?
she was financially supporting the mother and they were co-parenting along and the mother objected to it, no. But if the mother is agreeing to the fact that she is the de facto custodian, has been the primary caregiver and supporter because she's unable to at this time, then there is case law that says that can happen.
And is this Michael Jeremy, is he incarcerated? When's the last time your clients heard from you?
Year ago Christmas, yeah. He's not been very consistent. I think in their affidavits, Judge, we've got sworn testimony or
Yeah.
sworn statements showing that he's been very sporadic in his involvement with the child.
I don't think I didn't remember seeing when the last time they saw him. Maybe it's in there. Did you find this for me? I didn't find it. And the grandmother wants sole custody?
That's what she's asking for. I understand we may have to have a hearing to put some proof on for that, Judge. I wasn't asking for that today, but I did want to ask for her to be allowed to intervene instead of them having to file a whole new action for de facto. And then the court.
I'll let her intervene for de facto. And then you need to beef it up and show me some law on that. I'll go ahead and let her in. And then I also want to take a look at what kind of efforts there have been to serve this biological father again.
Judge, I followed the rules and mailed it to the last known address that we had, so I don't know what other steps you want us to take.
How about a warning order attorney?
I can ask for a warning order attorney to be appointed.
You know, if you get a warning order attorney, even that doesn't really do more sometimes than just mailing the last known address because some time. You think a guardian ad litem ought to be appointed for the children?
I don't know that that's necessary to add that expense when it's not in dispute, especially you've got one parent that's not disputing and she could testify because there were some time periods that she wasn't in the home with the mother or with her mother.
Okay, well, let's file it. Get some pleadings ready for next month and we'll see what we do, okay? Okay, thank you very much.
Thank you. And I do have an order, so I'll get that.
That'd be great. Yeah. No. I just thought them, see. Meredith versus Meredith.
This was our motion for a default and to get a hearing date since there is a minor child involved. I represent Mr. Meredith.
She was served on a fair.
I have a copy if it didn't.
I'm just asking the clerk to check so it's in file.
February, and she was served on sheriff, better.
Where's the child located now?
With Mr. Meredith.
And what's the status of the biological mother? Is she just deserted?
That is my understanding, Your Honor. There's been.
She made, how old is the child?
15.
Made it, she didn't make any contact with the child, no attempts to make any contact with the child. How long has she been gone?
So, since October the 3rd.
You want to take proof, require proof now as far as a divorce or?
Yes, Your Honor, that would be, that's fine with me if it is satisfactory for you. Go ahead and state your name, Mr. Meredith.
Raise your right hand. You let me swear in first. You swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth.
Yes, sir.
Lower your hand there.
Go ahead and state your name, Mr. Meredith.
Verlin Lee Meredith.
And how do you know what is your spouse's name? Sorry.
Erica Beth Meredith.
And what county do you reside in?
I reside in Cumberland County.
And where does Miss Meredith reside?
From what I've heard, it's Taylor County.
And how long have you resided in Cumberland County?
Been here for 2 years currently.
And had you resided in Kentucky for 6 months before you filed for this divorce?
Yes.
And had Miss Meredith resided in Kentucky for 6 months before you filed for this?
Yes.
When were you two married?
2015, January the 1st, 2015.
And when did you separate?
October the 3rd of 2024.
Did she move here with you?
Yes.
Go ahead.
And where were you married? Sorry.
We were married in Gatlinburg, Tennessee.
And have you lived separate and apart since you separated?
Yes.
And have you made any efforts at reconciliation?
No.
Do you think it would be helpful to try and reconcile now?
No, ma'am.
Do you understand what is meant by the phrase irretrievably broken or broken beyond repair?
Broken beyond repair, yes.
Do you consider your marriage irretrievably broken?
I do.
Do you and Miss Meredith share any children?
Yes.
What is their name and age?
Mackenzie Joe Meredith, she is 15.
And where does Mackenzie reside?
She lives in my home with me.
To the best of your knowledge, is Miss Meredith currently pregnant?
No, as far as I know, no.
Do you and Miss Meredith have any property together?
No,
Did she take her personal property when she left the home?
she did.
Do you and Miss Meredith have any jointly held debt?
No,
And are you asking the court to enter a decree of dissolution, dissolving your marriage and restoring you to the rights of a single person?
please.
Are you asking that you be granted custody of your daughter?
Yes, ma'am.
And are you asking that visitation with your daughter for Miss Meredith be at your discretion?
Most definitely.
And are you asking that you each be awarded the property currently in your current
Yes.
possession?
Yes.
Is there anything else you would like to tell the court?
I don't have any problem entering a decree of dissolution. I do, however, before I grant custody in this situation, I would like to grant him temporary custody so he could protect the child from being taken. Okay, but I would like to schedule next month and for you to serve her with one additional opportunity to come here and to make some argument as to what visitation she.
Of course, Your Honor.
I don't think she'll come.
Yeah, we have no way of contacting her.
Well, your attorney will make the best
Yes.
effort possible.
So,
And
The sheriff's department served her up there somewhere in this address. They have an address where they served her. I would suggest that you might call the sheriff's department up there and see where they found her, if there's a mailing address up there. Or something, and, you know, at least we'll give them the opportunity to do that. Okay?
was there,
Submit it electronically and hold, leave that one thing unresolved and we'll, if You come back here next month, I'll take care of that too.
Thank you. What is next month's date?
May the 22nd.
Thank you.
I tell you what, go ahead and give him custody and give her 60 days to come forward to challenge that. That would be better to do the order that way. And give her 60 days to come forward and challenge on that one issue.
Yes, Your Honor. I will get that tendered to you. Thank you.
Thank you.
Thank you very much. Planet Home Lending LLC versus Nicholas Glazen.
Good afternoon, Judge. William Rich on behalf of the plaintiff. It's a motion for default judgment and order of sale. The defendant actually is out of state. We served him via the long arm statute.
I don't see you here. You want to turn the camera on?
I'm trying to, Judge. I'm having an issue turning my camera on. I apologize. Wait, try that again. Do what you just did again. I hit the wrong button.
We might call
There
it.
we go, Judge. Sorry about that. Can you see me now?
Yeah, we can see you now. Yeah.
Okay. The defendant is out of state. We served him via the long arm statute, the Secretary of State. The service is proper. We're asking for a default judgment order sale.
Yeah, how much is the real estate involved in it?
Yes, sir. He does own real estate in Cumberland County, and we're asking that to be sold by the Master Commissioner.
Okay, did you provide the check to the Master Commissioner?
Yes, sir.
Okay, well, submit the order and we'll sign it, okay?
Very good, Judge. Thank you.
Thank you. Let's go to the back. Let's see. Does that take care of all the Cumberland County cases? That takes care of the Cumberland County cases. Let's go back to the Pulaski case. Pulaski case, Head versus Sloan. Heard from counsel on the other side yet? There he is. Yeah, there he is. Head versus Sloan. Hello, welcome.
Good afternoon, Your Honor. I'm Jim Ridings here for Karen Head.
Okay, what do you have?
Your Honor, we have renewed our motion for summary judgment. The court's very familiar with the case. I'll argue as much as, or as little as you prefer, but essentially the standards are that the agreement must have had full and fair disclosure, must not be unconscionable, and must not have been procured through coercion, fraud, or duress. After some 3 years of discovery, Your Honor, we submit that we're entitled to summary judgment. Mr. Head made a full, fair disclosure. There's no evidence of unconscionability, and there's no evidence of coercion or fraud or duress.
Okay, what do you have to say?
Yes, Your Honor. In response to that and in objection to the motion of the defendants for summary judgment, we believe that there are issues of material fact that we put onto the record. We want to focus on one. Of course, we rely upon all that we have filed and all that the prior attorney for Ms. Head has filed on the record in that respect. But the one, maybe two, I'd like to focus on be the issue of duress. As you will recall, Steve and Karen went to the office of the attorney. He prepared a document. Later, that same attorney said, you all need to go home and get your ducks in a row. You're not in agreement yet. Ms. Head, Karen, did not have the opportunity to even see any document from that point forward until the day that she was told by her husband to be, let's go to the court, let's go to the lawyer's office. We're on our way to get married. You sign this document or we will not get married. Karen loved this man so intensely that she didn't want to lose him. She wanted to marry him. She knew.
Is that in the record about how intensely she loved him? I don't remember hearing any of that.
She has indicated that
Well, I
she
know,
did
but
have
I'm
a
saying,
love
is
for
it in the record? I mean, I've heard these people numerous times and I've never heard any declaration of intense love connection. I've often wondered when somebody says, if you don't do this disclosure, I'm not going to marry you. If that's not a good indication, it'd be a good time to walk. I think, but go ahead with your argument,
Perhaps it would have been, but we as human beings don't always make the right decisions at that moment.
Well,
in
you and I
time.
would be out of business if they always made the right decision.
Perhaps
Okay,
true.
go ahead.
All right, sir. She asked that day to speak with the attorney who had prepared it, Steve Head's attorney, not her attorney. He wasn't there. She did not have the time to consult her family. She didn't have the time to consult with an attorney of her choosing. She went in and was told to sign it. She did sign it, not knowing what was in there.
Yeah, as I remember from the record, she'd been involved in setting another prenuptial agreement aside, hadn't she?
That is correct, Your Honor. That
So
had
this
happened.
wasn't her first rodeo, was it?
It was not her first rodeo.
Do you think that ought to influence me some, the fact that she had the experience of setting one aside before and then she went ahead and signed it because she wanted to marry this guy for some reason?
Not at all, Your Honor. It's
Okay.
not a pattern of conduct.
Yeah.
There was one incident before, and we humans make the same mistakes over and over. We know that. Human beings are of that ilk. It happens. For this court to grant summary judgment to the defendants at this point in the case would be to deprive Karen of her opportunity, show the jury the pressure she was under, the intense pressure she was under that day. And we believe that's an issue of material fact.
Who was the attorney that drafted this thing?
Judge Prather.
And is he still available? He can be a witness? He said
He's given a deposition, Your Honor.
I knew he did, but is he still available now? You expect to call him to trial?
May we approach?
Well, you don't have to. I can,
There's some health issues, but,
yeah.
so I
Do
couldn't,
you think
I couldn't say
he
for
might be
certain.
diminished now, is what you're telling me?
No, certainly not mentally. I actually saw him, approximately a week ago.
Yeah.
And he was doing well, but, I couldn't speak for the future. I'm not,
Okay.
but he gave a thorough
Okay,
deposition.
what's your other thing besides this?
The other issue is whether there was a mistake. Karen had said to her husband-to-be, the idea of my having ownership of this house and this land where we're living has to be in there. And he did not make a will. Well, there's information that he did make a will, but that will doesn't exist at this point in time. It's never been found, a signed version.
What proof will you have that she told him that?
Her testimony.
Other than that?
I don't think anybody heard it, but I'm not sure. I mean, it's uncontradicted that she had
There's
said that.
nobody around to contradict it. He's not around, is he?
He is not around. He has
Yeah.
passed on.
Yeah, I don't think, so she could say she told him anything that wasn't included in the thing.
She could say that. She's a Christian woman who would not lie about that.
Even Christians backslide, to take up your point. On occasion, I'm not saying she is lying.
Well,
I don't know, what do you have something else?
no, I fancy myself to be a Christian, and yeah, I have not been the best, but I'm trying so very hard. And so is this lady.
Well, you say, I mean, you're not, I don't want to hear that portion of her Christianity fitting into this thing. Why I should believe it because you say she's a Christian. I'm a Christian, I
Well, the
take that
issue with-
seriously. What do you have to respond to this?
Your Honor, we've attached, to our second response to the plaintiff's motion for summary judgment. Which I think is interesting, saying on the one hand, the material issues of fact, on the other hand, she's entitled to summary judgment, so they're either material issues of fact or they're not.
I can't hear what you're saying. You need to talk more distinctly.
There are either material issues of fact or they're not. So I think the plaintiff is saying on the one hand, there are material issues of fact, preventing our motion for summary judgment, but is claiming that there are no material issues of fact to grant her summary judgment, and I think that's an inconsistency.
So if we go to trial on this thing, the only thing a jury is going to decide is whether or not the antenuptial or prenuptial agreement is valid or not. That's the only triable issue. Is that correct?
I don't think it's triable by a jury, Your Honor. I think it's a matter of contract law, and I was referencing the Aubrey decision. Aubrey versus Aubrey is an unpublished decision, but it cites published decisions that define coercion and duress. And it has to mean such violence or threat made by the party or some person acting for or through him or by his advice of counsel as are calculated to produce on a person of ordinary intelligence a just fear of great injury.
I tried one of these cases.
Yeah, so I think it's a matter of law. There's no evidence in support of any of our claims. I think it's a matter of
You think
law.
you're entitled to a jury trial?
I have filed a motion for summary judgment on the primary issue of duress, so I think.
You're not gonna get a summary judgment on duress on.
Then I won't argue that.
On your client's word that he said this to her and he's dead, you know, I mean, that's problematic to me.
I believe that because there is at least one and probably three primary issues of material fact, that the case is not proper for summary judgment. There must be, well, of course, fully aware of the case law on what it requires for summary judgment. This lady should not be deprived of her right to a jury trial. She should be allowed to go forward and convince this jury, if the jury chooses to believe her, that there is an issue of fact and that the document should be cast aside.
What was the duration of this marriage?
Not sure exactly. I think it's in the record, probably a dozen or so years.
Thereabouts.
Relatively lengthy.
Sure. It was not a short duration. I agree with that.
Well, I'm inclined to grant you summary judgment on the thing, and if I'm wrong, then we'll have a trial rather than do it the other way. I just don't see where there's any tribal issues on this thing. I've dealt with this for a long time. I've heard all kinds of testimony on it. I just, you know, the lawyer that created it's a highly respected lawyer, experienced lawyer who I've known, we all have known for a long time. I don't see any mistake there. I don't see I just don't think that when you have these documents of this import, and whether I should include it or not, I'll put this on the record so you can challenge it. The fact that she's been involved in that sort of transaction before and knew the importance of this document, it gives her an extra level of knowledge before she entered into this, in my opinion. And go ahead.
If I may, just very briefly, we're not saying that it was Johnny Prather who made the mistake as such. What we are saying is that Steve Head made the mistake of failing to include that in the document, or else deliberately deliberately omitted it, I should say. That's our issue.
It really bothers me to open one of these documents back up and let the survivor say what they told somebody, they told privately their spouse was supposed to be in it, and it wasn't in it by mistake, or that. I just think that you might as well do away with these agreements if you do that. And we know that the agreement's not necessarily favored, but they're enforceable. So you draft a summary judgment and present it, and I'll get it entered so you can appeal this thing. If I'm wrong, we'll have a trial, okay?
Surely.
Thank you very much.
I'll get that to you. I'll get to Mr. Ryan.
Thank you, Your Honor. That's all I have today.
Yeah, you have safe travel. It's good seeing you as always. Now, the Clinton docket's the only thing we have? Yeah. 2:00, till 2:00, sir. So we have a two. Okay, Ray versus Ray. We got two more asking. Okay, let's call Clinton Circuit Court in special session. Meeting by agreement here in Cumberland County. Call a case of Moons versus Moons. Ashley Moons versus Timothy Moons. Can you find it? Okay. Okay, I think the hearing today is whether there was there's been a violation of a protective order, isn't that correct? The hearing is on a violation of protective order?
Yeah, and for clarification of the original.
Okay, all right. But let me hear what you have to say about what clarification is.
The only order that we received was an IPO that indicated there was a 50-foot buffer area where he's not supposed to be around. When I reviewed your initial order, you held the domestic violence order in abeyance and directed Angie to draft an order to get it to us within 2 days. And then after, I never got that order. I'm not really sure what that order was meant to be. But you then said, I'm going to sign the IPO today. So our understanding was, and still is, that because you held the DVO in abeyance, that the EPO is still in effect, and the EPO indicates there's a 500-foot buffer area.
Well, I'm gonna rule against you on that. I think I did the IPO with 50-foot because of sporting events and things like that, but I'm not prejudging whether or not he, was playing fast and loose with measuring 50 feet and still trying to do something. We'll hear some testimony about that.
So,
Do you agree or disagree with that?
On the 50 feet?
On the,
Yes, I think it was clearly stated on the record, Judge, that you said that you would allow them both to attend sporting events for their children. And I think that's the only allegation is they're alleging that he got, I think the most at one point they said was a measurement of 40 feet in a public arena.
well, I'm not going, one of these days, I'm gonna get tired of this case. And I'm gonna do something wild to somebody if they keep gaining this stuff. If you start to take 42 feet, you know, I mean, I enter an order for him to stay away from him. And then he comes over and wants to step off a number of feet so he can go over there. If I find out that happens, there's something gonna happen in this case that somebody's not gonna like.
And Judge, I believe the testimony is going to show that's not what
You know,
happened.
I didn't say it, I just, but when you said kind of 42 feet or something, it kind of triggered me a little bit. You know what I'm saying? Okay, well, you gonna put your witnesses on?
I did, yes. Recall, Ashley Moon, you want her up here?
Sure, yes, she'd come up here. Ms. Moon, you raise your right hand, you swear the testimony you're about to give is the truth, whole truth, and nothing but the truth.
Yes.
Lean forward and speak into the red microphone. Do y'all have any other
Judge,
witnesses?
I was going to ask
Wait
if we
just
could
a
have the
second.
rule.
Well, I'm going, do you have any other witnesses?
I have one that I asked him to step outside, a
Okay,
police officer.
Do you have
Go ahead
any,
and step
do you have
out.
any witnesses? We'll apply the rule to witness and both of you the police the thing. Okay. What do you say?
Well, sorry, I'm trying to. Provision for witnesses, so that way she couldn't hear, so I could, Jamie couldn't see in the way.
Okay. Got somebody in the waiting room. Do you, is that your witness?
It,
or-
it probably is. He's a police officer from Western.
No, Judge, it's my witness.
Okay, well, she's in the waiting room now. Okay, go ahead.
Okay, tell us your name, please.
Ashley Moons.
Ashley, since the IPO that was entered in March the 6th, 2025, have there been any instances wherein Mr. Moons has violated that order?
Yes.
Okay, I'm gonna start with one of the last. Was there an occasion at Western Kentucky University, Diddle Arena, where there was a violation?
Yes.
Can you explain to the court what happened?
Yes, we were at a regional championship game at Western Kentucky University at Diddle Arena. I was sitting third or fourth row from the bottom. I did not seat him, but someone had told me that he was at the very top. After the game, I immediately went onto the floor with the people that I was with. Upon looking around, I noticed that Tim had moved to the second level of Diddle Arena. He was staring at me, very intimidating. And then I stayed on the floor. I talked to some parents. We were waiting on the kids to come out of the locker room. And then when I turned around again, I had noticed that Tim had made his way down to the floor, also against the wall with, he had one of his sons with him, and then our son Jex.
Was with him?
Yes.
Why were you there? Was Jex playing or were there other?
This was, no, my middle son, Max, was there. He's on the team.
Okay. So did you bring Jex with you to the game?
I did not.
So I guess Tim brought Jex.
Yes, he was with his father.
But Jex wasn't playing that day?
No.
Okay. How close do you think he was to you when he reached to the floor?
It seemed very close. I would assumed he was probably 30 feet away. I did move around some. I tried to move further away at different times and move closer to like where they would be coming out.
Was he looking at you or trying to engage with you in any manner?
At one point, he did, say the word bitch and was
Out
looking.
loud,
Mhm.
directed towards you?
The person that I was with,
Who were you with?
Cliff Jasper.
Your friend?
Yes,
Okay. Did you report this to authorities there at the game?
I didn't immediately, because our children were there. Jex was with his dad. I didn't want to alarm Jex.
Okay, so at a later date, did you report it?
Yes, I did the next morning.
Who did you report it to?
I called around to see who I needed to talk to about it, and they told me I needed to contact the Western Police, Western Kentucky University Police.
Did you report it?
I did.
And did you receive an investigative report?
I did.
And from your review of the report, do you believe that there's documented evidence that he violated the order?
Yes, I do.
Okay, in your affidavit, you indicated some other instances that occurred that have at least given you pause for concern that you believe may have been a violation. Is that correct?
Yes.
Can you tell us what the first one was?
The first one was a couple days after we had went to court last. Jex had a basketball game at the elementary school. I arrived first that day, and the way he had a couple games, the way the gym is laid out, there aren't bleachers on both sides. It was my understanding from our last court date. The judge had said, you all can be 50 feet away from each other when there is a ball game, opposite sides of the gym. I was at one point sitting at the very end of the gym, and he was standing in the doorway the entire time instead of sitting on the bleachers. This was before he did help coach the game, but for a majority of the time, he was standing in front of the doorway.
Was he on the opposite side of the gym as the judge had instructed him to be, even when it's circumstance that you can't be 50 feet
It
away?
would be on the same side of the gym. I mean, there's only one way in and one way out of that gym. So he was standing in the doorway.
The whole time you were there?
Not the entire time, but a good majority of the time.
Did that impede your ability to leave?
It did. I felt like he was trying to intimidate me the same way I felt at the Western game.
You know if he was, how far away he was?
I don't know how
You
far
didn't
away.
measure it, didn't
No.
report it to anyone?
I did not.
Did not make a claim to the court on that, right?
I didn't make a claim.
Okay.
He was as far away as he could be from me in the gym, but again, standing in front of the doorway, the only in and out.
Okay. And was there another occasion that gave you concern?
Let me
Do
think.
you have a photo of that or a video of that?
I do.
Is it on paper?
It's on my phone.
Could we demonstrate that to the court?
I don't know whether you can or not. I couldn't. If I had it, you might be able to. How would you do it?
We put it on the Elmo device?
Elmo like that? I never.
Yeah, we've done it before.
Try it. Turn the Elmo on.
I think so. Yes.
Okay, you can turn that off, put her back on. We're on, okay. So prior to these events, was there any other issues that gave you cause for concern?
Are you talking about just in general after?
I'm talking about after this incident happened, there was some drive-bys.
Oh, yes. Before, I think it was before the Diddle Arena incident, he was driving by my house. I do live in town. So he was driving by frequently, circling around through there, and he actually blew the horn a couple times when he passed through. I was in the driveway, my daughter, her boyfriend, some of their friends from high school.
How many times did he drive by in what shorter period of time?
It was 3 times in 10 minutes.
And one of those times he blew the horn?
Yes.
Okay, and was there another incident involving a message?
Yes.
Concern?
I had picked Jax up either Saturday or Sunday. He wears the same outfit back and forth. I was putting his clothes back on in that Wednesday to send him back to his dad. His legs were turned inside out, and a green Post-it had fell out of the pocket of this pants. And I do have a picture of that. I forgot about that one. It said, huh?
Pull the picture out.
See one.
Do I just lay it up there? Do I need to?
I think you have recently been to district court, is that correct?
Yes.
Is there a pending violation of the emergency protective order in district court against Tim?
Yes.
Do you know what the bond is in the district court?
I believe it was 500 feet.
So after he was arrested on the district court case, he was not to be within 500 feet of you at any time, right?
Yes.
And that district court case is still pending.
Yes.
Was he arrested for that before we had the domestic violence hearing here?
We just went Tuesday. He wasn't arrested that day.
I understand. When he was originally arrested on and the bond was scheduled, was that before we had the domestic violence hearing?
Yes.
Anything else I need to ask you about?
No.
That's all, Jeff.
Let's guess.
None of these games that you've testified Tim was breaking the 50-foot limit. He did not approach you at any of those two.
He did not approach me.
And you said your son was on the team at Diggle, but your son wasn't dressed out for that game, was he?
No, he does not dress out for
But in
varsity.
fact, Tim's had a son that was playing that day, that night in that game, didn't he?
Yes, he was dressed for varsity that night.
And he actually played on the floor, didn't he?
I'm not sure.
Now, where you're saying that you heard him yelling out, bitch, how many people were in that gym at that time?
Several.
And Tim was not within a close proximity to where you could identify that was him among the crowd, was?
Yes, he was.
But you just said that he didn't get within even closer from your measurements, 42 feet, right?
He was very close at different times.
Now, the incident that you're talking about at the elementary school that you showed the videos, Tim didn't approach you at all during that period, did he?
He did not approach me.
And he was in fact coaching games that day, wasn't it?
He was helping.
Okay. So he had a purpose for being there at the gym that day.
We both did. Our son was playing.
And the pictures that you showed of Tim on the field this past week at Jax's first game, Tim was actually on the field, wasn't he?
Yes, he was on the field.
and he was there on the field assisting while the team was playing.
He is not a coach.
Not a coach at all, but he's apparently for some reason he's out there on the field with the other coaches.
Because he walked out there.
And nobody asked him to leave, did they?
It was a message the next day for no parents to be on the field.
You didn't present that just a while ago, did you?
I can.
Okay. Now, you said that Tim has driven by your house. At one time he drove by 3 times and was blowing the horn.
Yes.
Do you have a video of him doing that?
I do have one video of him driving by.
Okay, but is he driving by in one instance on a public road, or do you have videos of him circling multiple times?
It is a public road. No, I don't have the entire video.
Do you have a video? In the video, is he honking?
Not in the video that I have.
So as we sit here, you're saying, based on your measurements, that he violated, so you're measuring every time the 50 feet when he's not coming towards you and not approaching.
I did measure at the Little League baseball game. Measurements have been made, and the witness that we have can attest to that.
But what I'm saying to you is, during these time periods, he's not getting close. He's not following you. He's not approaching you, correct?
He's staring and smiling at me, which I find very intimidating.
And you wouldn't deny that there are times you've stared at him at some of these events, would you?
I'm not staring at him unless I'm trying to take a video.
Okay. I'll make a British judge. See you. No. Does that appear to be a picture of you staring up?
Yes, but it does not show me staring at anyone in particular.
But you wouldn't deny that you staring upward in the bleachers.
That is me noticing probably that he's standing there.
Looking and staring.
Judge, if I could put the Elmo on.
Yeah, I'm having a little trouble with definitionally.
And we don't have any, you didn't document or take any pictures of pulling the note out of Jex's clothes or anything like that today, did you? To bring to the court today?
I just have the picture that I presented.
And you all were, in the course of your marriage, you all would exchange little notes and things together, wouldn't you?
We did.
Right. So you don't have anything showing that that's a recent note and not a note that you exchanged prior in your relationship?
I don't. I mean, I wouldn't have had my camera out for any reason to record myself taking a note out.
I don't have any questions, Judge.
So, okay, you can stand down. Are you more questions?
I just have one more question. The exchange of checks, the court order indicated that at Mr. Moon's request that his brother Josh be the primary one to do that exchange.
Yes.
And that your mom and his father be the alternates.
Yes.
Correct? Who has been doing the exchange at the videos?
His mother, Wilma, has exchanged a majority of the time. His brother, Chris, has exchanged 2 to 3 times, and his sister, Ginger, has exchanged.
Has Josh ever done the exchange?
I haven't seen him.
Has his dad ever done the exchange?
He was with Wilma once.
Okay. Are you asking that the order be followed and that it be Josh or your mom or his dad?
Yes.
Thanks.
Okay, stand down. Yeah, I'm a little confused about what you were doing over in district court. It's your position that the EPO is still in effect because I held it in abeyance and that's the reason y'all are back in district court? Or there was a criminal charge
Yes, sir.
filed, violation, that's what you're on, so you're over there on a criminal charge.
I'm not there. I'm not in that
But
case,
that's
but
why she's over there on a criminal charge.
that's correct. Criminal violation of the E
Before
EPO.
before it came up.
Yes,
Yes, sir.
Judge, that's what I was saying, it was the March 4th, I think is when that.
Okay, how are we next witness?
Officer Dustin Lee, Officer Dustin.
Doesn't sound like anybody has to worry about a softball or a baseball game this afternoon. And the flood out there, jeez. Officer, you want to come up here and bailiff will show you the witness statement. Yes, okay? You raise your right hand, please, and swear the testimony about you is the truth, the whole truth, and nothing but the truth.
Yes, sir.
Thank you. Have a seat, speak toward the red microphone in front of you there and state your full name and then your employee work capacity.
Dustin Lee, Western Kentucky University Police Department. I'm a patrol officer.
You may proceed, counsel.
Mr. Lee, were you engaged in your duties with the Western Kentucky Police on or about March the 19th, 2025?
Yes, sir.
And did you receive a complaint from Ms. Moons concerning potential violation of an existing interpersonal protective order?
Yes, sir.
So did you see that the same day that the incident happened or a later day?
I believe it was the following day.
Okay. And did you undertake an investigation and results?
Yes, sir.
Can you just tell the court what you did and what your results were?
When I received the complaint from Ms. Moons, she advised me that there was a 50-foot stay away order with her ex-husband. She gave me a clothing description of him during the event and a clothing description of herself during the event. This was during the KHSAA basketball tournament that was hosted at Diddle Arena, which was why we were there. Diddle Arena has quite a few cameras set up inside of it. I told her I would review the camera footage to see if I could find where they were at based on where she had told me they were. While I reviewed the cameras, she told me more about what happened, about where he had come down, out and down onto the floor, what her interactions were with the, and about where she was at on the court. After a phone call with her, I started looking through different camera apps that we have, and I was able to locate her on the court. She was down at the home team sideline and near the Conference USA logo in the free throw area. And Mr. Moons was located at the very end where our bleachers push in to, when they push those in, it's to take away seating. It's only out during WKU basketball games, men's and women's. He was standing at that end. I got the rough area of where both of them were standing. I went down into Diddle Arena and took rough measurements with my iPhone using the measuring app on there. And the distances I got were anywhere between 40 and 42 feet from the rough area where she was at and the rough area where he was located.
Of the rough areas, there some area for difference that you could possibly be wrong, or are you pretty sure that?
To go above the 50 feet, no, sir.
So it would have been no doubt that it was less than 50 feet?
Yes, sir.
From how many of the video angles did you view?
I believe it's two angles that we have. One would be from behind looking down, and the other across the court looking down the other direction. So basically crosses as they go.
Okay. Were you able, after you watched those videos, to make any determination about the movement of these two folks prior to the time that they engaged within this 50-foot area?
Yes, sir. Ms. Moons had come down out of the stands. She was right behind, I don't recall which high school it was. She was right behind them in their stands.
I finally found her coming out, and I found Mr. Moon's coming out as well on the far side, coming down the stairs. They come down like down, and then you make a left turn, come down to the floor. She was, before she got to the free throw line area, she was standing about halfway between there and the bench. Mr. Moons had come down, was stopped right at the very end and came to her final spot.
Okay. Did you see them each time?
No direct talking back and forth, nothing like that we could see on the cameras.
Were you able to see whether or not they looked at each other and knew of each other's presence on them?
It did appear that Mr. Moons did look in her direction because there was a couple times that he had turned back, but he would turn back, look again, turn back, look away.
Okay. And I think you may have brought these videos that you utilized with you.
Yes, sir.
And is that in a CD?
Yes, sir.
or
It's a DVD.
DVD, and I'm going to assume, Judge, that we don't have the capability of playing that. So do we have a capability of playing a DVD?
Someone has a laptop to the phone.
Don't have one. So, okay, so we don't have that. And anything else you need to add, sir, to your testimony?
No, sir.
Okay, then Ms. Angie will ask you some questions.
Officer Lee, you noted in your report, I think, that initially Mr. Moons's back was to Miss Moons. Is that
Yes, that's
correct?
what it appeared. Yes, ma'am.
And when you reviewed the video, was it just a small amount of people that were on the floor, or was there an actual crowd that was there on the floor?
It varied from time to time throughout the entire length of time from the game ending until everybody started leaving. There would be large groups that would come down, large groups that would leave. It varied at different points when they were both within that area. There would be quite a few people, and then there would be very few. The majority of the time, the largest part of the crowd would have been, if you were looking from Miss Moon's direction towards the end of the court, would be to her left, where Mr. Moon's would have been to her right.
And I think you testified that on the video, you could see him look in that direction, but then he would turn away.
Yes, it did that a few times.
Okay. And then you said that when she was already on the floor and he was coming down, that in the video you saw her circle back around to
Not the
direction
entire,
where he was,
not the entire length of the floor. It was,
but she
trying
brought
to
herself
describe-
back to a closer distance to Mr. Moons.
it wasn't, try to explain this, without the video, it's kind of hard to explain. If you imagine the free throw line going straight across, she would have been about even with that, and her distance wouldn't have gone beyond the 50 feet going this way. It wasn't like she made a loop to the other side of half court and came back down. It was just coming over to this side.
But you didn't see anything on that video that they were interacting or that he was getting extremely close to her or moving around with her in the gym, did you?
No, ma'am.
Okay. So from reviewing the video, what you saw was two people that are there at the ball game and coming onto the floor after the ball game's over.
Yes, ma'am.
Okay. No further questions.
I have nothing else, Judge.
Will this officer be excused?
Yes.
Thank you for your trip over here. Have a safe trip.
Yes, sir. Thank you, Judge.
Have a good week.
Would you like to put in witnesses on?
Yes, Judge. I would like to call Jamie Cooksey. She's the one that's on Zoom.
Megan, are you back there to put Miss Cooksey on? Okay. Call Jamie Cooksey, okay. Would you raise your right hand, please? Swear the testimony you're about to give us the truth, whole truth, and nothing but the truth.
Yes,
Lower your hand, state your name, please.
Jamie Cooksey.
Okay, proceed.
Miss Cooksey, can you hear me okay?
Yes,
All right. And were you at the ball game back at Diddle Arena when Clinton County was playing in the regional tournament?
I was, yes.
And do you know Ashley Moons and Tim Moons?
Yes.
And how do you know those parties?
I have known both of them probably most of my life. Tim and I were friends all through school and high school. He's coached my children, and I was a teacher to their child for 2 years.
And so you're a teacher that works in the school system then?
Yes,
And at some point, have you worked with both Miss Moons and Mr. Moons?
yes. And I worked with Ashley also at the Early Childhood Center.
So were you present and able back, I think it was maybe March the 19th of this year, to observe Tim Moons at Diddle Arena?
Yes.
All right, if you would tell us what you saw, I guess toward the end of the ball game that day.
After the game was over, we made our way down to the floor, and I was just waiting on my son to come out of the locker room. And I heard Tim just yelling, Miss Jamie. So I turned around and he told me that Jex was yelling for me, and I waved at him because I couldn't hear him. And I just talked to him for a minute, and he was up on the upper level at that time. And he told me he said, I said, why are you standing up there? Because everybody was down on the floor. And he said, I have to stay away from her. And so I just waved and went on. A little while later, time had passed and the kids started coming out of the locker room. And he was down at the end of the floor with his younger son and taking pictures with the boys. And I asked if he wanted me to take a picture with him in it. And he said yes. And so I did. And that was basically the extent of it. We just all were kind of just standing around talking, waiting on the kids.
So you were there for a little while then with Tim while he's on the floor at Diddle?
Yes.
Right. That you were interacting with him there on the floor. And did you see him following Ashley or looking at attention in any shape, form, or fashion?
You cut out a little bit. Did you say, did I see him following?
I said, did you see Tim following Ashley with his eyes, looking in her direction, or do anything to try to get her attention?
I didn't see anything like that. I mean, I wasn't really looking for that. I was just, we were just kind of standing around, but I didn't see that.
Well, I guess what I'm asking you is, did you see him being focused on your all's interaction with the kids, or did you see him being focused on Ashley?
He was, when I was talking to him, he was just talking to me about the game and about the kids. My little girl was kind of running around, and
I don't have any other questions, Judge.
I just have a very brief question. I thought the best place to go to.
This is the best place.
While you were standing around him in the upper bleachers, did you see him take a picture of Ashley on the floor with his phone?
I did not. I was on the bottom part when he was up there, but I did not.
Thank you.
May this witness be excused?
I would ask that she be
You
excused,
may be
Judge.
excused. Thank you for your attendance.
Thank you.
Okay, you gonna call your next witness?
I called Tim Moons.
Tim Moons. Raise your right hand. You swear the testimony about to give us the truth, whole truth, and nothing but the truth.
Yes, sir.
Have a seat, lean toward the red microphone there and state your name.
My name is Tim Moons.
Mr. Moons, you've heard your estranged wife Ashley's testimony about your violations of the IPO. If you would first, let's start with the Diddle Arena. At any point, did you approach Miss Moons?
No, ma'am. I stayed as far away as I possibly could.
And I used your phone a moment ago to show a picture that you had taken of Ashley. Why did you take a picture of her at the game?
Because at many events, she's taking pictures and video of me, and I seen her looking at me. Actually, I didn't see her looking at me. My youngest daughter was standing beside me, and she seen her looking at me.
You can't say what somebody else told you. I'm asking you, why did you take the picture of Ashley?
Because she was staring at me, or looking at me.
Had she been staring or looking at you more than that one time that you took the picture?
Twice that I seen. I mean, I'm just as I was looking.
And did someone else in the crowd point out to you that she was also looking up to find you?
Yes.
Other than that, did you take any other videos or pictures of her interacting there at Dental that day?
No, I was focused on my son.
Now, let's go to the elementary school that she testified about, where you had Jex's first game. Did you approach her at any point during that time?
No, I was told by Mr. Judge Williams that to stay as far away as I could. When I come in the door, I purposely let her get there first, so I know where she was. When I come in, I can see where she was going to be at. And there's 3 double doorways in the elementary school going into the gym, not going into the school, going into the gym. And Jex's game was only about 7 minutes on the clock left before his game was up. So when she says 25 minutes, I stood by the door because there's only one side of bleachers at the elementary school, and there was 2 other teams playing. So I couldn't go over there to the bench area, wherever you would coach the team at the next game, while the other team was playing. So me and Jex and I think Coy or Titan 1 stood down there by one of the doors, and there was actually 2 more doors she can go out.
To get to the bench where you would have been coaching, would you have had to walk past the bleachers or in the area where Ashley was standing?
No, you can go around I don't know which way you call it, north or south end of the floor. You can go around the one end of the floor right when you come in the door and go to the bench area. But like I said, there is no bleachers behind the benches. There's just a wall, and there was another 2 teams sitting on the bench with a game going on. So I didn't want to go over there and sit on their bench when it wasn't my team play. It wasn't Jex's team playing.
And would you have been approximately about the same amount of distance if you went to the bench as well as?
Probably been closer.
Closer if you went to the bench? Okay.
Another day that the whole time that I was on the bench and the whole time that I was coaching my son, that I was getting videoed and pictures snapped the whole time.
Now, what about the other day where you were out at the ball field and you were actually on the field? Where was Ashley located?
Well, I have video that I went back and got the next morning because this is the kind of life I have to live now, of where she was sitting at when I first arrived. Again, we have to look for all this stuff. And when I first arrived, she was sitting on the opposite side of the field. And me and my son, my oldest son, Titan, and my son, Jex, who had the game, if you know at Clinton Canyon Park, there's a big building right in the middle of the 3 fields. Instead of going the easy route to the little T-ball field that he was playing on, we've circled the whole building to go around the baseball field, the softball field, and back up to the third base dugout just to stay away from her. As I approached the dugout on the back side of the third base thing, and I was well beyond 50, 60, 80 feet at that point, I noticed Ashley pick up her chair because some of her family had arrived, and she had moved to the third base side at that point.
So was that her moving closer to where you were?
Yes, much closer, probably 40 feet closer. And after the game started, before the game started, I asked one of the coaches, because I coached Jackson this same stuff last year, and 2 coaches can't coach 5-year-olds. If you ever coach 5-year-olds, you can't have 2 coaches coaching. You got to have a coach for each base. You got to have somebody pitching to them, and you got to have somebody helping them bat. So I asked one of the coaches, I said, "Do you need me helping work?" And the girl automatically said, "Yes, we'd love for you to." And I said, "I can coach a base, I can help bat." And she said, "We don't know what we're doing. Please go help bat." So I said, "Okay." And whenever I made my way to behind the plate, instead of walking close to the fence, I walked all the way to the pitcher's mound to the other side of the field and then back up to the plate to stay away from her.
Now, you said that you had some video. That wasn't actual video while you and Ashley were there at the game, was it?
No, but I have pictures of where she moved to.
If I may approach, Judge.
It's not necessary.
Have you been driving back and forth around Ashley's house or doing anything to harass her and intimidate her since we had that hearing?
No, ma'am. She lives on the main road, and my bank's right across from her house. The post office right beside her house. To go eat at Pizza Hut or Dairy Queen or the Mexican restaurant or Lee's, you have to go by her house. I mean, if not, I have to take 6 back roads and the bypass. It takes an extra 15 minutes to get there. And then if I have to go to the courthouse, you have to go by her house. There's no other way around it.
Were you just circling around her house like
No.
she's alleged?
No.
No further questions, Judge.
Examine the witness.
At Dental Arena, you knew she was there, right? You knew she was there because you were taking pictures of her.
I didn't know. I mean, yeah, I knew she was there after the game was over.
Or you took a picture of her from the stands. You say she was staring at you, right?
The game was over, sir.
So you knew she was there. Why'd you move close?
I didn't move close. I actually, to be more elaborate on the Diddle Arena thing, as Miss Jamie Cooksey testified, I stood up on the balcony and Ashley's son had already come out and he didn't even play. He was not in the locker room. He come out, she talked to him, he left again, and she stayed around to do nothing. My son still hadn't come out. But once my son made his way out, if you know Little Arena, you go down the steps, the bleachers is pushed in as the officer testified. I stood as close as I could to those pushed in bleachers without pretty much sitting down in the chair that was not even available to sit down on. And I stayed there the entire time until my son came out, and then I still didn't move. And when Miss Cooksey took a picture of us, we was backed up, and I can show you the picture. Miss Angie has the picture. We was backed up against the bleachers. That's how.
You just told us that you saw her on the floor, right? That's what you just said. You saw her waiting on her son to come out. Why did you move closer to her?
Sir, a basketball floor is 94 foot long.
Why did you move closer to her?
I didn't move closer to her.
You're saying that the officer is lying when he testified you within 40 feet of her?
I didn't know. If I had to leave the gym, I'd have to walk down the steps or jump out the top window. I had to walk out the steps to get down.
Were you 50 feet away from her when you were up in the stands?
When the game was going on,
Yeah.
I was probably 150 feet.
Okay, well then why'd you move closer? You know you weren't supposed to be within 50 feet of her at any time, right?
I didn't move closer, sir.
You didn't.
No, I moved. My son had to ride home. I had to get him. I had to go get him.
Were you within 40 feet?
I didn't measure it.
At the recent baseball game, you were within 30 feet of her, weren't you? When you were standing on the field.
I didn't measure it, sir.
You knew she was there because you just testified she had moved from one place to the next. And then you went on the field knowing she was there and you were within 30 feet of her.
And as the last,
Is that a yes or no?
I did not get close to her. No,
You were not within 50 feet of her at the field.
I didn't measure it, sir.
Okay.
I was coaching my son, helping my son bat at a baseball game.
The ring that you gave to her, did it have an inscription on the inside of it?
What ring?
A ring you gave to her that has an inscription on the inside.
I have
of it.
no idea.
Okay. Did you make a note to your son and put it in his pocket with a little note on the bottom of it that has some initials on it?
I have not wrote a note to Ashley in 24 plus months.
I get that. There was a note that was in your son's pocket that
No.
said there was not.
That was not.
So did you see the note that was
I
on the
sure
video?
did.
Is that your handwriting?
It is. I check
Okay.
my son's pockets and I check my son for bruises every time he leaves, and I have pictures to show.
So she's fabricating that.
Absolutely, 100%.
Okay. You drive by her house all the time. Is there a reason for you to drive by 3 times in 10 minutes and blow your horn?
I didn't.
Okay. I think that's all.
No further questions,
You would
Judge.
stand down and our names witness.
Talk to my client. I'd call Wilma Moons.
While she's coming, the decree hasn't been entered yet because we're dealing with this stuff right now.
That's correct, Judge. Just go up there that way, watch your step.
Will you raise your right hand, please? You solemnly swear or affirm that the testimony you about to give is the truth, the whole truth, and nothing but the truth. Lean toward the red microphone and use your outside voice and tell us what your name is.
My name is Wilma Moons.
And you're the mother of Tim Moons, is that correct?
That's correct.
All right, Wilma, were you present at the Dill Arena game back on March the 19th of this year?
I was.
All right, and were you present the entire time?
I was, yes.
And where did you sit in proximity to Mr. Moons?
Okay, do you have anything that you're gonna ask her besides the little arena thing?
I do.
Okay, Okay, let's move on to whatever
Okay.
that is. I'm not real impressed with the little arena thing.
Could I just speak to that, Judge,
He
please?
said he didn't want to hear that issue, so.
Unless you want to hurt the case of your son, I would go on to the next situation.
No, I just wanted to tell you my perspective, but that's okay.
When
Yes.
Jax was playing.
Yes, it was.
And did you see Tim and Ashley both there at the game?
I did.
Did you ever see Tim interact with Ashley in any way?
No, he was, helping with the batting order for a little while, and then he was on third base for a little while, and she moved pretty close in the seating to him.
So when you say she moved, did you see where she was originally?
I did not see that because I was just a minute or so
But
late
when you
getting
saw
there.
her move, you saw her come closer.
She was sitting very close to the fence on the first row, and he was at the batter's box.
But Tim was actually there on the field helping.
Yes.
Did you see anybody trying to get Tim off of the field during that game?
No, I did not.
Did you see anyone or hear anyone protesting about Tim being out there on the field?
I didn't hear it myself, no.
All right. Did you see anybody approach Tim to try to get him off the field?
No, I didn't.
Did you see the other coaches interacting with Tim while he was out there?
I mean, they were all interacting with each other. I don't really know what you're asking on that.
Did you see Tim turning and looking at Ashley in any direction during that game?
No, I didn't.
No further questions, Judge.
I have no questions.
You may sit there, stand down, you may stay in the courtroom if you like. Call your next witness.
That would be all the witnesses for us, Judge.
I have a brief rebuttal.
It's not necessary. You know. You want to make your argument?
Judge.
You want to come up to the podium?
I would argue that they've not put on any proof to where my client is trying to intimidate her or in any way acting that's inappropriate according to the terms of the IPO. This court clearly advised both parties they could go to these events because they have children that are active in those. In fact, Mr. Moons's children are, as we saw, was the one actually playing at Diddle Arena at that game. And so I would just ask that the court overrule her request for contempt or that he's violated in any way.
Okay, well, let me ask you a question or two about this. The Diddle Arena thing doesn't impress me very much. There's a huge crowd at Diddle Arena. It was a big game. I was at the game. For things, I didn't see anybody at the game because I was so disappointed at the end of the game. I couldn't hardly see anyway. So, but in any event, you know, it doesn't appear to me. I mean, looking or staring at each other, I think both of them probably are watching each other. She's watching to see if he's coming around, and he's watching to see if he's too close. I mean, they got to look at each other. That sort of thing. Now, does he game the thing a little bit? You know, probably, but not to the point where I can make a ruling on that. Now, let's go back to this 50-foot thing. You know, when there's a 50-foot thing going on, and I reduced it significantly from the 500 feet to hope that people could get along and enjoy, you know, the athletic events of both. Does that mean that if he wants to coach that he can ignore 50-foot thing? Was that in the order, or was it just 50 feet? I mean, if he wants to get on the field and volunteer and it brings him closer to 50 feet, does that mean he can't do that? I mean, there's this is a rhetorical question. There's some things that he's going to have to sacrifice because it was his finding. I'm sorry he has to sacrifice this involvement. That's what happened when people don't get along with each other and confront each other and get in divorces. So maybe he can't go on the field and help with batting if she's there and he's closer than 50 feet. I could have made it 500 feet. He couldn't even been at the park at all. But I didn't do that because, you know, I'm aware of both of these people. I'm aware of their families, you know, their involvement. Anybody around here would have to be, and that's been in Clinton County, would have to know about the involvement of all these people in sports and how much it means. I mean, this mother obviously is very supportive of the child, the father is very supportive of the children and of the other people. So I don't know what you think there's a caveat on the 50-foot thing that if.
I don't, Judge, but you heard the testimony from his mother that she was, actually, they probably were 50
No,
feet
I'm
or
talking
further
about the
away.
ball game. I'm talking about, it doesn't bother the WKU thing.
No, I'm talking about the ball game where he's on the
Okay,
field
well,
coaching.
I'm talking about if she's sitting there on the sideline at a game and he's out on the field coaching and he's within 50 feet, is that an exception? Do we need to carve out an
I
exception?
think we do need to carve out some type of exception for
But
that,
there hadn't
Judge.
been one carved out yet, and there wasn't on this particular day, one carved out. And I will tell you that I never thought that I would be a family court judge in my life. You know, I think I'd rather pick up cans, but we don't have a family court judge here, and I've been placed in this situation. And I cannot draw orders, and this is not directed to you. I cannot draw orders that will be sufficient to keep people from deviating, harassing and bothering each other. It just can't happen. That, you know, people can glare at you from 100 feet. You know, it's kind of reminds me of the guy that went out was a little worried about the huddle at the football game because he thought everybody was talking about him in the huddle when he watched the thing. So I don't know what to tend. I do know from Mr. And I don't just tell it like it is. I do know from all the testimony I've heard about Mr. Moons down through the years, the multiple phone calls and all that, he's fully capable of trying to skirt and do this sort of thing. He's had this time period, but I think he's improved that from what I've seen, but I don't think he's completely beat that tendency yet. Now, you can make your argument if you want to, but I'm not interested much in the WKU thing. But what do you think about the carve out for the 50 feet? There doesn't appear to be one. What if she's there at the game and he comes to the game and he's supposed to sit on the other side away? And if they have a child, or what if he has a child there and she's at the game and doesn't have a child? He can't get out on the field then?
I think that's the nature of a IPO or a domestic violence order or a restraining order. I think that's the nature. There's nothing restraining her from doing anything.
Yeah.
He is restrained from doing that. And just from the testimony, her testimony was that he had no business being on that field. He is not a coach. He wasn't coaching. Doesn't have the ability to coach on the field. He was told not to be a coach this year. And the purpose of him being on the field, who knows? But he got within 30 feet of her, 27 feet of her, which is a direct violation of the existing order. And the other thing that I would, and you heard all the evidence, I know you're going to make the decision on this, but, and I just learned this the other day. He was arrested on a EPO violation. Part of his bond that he signed and he knew of was that he was not to be within 500 feet of her, according to the district court bond.
You know, that was before this.
It was before this one was entered. That's still an existing bond because they had court yesterday or the day before yesterday. It's a criminal case, but still there was he was violating a bond not to be within 500 feet. And he even was within 50 feet. And I agree with you. He's very capable of trying to stretch and push the boundaries of all this. And I think that's exactly what he has done. I would ask that the court at the very least take the DVO out of abeyance and enter the DVO to make it really clear what he is supposed to do and not supposed to do, and have the ability for an immediate arrest if there's a violation, as opposed to trying to gather the evidence and watching each other and coming into the court to try to convince what was going on. I think he very clearly has violated and had the intent to violate these orders on multiple occasions. And I think you should hold him in contempt or do that.
Judge, I don't think they've met their burden to show that he is willfully trying to violate this court's IPO.
Well, you don't have to willfully do something. I mean, you either violate it or don't. I mean, there's an admission that he was closer than 50 feet to her.
No, I don't think there's listed. I think that's what the officer testified.
I'm not talking about Western. You've won on the Western thing. Forget the Western thing. That doesn't bother me. I'm talking about they're not going to be at Western. Hopefully they're at Western next year at the finals of the regional tournament, and we have this problem to deal with, but I don't know whether that's gonna happen or not. Where it's gonna happen all the time are at the Little League field. It's gonna happen at the T-ball or the Little League or the high school baseball or the grade school. So he's got to stay 50 feet away from her. They're exactly right. He's exactly right about the burden that's put upon the person that has the EPO or an IPO in this situation. They don't have to they don't have to stay away, whether that's fair or not. They can move around wherever they want to, and the other person's got to avoid them if they've got it. And you and I both know that, whether we like it or not, and we see them misused sometimes. I've been to seminars or judges college, and I've never seen an EPO misused, or I've never seen a DVO misused. And you and I both know that they're misused all the time to get advantage in divorce cases and things. That doesn't seem to be the situation here.
But Judge, I guess that's the thing is at that particular Little League game, if his back is to her and he made all the steps he could to be as far away from her as he could, and she moves her
50
car.
feet is what it says.
But if
It
she
doesn't
moves-
say if his back's to her, if he's looking at her, it says 50 feet. And that's what I signed, okay? Now, that might mean he's gonna have to miss out on some things, and the child is gonna miss out on something, because whether you like a guy or don't like a guy, he has a lot of knowledge about every sport. You could invent a sport and give it to him. He could beat you at it in about 2 weeks. I mean, that's just the way it is. Okay, but he was in violation of this order that I do, and I'm gonna fine him $200, okay, for being in violation. Now, wait, I want both of y'all, you can go ahead and sit down. The issue is what are we gonna do up to this point? And I'm telling you, 50 feet is 50 feet. I'm not gonna expand it. And I'm going to replace I am supplanting the EPO with this order here that I'm doing. I'm supplanting. It's 50 feet. Now, in addition to that, I'm going to say that he should not harass her in any manner, should not follow her, should not stalk her. Those are going to be things of proof. I mean, it's not just distance. If he is caught stalking her, driving around, harassing her in any way, at any place, no matter what the distance is. I don't want him like calling in from an airplane that's flying over California and harassing her. No communications, no harassment, no notes, no anything, okay? And I want that drawn up, and I want that language. Now, is there any language that you would like added to that? No. Okay. I mean, it's gotta stop. It's got, I mean, it's gotta stop. I'm gonna put somebody in jail. You can go to jail for a long time for violating one of these things. And jail is not a place that we need to go to, okay? We don't need to go there, but I put people here every day. Yesterday, I guess it was yesterday, I was faced with terminated parental rights. Worst job that I've got, where I had 2 different cases where was on the edge of, and it's a sad thing that people put these children through. And I'm worried, hey, when I'm talking, ma'am, if you will pay attention to me, it'll get you a long way in here, okay? You talk to your lawyer after you leave here. You and I have an understanding about that?
Yes.
Okay. So the bottom line of it is I'm gonna continue. I'm gonna advance this divorce decree. And I'm gonna make some decision. Now, do you need any other proof about custody or anything that you want to put on?
Also, I think we have submitted all of the 18 hours of testimony. Both sides have submitted their proposed findings, and we're ready for your.
Are you ready for the
That's
decree?
great, Judge.
Okay, so we're gonna go ahead and put this as the top of our goal, is to sever this relationship forever. But it's gonna take some cooperation. And Mr. Moons, I'm gonna give you a fair warning. She don't want you around her. She don't want you looking at her. She don't want you doing anything with her. You got to accept that. I don't want a response from you now. And you got to be defensive about this thing. You got to stay 50 feet away from her and not bother her, okay? If you do, no matter what impulse you got, I see people come in here all the time that have impulses that they can't control. You got to control this. And ma'am, I don't want to, because I jumped you a little bit, I do not want to diminish your right to enforce this order. You have every right to seek the protection of this court. And I don't want you to be in any way diminish the fact that this court will protect you, because this court will protect you, okay? Now that finishes this case.
Judge, can I ask for one carve out that might be a suggestion? That when it's the particular party's time exercising the timeshare, that party be allowed to go to the game for the child?
They can go to the games, you just need to stay 50 feet away. He's not coaching this year, right?
He is coaching, that's the thing, is her testimony is completely contrary to what it actually is. He is still coaching, he's not
Is he a
been.
coach? Is he a coach?
Yes,
For what sport?
What sport?
I was thinking of baseball.
He's not a coach in that league over there. That's what the testimony was earlier. Now, he can take his child out and give him instructions on batting or whatever without being at that game. Now, I will tell you, as a very successful former T-ball coach, it's a tough thing to keep T-ball kids or coach pitch kids or any of that kind of stuff from going everywhere and playing in the dirt and doing everything. So I know, but it's just something that's gonna have to happen. 50 feet's gonna be enforced.
But I have one question. You
Okay.
had previously indicated that if you were in a gym and it could not be 50 feet away, that he's just saying your words were on the opposite side of the court. Does that remain in effect, or is it 50 feet no matter?
Well, I mean, I don't know whether you can sit on one side and, you know, I think that if they're in a gym somewhere like the Clinton County gym, I don't want to exclude this man from going to a game at the Clinton County gym. And I really don't think your client wants to keep him from watching his children play basketball. I don't think she wants to do that. She just wants him to stay the heck away from it. So if it's in a gym or something like that, then he needs to stay completely on the other side. He needs to not block any ingress or egress. He needs to stay completely on the other side, okay? And
One last question
Yeah.
about the exchange of the child. The existing orders haven't been followed.
they need to be followed. Existing orders. Do you want to moderate?
Judge, I think what we had agreed was that one of his family members would be there to exchange for one
We
time.
we actually named him because I remember his father being present. I remember his father being named and I didn't know who else was named. So if you want to change the names,
I would ask that any of his siblings
well,
or his parents.
I don't think you ought to do that. Okay, I think that unless she agrees to any of the siblings do it, or you agree, well, for any of his siblings to do it?
Two of the siblings testified against her in the case. We don't want.
Well,
that
they're
to
supposed to
occur.
testify against
I
her.
get it, but we don't want that.
Okay.
to occur.
Is that the way you feel, ma'am?
He's the
Okay.
one that suggested-
Okay, well, name the two that you want. Let's do three, okay, and see if she's agreeable to ones they name, okay? You got Mr. Moon's a father, was a previously, and who was the other one previously agreed?
Josh, his brother,
Josh.
it was his initial suggestion that we.
Okay, the two of those, now.
And then his mother, because
Well, I think the mother is too hostile to her and her view to allow that to happen. And her mother will protect her, this mother will protect her hens. This is a hen that will protect her chicks. I'm telling you, I've seen that, you know, so it's not acceptable. Her, so you got those two.
Judge Josh. She won't agree to Jenkins. Chris. We would ask for gingerbread. I think that's probably the other one that she would object.
Chris, okay.
Okay.
Okay, let's do the three then. Okay, those are three. And that ought to give you a good rotation, have people who can do it. Okay, well, that begins this matter. You're going to draft something and circulate it to Ms. Capps. Ms.
I can
Capps.
do that. Yes, sir.
Judge, in the event that, because this is a very active family with activities and things, could there be a member of her family that could exchange with Mr. Moons? Where they alternate some of it, because at this point,
I don't want to take up anything else. I've had all I can. I had all I can stand today. I can't take no more.
Thanks.
Okay, thank y'all very much. And the fine will be payable within 30 days.
no, you don't. He can't change your law.
Your Honor, that Mr. Carter and I briefly approached to update y'all Hazrowski case.
No, I'm sitting.
Well, let me see what else I've got here and then I'll do it. Okay, I've got Cole versus Gray.
Yes. That's a big part. When we're doing problems for Christmas.
Okay. Ray versus Scott. Okay, what do you got, Mr. Cross?
Your Honor, we tried to come to a complete agreement regarding the Kazarowski case. There were some there's a custody issue. We've got that resolved. And Nick's drafting an order. And I think that order is going to state we bring the rest of this up on motion of either party.
If that's phasing to the court, Judge, we'll schedule a property issue hearing if we can't resolve it amongst ourselves.
This is one where it was held jointly but she left for a year, he'd left for years with the guy.
They've been split for about 4 years.
Yeah.
What is the legal issue that keeps the property from being sold?
No, you're getting,
I get another, give me the fact.
this is not the Whetstone case.
Okay, this is not the
Okay.
Whetstone.
This is not the
Okay.
Whetstone.
Give me a short factual.
Separation agreement was entered about 4 or 5 years ago. I think they were both pro se. And there's part of it trying to be enforced by Mr. Cross's client. My client doesn't agree to it because he believes that other parts of it had not been enforced previously, and it makes that part now unfair. I think we'll in good faith work toward an agreement. In all likelihood, I believe we'll have to have you decide, Judge, at some point. But
Well, if y'all want to compare that portion of it, then we'll have a hearing on that, okay? If y'all want to draft something up to evidence that you got something, or you have enough agreement to draft anything?
we can draft a custody order and submit it to you if that pleases the
That'd
court.
be helpful.
Yeah, we're gonna try.
And then just put in there that the rest of it will be held in abeyance subject to additional proof being provided. Okay, thank you. Now, the next case, was Ray versus Cowett.
That one may take a while. I don't know if you want to take up your 2:30.
Well, let's bring it up here and hear just what it's about first.
Okay.
You're good.
I'm sorry. Find this for me.
Just like this.
Okay, what we got going here?
Your Honor, this was a, oh, I
Have
forgot
your
this.
mic on the outside of you. On the outside of it, okay.
This was a motion we had filed, I think, last month. My client, for approximately the first 5 years of the child's life, had fairly much sole physical custody. I don't think there's a custody order. She was arrested due to some issues with the that she had with the child. While that case was pending, there was a custody order agreed to by the parties that granted Ms. Cap's client primary custody, and my client essentially has alternating weekends. Since that time, the charges were dismissed. My client's situation has changed, and she's asking not to go back to the way it was where she had primary custody, but she was asking to get.
What were the charged crimes against the parties and our child?
Can you answer that for me?
Ms. Capps can answer.
Abandonment of a minor.
I think the gist, the young child got out of the home.
Yes,
Some
sir.
confusion without her presence.
Judge, I think that the allegations were the child was out of the home for numerous hours, and this was a child that was very young, under 2 or 3.
What's your position on what we need to hear evidence on, what needs to be done?
Of course, just to remind the court, the last time we were here, I think Ms. Cowan advised she did not smoke around the child, and then we had brought up there's 2 pending cabinet investigations, and then this child has come back since this order was entered with multiple cigarette burns. Has come back to my client after visiting with Ms. Cowan. So our position is that, I think their motion needs to be overruled. We have some concerns, and I've not filed any other motions to limit her
How
visitation.
long is this, what does the cabinet have going on?
They have first a physical abuse allegation that they're investigating where the child returned from a visit with serious bruises that the hospital reported. That started, I think, at the end of December. Since then, they've now gotten an investigation going with cigarette burn to the child's face right near the eye. And I've talked with the workers. Both of those cases are ongoing. One of them's here today.
And Your Honor, the case back at the end of December, we were made aware of that in court last month. The cigarette burn case, my client's cooperated fully with the client. She maintains it wasn't her that did that. The person who is responsible for that is here to testify to the court today. We're prepared to have a
Back in
hearing.
her home, but she didn't have anything.
It's during her time. I don't think it's actually at her home. The child's visiting her grandfather. And Judge, we don't,
How long has this order been in place,
The current order's only been in place since mid-June of last year, of 24.
So you're gonna show substantial change in her lifestyle. That's what your testimony is gonna be about.
Your Honor, I was gonna show that at the time that was signed, one, she was unrepped. Two, it was due to the fact that she was in a position where she didn't think she could fight it. You know, that case is no longer in existence and you know, the situation is in fact.
Was it just outright dismissed?
No, Judge, it was not. It was continued for 6 months to a year for her to work the cabinet plan.
No, it's criminal charge dismissed.
It was not outright dismissed. It was
We can
continued.
find out.
Yes.
Y'all want to get the file?
It was in Monroe County.
Well, call over there and get the file.
I don't know. I think a cabinet case did happen. She worked the case plan with the criminal charges.
And the criminal charge hung out there until she completed her case plan with the cabinet judge. Because the criminal charge happened in September and we were still fighting in court with the criminal charge pending when we came at the end of December of
What's your
23.
client's position gonna be when ultimately when this mother gets more visitation? What's the end game with this?
Judge, the end game is my client just wants his child to be
I
protected.
understand that, but what's it gonna take to get him to that comfort level?
I think it's gonna take time and the child not coming with multiple cigarette burns and the child, her being involved in getting medical treatment for the child. When he got custody of his child, the child had never seen a dentist.
I don't wanna retry all that again. I mean, that, you already got that order in place. Okay, I'm talking about what's the end game, how much is it gonna take?
I think we're gonna have to see some patterns change and behaviors of the mother change.
I really don't think you can present enough evidence, you know, to get that out there, but I'm gonna give you a chance to, you know, we'll do it right after we finish the one we're coming now. You got all the, are you ready
Everybody's
to
here.
hear evidence on that? Everybody's here. We'll hear evidence on that soon.
Okay, we're gonna guess what.
Okay, what does it say?
She was charged with abandonment of a minor on 9/12/23. That got amended down to endangering the welfare of a minor on 10/10/23. And then it got dismissed August 6 and 24.
Does it say any conditions on it?
So Judge, it was a pending charge for over a year. It didn't just get dismissed.
I just asked if there was a note on it. I'm not doubting, I'm just asking. There was a note on it. Sometimes there are notes. I always, you know, subpoena the county attorney or whoever handled it to testify about what the circumstance of it was. Okay, well, y'all just have a seat there. Okay. Now that gets us to I think Whole versus.
Yeah.
Whole versus Gray. Whole versus Gray. Whole versus Gray. Somebody get Mr. Cross back there. Can you help me find this one? I got it. Okay, gentlemen, have y'all tried to reach any accord on this today?
We're back there talking about it now, Your Honor. Mr. Little doesn't want to agree to pass it to try to pinpoint where a division could be. And all I want to do is have him pinpoint where he proposes it would be. Let my appraiser tell me what he thinks the house is worth and see if we can agree. We can't agree in the next.
You were supposed to have a appraisal.
Well, Your Honor, when you give me a 10-day deadline, and I realized after I left, it was almost impossible. And I tried to get a lot of work done on vacation, but people kept calling me at 4:30 in the morning, and it was just really tough to accomplish very much. So,
The way you settle that is you just don't answer.
well,
Okay.
That's correct.
Now, What do you have to say?
Well, Your Honor, before I became involved, before he became involved,
It was simpler before both of you.
probably so. They were not able to settle it. They're not able to settle it now. They're not able to buy each other out. They're not able to agree on division. She's proposed a division. And what she proposed is close to what Nathan Gross would testify to would be equitable. And there's no need to have another appraisal or another delay. If they don't agree under the case law I've researched, since they got the burden, and it's obvious they can't agree, there's no choice but to set.
You know me when I throw my hands up, and I'm ready to do that, but I'll refrain from doing that.
It could be in praise. Some people throw their hands up in praise.
Your Honor, it's not, nothing's been appraised. The big issue between these folks is what is the house really worth? And that's what we're trying to determine. Gary is, they've sent us a drawing, Gary sent us a drawing, he said, we will agree to divide it here, basically giving you 1/4 of the property in the house and giving her 3/4 of the property. That may be fair. That may not be fair,
Well, let me ask you this.
Yes.
What about dividing it that way and selling it in 2 parcels?
I think that would be something could work, but they got to agree on works.
They don't have to agree on anything. I can order a sale and sell it all, or they can agree upon selling it in 2 parcels. Once you consult with your client for.
Okay, explain.
They offered a division of the property.
Yes.
If we cannot determine that the equivalency of the value of the 2 things, we can sell it in 2 different parcels and determine what each one of them is.
That's the fairest. Let me talk to it.
Yeah.
Wisdom of Solomon. Occasionally, when it comes up, it's pretty good. Let me say.
If David sold theirs and we would sell on.
Go off the record. Let's go on the record. Parties have had time to consult. What do y'all think?
Your Honor, Mr. Cole would consent to the property being sold in 2 tracts, 1 tract including the house, 1 not. Parties would divide the proceeds equally. They would share the cost of the survey, which would be necessary, be a commissioner's sale, and just sell it and see what happens.
Are you saying a commissioner's sale or an agreed auction?
The commissioner's sale.
Wouldn't agree to.
Well, commissioner's sale is cheaper than an auction. It's cheap. And if y'all want to agree to some additional advertising between the parties, if they want to agree.
I think it'd be appropriate for some additional newspaper advertising.
Y'all can work with the commissioner on that. That way the advertising doesn't get out. I'm pretty much finished using real estate agents in division cases and forced sales. I'm pretty much finished with that. I mean, it just it's fraught with too much peril in my mind. I mean, that might be it might be an extraordinary thing sometime in the future. But I do think that the law allows for additional advertising if parties agree to it. So y'all might decide.
Would you agree additional advertisement?
And here's within reason, and here's what I'm saying. There are as many real estate agents out there looking to buy property for people as there are sell property.
That's true.
You know, so these real estate agents around here don't miss when these sunrises. So when this property gets advertised, there will be people that want property to buy here, and their agents will be looking at this property and out after it. So that's the fairness of it. That way, let whoever buys it and pay the cost.
All right, so, hard for me to hear folks, but we need to get it surveyed. We need to agree on the line. Would Derek Bell be acceptable?
Derek Bell is fine. He does a fine job. I commend him. Everything he really is the survey.
Anyway, and, you drafting the order?
I draft orders. I'll be a judge for order of sale.
You sent to me, mention the survey, and if you wish, I'll contact Derek survey, because it needs to be done before the sale.
It's on the list. It's fine.
And
Well,
it's gonna have to be close to the house like we specified.
well, we may have to go down there and look at it, okay? Yes, sir.
Well, look at it before he surveys.
Well, I mean, we'll have to go down there with Derek and look.
We all need to be down there, everybody needs to be down there when the survey is being done.
Okay, just guessing.
Yeah,
I'll
to show them where you want the line run, where you want the division line run,
Right.
you know.
Here, it really doesn't matter because we're gonna split the proceeds anyway. See what I'm saying?
Right, but.
Well, it would matter if one of the parties thinks that the other part of the property would be worth more if it didn't stick some of it with the house. That, the house property should have enough for a normal garden lot, garages, outbuildings, stuff like that. That's what you're saying, right?
We can work through that.
Okay,
Thank you, Your Honor. Please, that's all I have.
okay, thank y'all very much. When will I expect to see that over at Mr. Little's office? When will Mr. Little see that?
Oh, I'd say, probably by Monday or Tuesday.
Okay, that's good.
That would be good.
We want to get it done. Everybody wants to get it done.
Thank you, Judge.
We've got a busy day tomorrow. We'll knock her out.
Thank you, Judge.
Okay. Okay, now we got Ray working. Okay, we only have one case left now. That's Ray versus Calvin. And so we will get started on that. And Mr. Poindexter, you want to call us, this Mr. Poindexter. Mr. Carter, you want to call your first witness.
Your Honor, I would ask to invoke the rule.
How many witnesses do you have?
I have my client, 2 others.
Okay, how many witnesses do you have?
I have my client and 4 others, Judge.
Your Honor, I would first call.
Okay, but anybody that's gonna be a witness, you call your witnesses off and y'all enforce it with both sides.
I'm sorry, 3 others. Josh Ford, Benny Jeffrey Cohen, and Betty Sue Ford. My 3 witnesses.
Okay, y'all need to stay outside the courtroom until you're called upon. Are
Uh,
those side rooms comfortable or unbearable now or going out? I was talking to the bailiff.
Benny, you stay, I'm gonna call you first.
Okay, and who are your witnesses?
I have Jimmy Don Abney, Teresa Bishop, Michelle Ray. I've got also Lisa Corbin from Child Support. Hers will just be a very quick thing. And then I've
She can
got
stay in the courtroom.
Courtney Riddle from Social Services, the cabinet.
She can stay in the courtroom also. Okay, call your first witness.
Honor, I'll call Benny Jeffrey Cohen.
Okay, get comfortable in that seat there. Raise your right hand. Swear to testimony about gives the truth, whole truth, nothing but the truth.
Yes, sir.
Take a seat there and lean toward the microphone, your outside voice, and tell me your full name.
Do what, sir?
Lean toward the microphone, tell me your full name.
Benny Jeffrey Cowan.
Okay.
Mr. Cowan, what's your relationship to Lou Ann Cowan?
She's my daughter.
And recently, and I think you probably heard some testimony, just, or arguments a little bit a while ago about, a cigarette burn on this minor child.
Yes,
Did you
sir.
hear that? All right. Are you familiar with that situation?
Yes, sir, I am.
Can you just tell the court what happened in that incident and where you were and just give the exact details of what went down?
Okay, the day that happened, we had our grandchild, Paisley, over for the weekend.
Paisley?
Paisley.
And that's who we're here about today.
Yes, sir.
All right, go ahead.
And, she was getting ready to take her back to her father's house. So, I was sitting in the living room and she was in the back bathroom getting Paisley ready to take her back. She always gives her a bath and make sure she's clean before she takes her back. So anyway, I'm watching the Kentucky Wildcats play ball.
Let's not go into too much detail. Just tell me quickly what happened.
What happened when the cigarette burned the child?
Well, what happened was when the cigarette burn occasionally happened, she come walking through the hallway. She fumbled the phone. She fell over on top of me and I was smoking. Yes, I was. But there was no kids in the house when I was smoking.
Except for Paisley.
Except for Paisley. And she was in the back bathroom at the time I was smoking.
Okay.
I don't smoke around my children or grandchildren.
And do you, how often do you see Paisley?
I don't get to see Paisley much at all, except for when Luann gets her. Sometimes she brings her to the house, sometimes she don't. Since this has been going on, we've not got to keep Paisley not one night or 2 hours at a time. I'm a grandfather. I love my kids, my grandkids.
To your knowledge, is that the only time that anything like that has happened?
Yes, sir. For me, it is.
Have you taken steps to ensure that won't happen again?
Yes, sir. You know, from day one, when any of my grandbabies is ever born, brought home, or my grandchildren, you can ask just about anybody in my family. We don't smoke around the kids or grandbabies, and I force that law 100%.
Was a social worker involved in this case? Have you talked to a social worker about the cigarette burn?
Yes, sir, they was.
All right. Did they come to your house, or did you go to the cabinet, or how'd that go down?
They came to my house.
And how was that left with them? Are you under any kind of orders or restrictions?
Not that I know of. They had me on a 14-day thing, from what I understand, and that was lifted. From what I understand, I was told from Courtney that everybody's story matched up, you know, and that's pretty much it.
Have you witnessed your daughter, Luann, with Paisley?
Excuse me?
Have you witnessed Luann and Paisley interact?
Yes.
How would you describe Luann's parenting ability?
Luann is a real good mother. She's all the time doing activities with her, like anything like Easter, Christmas. She takes them places, sits and plays games with them, with her. Since Paisley's been gone, my daughter's just been not herself because, I mean, for the first 5 years, I mean, Paisley was totally in her life every day. The father was nowhere to be found for 5 years.
Since that time when Paisley visits Luann, you testified that you'd only seen the child a couple hours at a time. To your knowledge, does Luann exercise all her time herself?
Pretty much. She's got a boyfriend named Josh Ford, and he's been in Paisley's life ever since she was born. You know, Paisley's always called him daddy, you know, and the father actually of Paisley, she won't even call him father or daddy because she don't know him.
Is there any concerns you have over Luann's parenting ability?
No, sir, I do not.
Your Honor, nothing further at this time.
Inquire.
Mr. Cowan,
Yes, ma'am.
Are you aware that your granddaughter has come back with multiple burns from cigarettes besides this one?
Well, I can say this, Miss Angie. I've never burnt none of my grandkids on
That's not what I'm
purpose or
asking.
anything. Well, I'm just, if
You need
you,
to be responsive to the question.
okay, sir, I'm sorry. What was the question again then?
Are you aware that your granddaughter Paisley has come back from visits with Luann with multiple cigarette burns besides this one that you say was an accident?
They haven't been from me?
She's not asking you that question. She said, if you don't know, you don't know.
No, I don't know
You
that.
don't know. Okay, so you don't
This is
know
new,
about,
no, this is new on me from what I just heard.
so you don't know about the other cigarette?
No, I don't, because it was never reported that I know of.
And do you know about the bruising that Paisley came home from with?
I know about the bruising. That's what was told. But that was dismissed on Josh.
You know that Josh told that was tanning lotion and not bruises on that.
That's what it was, tanning lotion. They had got into some tanning lotion there at the house.
Have you seen the pictures?
Yes, I've seen the pictures.
Josh, the boyfriend.
Yes.
Yes, sir. Yes, sir.
Just want to get straight on.
Now, you can't testify as to Jacob's interactions with Paisley whenever Michelle Ray and Ricky had Paisley, can you?
You know, Ricky, what was the question again now?
Said you can't testify to Jacob's interactions when Paisley was with Ricky and Michelle Ray, can you?
They watched Paisley more than he did. He never was around.
You can't testify to that because you weren't there all those times, were you?
Sometimes I was,
You weren't there all the time, were you?
not all the time, but I was at times.
Now, and you're aware that that cigarette burn that was close to her eye, neither Luann or you or anybody on that side of the family took that child for treatment, did they?
We had a time to take her back. And Jacobs always told us, we was always threatened if we didn't bring her back at a certain time, that they would call the law on us. At that time when that happened, she was going back to her father's house. And just as soon as I seen that, I looked at that. It wasn't.
Again, my question is, you did not take her for any
No,
kind of
sir.
treatment.
No, ma'am. She wasn't took to the hospital.
And Luann did not take her for
How
any
could-
kind of treatment.
How could she? The father was demanding that she be brought home at a certain time. If not, we break a court order.
To your knowledge, Luann didn't demand that that child be taken for treatment at that moment either, did she?
No, ma'am, she did not.
Okay. Now, and you all did not actually message Jacob right then to tell him what had happened to Paisley's face when she got burned that time, did you?
We didn't have to because they warned us pretty quick that she had been burnt by a cigarette.
Okay, so they actually pointed it out to you all then through messages.
You know, they don't
Right.
give it.
Okay, that's all the questions I have, Judge.
Let me redirect.
No,
Y'all finish this witness.
yeah, I would ask them to keep it just in case.
Okay, you need, in case they recall, you need to go back through room again.
Okay, thanks, sir.
We call your next witness.
Your Honor, I call, my client, Luann County.
Pretty sure, and you swear the testimony documents the truth, whole truth, nothing but.
Yes, sir.
You need to lean toward the microphone with your outside voice, okay?
Okay.
Miss Cowan, am I saying your last name right, Cowan?
Yes, sir.
You're Paisley's mother.
Yes, sir.
Is that why we're here today?
Yes, sir.
To start with, what are you asking the court for today?
All I want is 50-50.
Are you
More-
asking, go ahead.
More time with my child. That's all I want.
And prior to the order of in 2024, I think it was, what was the custody situation?
Which one?
Prior to the order where Paisley went to live with Jacob,
Uh-huh.
how's the situation with Paisley, the custody situation?
Like when I get her or
Prior to that order, before that, where did Paisley live?
me?
Okay.
Yep.
And did she live with you all the time
Yes.
until last year sometime?
Yes, sir.
Okay. And currently, where do you live?
1017 Beautiful Home Road, Tompkinsville, Kentucky.
All right. Who do you live with?
Betty Sue Ford.
All right. Who's Betty Sue Ford?
My fiance's grandmother.
Okay. Who else lives in that home?
Cynthia Starlin, Cody Starlin.
Who are they?
That's Betty's other grandchildren. That's Cody's mom, Cynthia.
Okay.
And then me, Josh, Maggie, Kinsley, and Canaan.
Who's Maggie, Kinsley, and Canaan?
My other two kids,
All right. And who's their father?
Josh Ford.
So you and Josh have other children. Do you all have custody of those children?
Yes, sir.
And you said they live in the home with you.
Yes, sir.
Do they go to school or are they too young for that?
Kinsley's in Head Start.
Head Start?
Yes, sir.
Okay. And right now, I can't remember, are you working anywhere at the moment?
Not at the moment, no.
Okay. What's Josh do?
Landscaping.
And financially, do you and Josh have the means to care for Paisley?
Yes, sir.
And prior to the child moving in with,
Well, let's go into some detail. She says they do. She's not working.
okay,
How much does he make?
how much does Josh make?
$600 to $700 a week.
Okay, $700 a week. Okay. And do y'all have to pay rent there where you're at?
No, sir, we don't.
Are you all responsible right now for any of the utilities or bills?
Not right now, no.
Does the $600 or $700 a week, is that solely available for your all's needs and the children's needs?
Yes, sir.
Okay. And when you had Paisley before, were you living in the same location?
No, sir.
Okay, where were you all living then?
Rolling Acres Apartments in Tompkinsville, Kentucky.
How long have you been in a relationship with this guy?
7 years.
7 years.
Yes, sir.
How old's Paisley?
She's 6. She'll be 7 this year.
So you were in a relationship with him. He impregnated you?
Yeah.
And were you and Josh essentially raising all the children when you had Paisley?
What is that again?
Were you and him essentially raising all the children, including Paisley, when you had Paisley in your care?
Yes, sir.
And does he help you with Paisley now?
Yes, sir.
Were you there when this cigarette burn occurred?
Yes, I was.
All right. How many cigarette burns are you aware of?
1.
Can you heard your dad explain what happened?
Yes, sir.
Did you witness it?
Yes.
Do you believe your dad intentionally burned Paisley?
No, I do not. My dad would not burn her.
Has social services met with you regarding the cigarette burn?
Yes, sir.
Have you cooperated fully with social services?
Yes.
Have they placed any limitations on you?
No.
Are you familiar with a case that you've heard talked about from December?
The bruise.
I guess so.
Yeah.
All right. Have you cooperated with social services regarding that?
Yes, sir.
Have they placed any limitations on your visitation regarding that?
No.
Have they opened a case on you?
No, sir.
Have they took you to court in any manner?
No, sir.
Outside of denying visitation here today, has there been accusations against your parenting ability made by Jacob?
Not that I know of, no.
When you entered the agreed order last summer,
Mm-hmm.
why did you enter that agreed order?
I really don't know, honestly.
Were you represented by counsel?
No.
Was Jacob represented by counsel?
Yes, sir.
At the time you entered that order, was there a criminal case pending against you?
No, sir, I don't think so.
Okay. The criminal case, did you have a trial or something, or was it just dismissed to your knowledge?
Dismissed to my knowledge, that's all I know. Yes.
Okay.
When did the criminal charge come up, Mr. Clark? After this agreement?
Your Honor, I believe the criminal charge came up in the late fall of 23, and this agreement was entered sometime in 24. And in the case, I think Ms. Cap stated was dismissed in August 24. Have the other children ever been removed from your care?
Not other than when I had went to jail, Kinsley, they had placed her with my mother. And after all of it was dismissed, then they gave me her back. But I had Maggie in the home still. They only took Kinsley.
What did you go to jail for again?
Abandonment of a minor.
Going to,
What happened?
Okay, well, I had got up and Kinsley was not there, so I went outside hollering for, running for, hollering. And the cops come up there and told me, no, you're not getting your child. And then after that, they said I was going to jail.
And this is at Rolling Acres?
Yes, sir.
That apartment complex?
Yes,
So you woke up and she was not there?
yes, sir.
And how old was she at the time?
2.
And this was not Paisley that's subject to this case?
No, sir.
And where were your other children at the time?
Paisley was at school
Had you took a nap or been?
and
asleep
Maggie
for
was
the
with
night?
me. Yes.
Now, what time of day was it?
During 10:30, 11.
So you got that child back now?
Yes, sir.
To your knowledge, you've heard testimony of multiple cigarette burns. Are you aware of any more?
Not that I know of, no.
And prior to the day, were you accused of multiple cigarette burns or anything with this child?
Mm-mm.
Can you explain to the court, you said something about the lotion, there was talk about that, what happened there?
Her and Ariana, that's her little cousin. They was back in the back bedroom, and then they had gotten into Jasmine Paris, my niece's tanning lotion. And Paisley had come through there, and I said, and I was giving her, after that, I was going to give her a bath. So, saying it on her body. I said, Paisley, what is all that all over her body? And then she said tanning lotion. So that's what it was tanning lotion.
To your knowledge, was Paisley ever returned with bruises?
To me?
No, to Jacob.
Oh, no, no,
Okay. To your knowledge, did she ever get bruised up or injured in your care
no.
outside of the cigarette?
Well, unless it's a, accident, then no,
Okay. I mean, has there been some injuries to her that significant enough to report or anything like that?
no.
Do you feel like you're a capable mother?
Yes, sir.
What are some activities you do with Paisley?
We go outside, play ball, and make slime, go to the park and stuff like that, and go to Walmart and
Has Paisley, when she visits you, does she stay with you at the home where you reside?
yes,
Where does she sleep?
in her bedroom.
Is it her own room or does she share it with,
Kinsley
okay,
and Maggie, yes,
shares it with sisters?
yes.
Is there anything else you want to make the court aware of?
When I do get her, she does got all kind of bruises on her. When she does come into my care.
But are you here making accusations against Jacob today or just asking for time with your child?
Time with my child, that's all I'm at.
Nothing further at this time, Bill.
Steps you may inquire.
Miss Cowan, the other children that you got custody back, Josh is the father of those children, correct?
Yes, ma'am.
So the children were placed back in the home with you and Josh.
Yes,
And do you deny that you've sent Josh for exchanges and he doesn't have a valid driver's license?
my dad was with him actually,
Well, there was a time you sent him and he didn't
and
have
my
a valid
dad.
license,
And no, he's got a permit.
but he didn't have a valid driver's license.
No, ma'am.
And you don't have a car at this time, do you?
A what?
A car? Do you have a car of your own?
Yes, I've got a
You
car.
have a car, so you have a means of transportation?
Yes,
Now, you recall standing here in court and telling the judge the other day or last month that you didn't smoke around your children?
I don't.
Okay. I may approach the witness, Judge. You recognize that that's you and Josh in that picture?
No kids was around.
Okay. Do you recognize that's you and Paisley in that picture?
It was not lit.
I'm just asking, do you recognize
Yes,
that's
that
you and
does.
Paisley in that
Yes.
picture? And what's in your hand?
Cigarette.
Okay. Judge, I'd move to
It's not
introduce these
lit.
into the witness. It's an exhibit,
Mark them over here.
either one. I'll walk wherever you want me to.
Bailiff's gotten tired. Been had a long day.
And you said that you're not aware of any other cigarette burns other than the one to Paisley's face?
Nope.
Okay. I may approach, Judge. Luann, do you recall, an exchange between you and Jacob where he's asking you about a finger burn between Paisley's fingers being a blister that she said Josh?
I recall that, yes, ma'am.
Okay.
Yes.
So now you do recall at least another cigarette burn?
Yes, ma'am.
Okay. Move to introduce those.
And can I say something?
Text message exchanges.
You'll get an opportunity, you're.
Okay.
As a matter of fact, so I can keep things straight, right now might not be a bad time to let her explain that cigarette burn. She said never exists. Go ahead.
The one that
One
she said.
between the fingers.
What is that?
The cigarette burn that she just showed you the picture of that was between your child's finger.
Oh, I wasn't saying nothing about that burn, no. But they smoke around her also.
I'm asking you, did that happen at your house?
No, it was not at my house, no.
Where did it,
My grandfather's.
the second burn?
Yes.
So do you, now you do remember two separate burns.
Now that I do, yes.
Go ahead.
So, gonna ask you if you recognize a conversation, does that appear to be from you?
Well, yeah.
Okay. And does that appear you talking about her hitting your mom's cigarette?
Yes.
Okay.
That's not got nothing to do with me.
And that was a burn to her arm, right?
Yeah, but that's got nothing to do with me, though.
Right. Judge, I would
I
like
did
at
not
this
do
time
that.
to introduce.
The objection. Number three. Where does your mom live?
19 on Gray Gap Road in Burkesville, Kentucky.
With your dad?
Yes.
Now, Ms. Callan, it's gonna show you some pictures. Do you recognize those as pictures of the cigarette burn that happened to the face that you weren't aware of?
Yes.
Okay, but in these text message exchanges, you don't advise Mr. Ray of what happened to Paisley, do you? He actually has to ask you what happened to your child's face. That's what that message says, correct?
Yeah.
And for none of these instances, you did not take Paisley to get any kind of medical treatment.
No,
did you?
because I gave her medical treatment at home.
Let me see those.
And I would move to introduce these with the corresponding message exchanges, Judge.
Now, y'all might not ever accomplish anything else in life, but you made one pretty little baby right there. That's a beautiful child.
Thank you.
Now, during the time that she got the burn to her face, did she also get some injuries to her nose?
Her nose.
Mm-hmm. And other parts of her face on a different occasion?
That was when we took her on a vacation to Columbia, and we was staying at Cozy Haven, and them cabin rails, she had bent down when she was trying to get the cat, bent down and hit the rail.
Okay.
That's
But-
what happened there.
So you.
And
know
I
those
did let her know.
That's what I started saying, but in that instance, you
Yeah.
did let him know.
Yeah.
But that was the same weekend that she got burned as well, right?
No.
No, different.
No.
Judge, I would move to introduce those.
No objection.
I'm gonna show you some pictures. Appears to be like the side of your child's buttocks and up around the kidney area on the back. And those are the ones that you've just testified that you say is tanning lotion.
Yes, ma'am.
Right. But do you deny that in this you acknowledge that there are bruises in your conversations?
That came from that when I had got them from her, yes. Got her from them.
You're actually the one that brought up that Josh didn't do anything to her, right? In these
Yeah, he
messages.
didn't.
And he actually got on your message and messaged Mr. Ray that that was tanning lotion, correct?
I don't know. Yes.
Okay. Judge, I would move to introduce all these into the record.
No objections.
I try to get pictures of the messages that he can. Ms. Cowan, you testified that basically that your child had just gotten out of the apartment and that's when the police showed up, right?
Mm-hmm.
I'm gonna show you a copy of the police report. If you would just read that for me. Let me know when you're finished reading.
This is a sibling, correct? Is it correct?
That's correct. The 2-year-old sibling.
Well, just go ahead and ask her the question to save some time.
Just to make sure she had a chance to refresh herself. So that citation was cited at 1:40 PM, correct?
Mm-hmm.
Okay. And you gave him a statement that you actually had left somebody else in charge of your child and that there were text messages, but the officer indicates he spoke to that person and they were not aware of that, doesn't he?
Yes, but she lied.
Okay. And he also notes that there were.
Who lied?
Lacey Strode.
Is that who you were saying now that you left the child? and
Yes.
took care of it a few minutes ago, you said you took a nap, you didn't mention her, right?
Correct, Judge.
Yeah,
Yeah,
but
just making
okay.
sure, just making sure.
So Judge, I would just move to introduce this. into the
Not
record.
missing.
Thank you, Your Honor.
Now, Ms. Cowan, you were ordered to pay child support beginning effective July the 1st of last year,
Mhm.
correct? And you did not make a payment for your child and child support until January of this year, did you?
Yes.
And you've only made 2 voluntary payments since June of last year, correct?
Mm-hmm.
And you admit that you're not happy about having to pay child support and you try to direct Jacob how he's supposed to spend that money, don't you?
Well, he did me.
I'm not
The year
asking
he
you.
paid it.
You told him that he had to give that money to Paisley and let her spend it, didn't you?
I mean, he's supposed to spend it on her, yes.
Is that a text message where you're telling him that he has to give that money to her so he
I
can
don't
take her
really think
shopping?
that's relevant, so let's move on.
Judge, I do think it's relevant
I'm
because
ruling it's not relevant.
I just moved to introduce that.
Overruled.
And at times of exchanges, you have called the police to try to keep them from letting his mother pick up Paisley when he was.
Yeah,
on
because
vacation.
he hasn't picked her up once.
But you've had other family members of yours pick her up, correct?
Twice. That's it, twice.
But you've always got family with you when you go for the exchange.
Not always, no.
For the majority of the time you do, don't you?
Yeah, because I'm scared, yeah.
And you don't have the ability to provide your own shelter for this child, do you?
I'm looking currently, and yes, I'll be getting a home.
So right now, you're subject to as long as, if something were to happen between you and Josh, you might not have anywhere else to
Oh, no,
live.
I got a place to go, yes.
There's
You're
no
living-
worries
Right
there.
now, you're living with his grandmother,
Mm-hmm.
and he's your only source of income, correct?
Yes.
No further questions, Judge.
I'll briefly redirect y'all. Josh, that she just asked you about that you financially depend on. Are you all engaged?
No.
Okay. Y'all have children together?
Yes.
And have you all been together since you've had those children?
Yes.
You all are raising those children together in the same household?
Yes.
Yeah. Did I understand your testimony earlier that you all were together since before Paisley was born?
No.
Okay.
That's what I misunderstood. Yeah.
Okay.
No.
When did y'all start dating?
When Paisley was 3 months old, that's when.
Okay.
Yes.
How are you addressing?
I don't understand this testimony. I asked her if this gentleman here impregnated her while she was dating Josh, and she said yes. Now she's changed that testimony.
I misunderstood, sir.
Clear it up for the judge, please.
Huh?
Just clear it up for the judge so he knows.
Well, me and Josh got together when she was 3 months old. That's when. But no, we was not together when I got impregnated, no.
Are all your children younger than this child?
Yes.
So you had these children with Josh after Paisley?
Yes.
All of them?
Yes.
Thank you, Ron. How are you addressing this cigarette burn issue?
How am I addressing it?
Yes. What steps are you taking to ensure this doesn't happen?
Going outside and, I told Paisley, like, look, I'm going to smoke outside, go
Have
play.
you ever thought about quitting smoking?
Yes, I've tried. It's
Thought
not
about
easy.
that? Yeah.
Yes.
It's not easy for children to get burned or have inhalation here, but you're not willing to sacrifice not smoking to be around your child? Go ahead.
And clarify for the court, the Lacey Strode watching your child situation, what happened?
Earlier that
today?
morning, I had asked her, and she told me, yeah. And then
In your home or outside your home, or where was she?
at her
watching?
house.
Okay.
Yes, at her house, sir.
Uh,
And I had fell asleep, and that's when Kinsley had to get out the door. And my doors was closed, so I don't know. And there was no chairs, nothing. So I don't know how she got out that door.
Okay. At the time, did you have a belief that child was with Lacey Strode?
Yes.
Is there anything else about that particular incident you want to explain to the court?
No, sir.
As far as bumps and bruises go, did any of those occur due to carelessness or lack of paying attention to Paisley?
No, sir.
Do you believe they're consistent with normal bumps and bruises children get?
Yeah.
No further questions at this time, Judge.
You have any other questions?
Luann, you had never taken Paisley to the dentist until Jacob got custody.
Yes, I did, because I had her orthodontic appointment.
Who was the orthodontist you took him to?
Dr. Allen.
Were you aware that she had cavities?
Well, actually, I got put in jail, so.
But at the time she was.
Yeah, and that's why she had that appointment to go see
She was
Dr.
in
Allen.
Head Start at the time you got put in jail, right? Or kindergarten?
What is that?
Paisley was in Head Start or kindergarten at the time you got put in jail, right?
Kindergarten.
Kindergarten. Okay.
Yes.
So she was in kindergarten,
Mm-hmm.
and up until that point, you had not taken her for cavity treatment, had you?
I mean, I found out she had cavities. That's why she was going to Bowling Green.
How did you find out she had cavities?
How?
How did you find out?
Dr. Stevens.
So you took her to the dentist?
Yes,
Dr.
sir.
Stevens.
Yes.
So you did take her to the dentist?
Yes.
Before you were going to take her to the orthodontist?
Yeah.
Which Dr. Stevens?
John Stevens.
The Dr. John Stevens that doesn't see children, right?
No, he sees children.
Okay. And you didn't take Paisley for any type of vision exam either, did you?
No, ma'am.
Okay. So you've got a child that's in kindergarten and she hadn't had a vision screening. And you didn't take Paisley for any medical treatment regarding any of these burns?
No, because I took care of them at home.
No further questions, Jim.
You have anything else?
No, Your Honor.
Okay, call your next witness.
Your Honor, I would call Betty Sue Ford.
Betty Sue Ford. Betty Sue Ford.
Well, Betty.
You raise your right hand, ma'am. You swear the testimony you about to give is the truth, whole truth, nothing but the truth. Lower your hand. Lean toward that red microphone in front of you there and state your full name.
Betty Sue Ford.
Ms. Ford, can you tell the court your relationship with Lou Ann Cowan? How do you know her?
Well, I call her my granddaughter because she's with Josh,
All right, and who's Josh?
my grandson.
When you say she's with him, that means they're dating, right?
They live together.
Okay. And do they live in the home you own?
Yes.
And who all lives in that home?
Me and Josh and Luann and the 3 kids.
And do you have a deadline for them to get out by?
No.
Are you content with them staying there as long as they need to?
As long as they need to, yes.
Is it, there any issues or problems that you have with all them living in your home right now?
No.
Do you assist them every once in a while with the children?
Yes.
Do you help babysit, so to speak?
So to speak.
Okay.
I can't lift them and I can't
Okay.
run after them,
Right.
but I watch them for them time to time, go to the store, whatever.
Have you seen Lou Ann with her children?
Every day.
Can you describe her and what you see as a parent, how you see her interact with those children?
She's a good mother. She gets up every morning. She gets Kenzie ready for daycare. Well, Head Start. She takes her to Head Start. She comes back. She feeds the other 2. They're bathed every day. They go out and play. She plays games with them in the floor.
Would you describe her as involved?
Yeah.
Is there any character issues you see that give you concern with her parenting ability?
No.
Does she provide all the basic essentials for these children?
Yes, sir.
And do you have any reason to believe that they would have to leave your home based off your wishes or anything like that?
No.
The court could rely on the fact that they could stay with you until they get their own place. Is that fair? Is there anything else you would want to tell the court regarding Lou Ann's parenting ability or Lou Ann with her children?
No, she's a good mama.
And I know Josh is, go ahead.
Them kids love their mama.
And Josh is not Paisley's father, but do you see him interact with the children?
Every day.
Can you describe his parenting ability?
He's a good daddy. He's a real good daddy.
What makes you say that? What's he do?
Well, every day when he gets home from work, he's down in the floor playing with them. He's taking them out and they're riding their bikes, or or if Luann doesn't get one of the kids bathed, he'll give her the bath. I mean, he helps her with the kids.
And does Josh work?
Yes.
About how much is he going to work?
Well, he leaves around 8 every morning. He gets home sometimes 5, 4. It depends.
Standard 40-hour week?
Yes.
Um, does all the children have a place to sleep at your home?
Yes. They each have their own bed.
I appreciate your time. You may have to answer some questions for the other attorney.
All right.
Yes.
Afternoon, Ms. Gold.
Good afternoon.
How many bedrooms and baths do you have in your home?
I have 3 bedrooms, 1 bath.
Okay. And how many people live in your home?
Well, the 3 kids and Josh and Luann and myself.
And you don't have, is there a Cody and somebody else that lives? there?
Cody's my grandson,
Okay. And how old is Cody?
17.
And does he live there with his girlfriend also?
No, he doesn't have a
Oh, he
girlfriend.
doesn't have a girlfriend? I thought that's
No.
some testimony. Let me check the name real quick.
He's in high school and baseball. He didn't have time for girlfriend.
Cynthia. Who's a Cynthia?
Cindy's my daughter.
Cindy's your daughter, okay? And how old is she?
How old is she?
Yeah,
53.
okay. So it's been a long day for me. Do the math if you can with all those people, because you didn't name them first. Who all is living in?
Asked them if they live there.
Well, do they live there?
Yes.
Okay. So just count for me exactly how many people are living in your home with you.
8.
And do you have a significant other or a husband that lives in the home with you?
My husband passed away over a year ago.
Oh, I'm sorry about that. Now, do you sometimes have to assist Josh and Luann financially? Besides providing a roof over their head, do you have to help them?
Well, they might need $5 or $10 or something, but yeah, other than that, no.
And do you pay all the utilities there at the house?
Me and my daughter.
Okay. And do you help assist them with transportation? Like, do you provide them with a car or anything like that?
She might use my car in the mornings to take the baby to Head Start. But it's only about 5 minutes down the road.
Does Luann have a car of her own?
Yes, she does.
And if, to be frank, if her and Josh were not together, would you allow Luann to continue to live in your home?
Yeah.
So even if they weren't together?
He
the
would have to go,
relationship
but no, I wouldn't kick her in the baby's out. My family.
So you would continue to let her live there if they were not together?
Yes.
All right. That's all I have.
You want me to redirect?
No.
This witness be released, ma'am. You can go back and sit in the courtroom if you want to stay in here.
Okay, thank you.
Call your next witness.
Josh Ford.
Josh Ford. Raise your right hand, please swear the testimony you got to give strict no truth, nothing.
Yes, sir.
Take a seat there, I need to order the ready microphone, if you're outside the voice of those, what's your name?
My name is Joshua Everett Ford.
Josh, do you currently date, for lack of a better word, Miss Luann Cohen?
Yes,
And do you all reside together at your grandmother's house?
yes, sir.
And your all's minor children live there with you all too, is that correct?
Yes, sir.
What is it you do for a living, Josh?
I do landscaping and construction work for Eric Pitcock.
Eric Pitcock?
Yes, sir. And he's a preacher.
And how long have you been working for Eric?
2 years.
And about, what kind of income do you make working?
About 600 to 700 a week, depending on the job.
Okay. Is it a salary or just kind of based on the work?
Kind of based on the job.
About how many hours do you work a week?
50 to 60, easy.
And you raise, how many children do you and Miss Cohen have together?
3.
And what's their ages?
Kinsley is 4, Magnolia is 2, and our newest son, Kanan, is 8 months.
Are you comfortable leaving those children in Lou Ann's care when you're not there?
Most definitely.
Can you describe, how you see her interact with these children?
Luann's a great mother. While I'm at work, they call me, telling me how good they are. They get baths from her. They're fed constantly. I mean, they're very healthy children. She plays with them. They take pictures. I mean, all the pictures we have with our kids, they're happy. So,
Are you also pretty involved with the children?
yes, sir.
Do you feel like you're a capable father?
Yes, sir.
Do you have a relationship at all with Paisley?
Yes, sir.
Can you describe your interactions?
She is
with
the one
Paisley?
that actually wanted me to have kids in the first place. When I first met Paisley, she was about 4 or 5 months old, and I did not want kids at first. And then when I started raising her as my own, I fell in love with that little girl.
And at the time that Lou Ann got arrested, were you and her dating?
Yes, sir.
Were y'all living together at that time?
Yes, sir.
Were you at work when all that
Yes,
went
sir.
down? Did that affect your relationship with your all's children that you all have together?
It hurt my children a lot. They lost their sister.
And did you all have to take steps to ensure your parenting ability with social services when all that went down?
Yes, sir. They made us take precautions so this wouldn't happen again.
Did you learn from that experience?
Yes, sir.
Did you take classes and things like that, or what had to happen?
Well, as far as me, they had me. I didn't have to take no classes or nothing like that. Luann was the only one that had to do that.
To your knowledge, has she completed everything?
Yes, sir.
Is there any restrictions on her with any of her children?
No, sir.
When Paisley is at your home, does she interact with other children?
Oh, most definitely. That's their big sister. Yes, she plays with all my kids.
Does she interact with your family?
Yes, sir.
Your grandmother?
Yeah.
Your mother?
Yes, yes, sir.
Fair to say she fits right in.
Oh, yeah. She ain't no different than my other kids.
There's some. Backtrack. Are you familiar with some accusations or discussions via text message regarding bruises?
Yeah.
Can you tell the court about those alleged bruises and what happened to your mom?
Okay, so I was at work and I had got a call from Luann saying that the social services wanted to talk to me about the bruises, and I had no knowledge of any bruises. The only thing that I knew when Paisley did go back to Jacobs that she had gotten some tan lotion from her grandmother, and that's what apparently they thought was bruises.
And
But I don't even whoop my own children.
in your experience as a father, the kids get bruises?
Oh, well, yes.
They get bruises innocently?
Yeah, I mean, they fall all the time. I mean.
And about how old would Paisley have been when this occurred? 5, 6?
Yeah, about that. 5. Yeah.
Okay. When that occurred, did social services investigate the situation?
Yes, sir.
Did they place you under any restrictions?
Nope.
They make you do any classes?
Nope.
They limit your time with any children?
Nope.
Are you familiar with the cigarette burn situation?
I was there. Yeah.
To the best of your ability, have you all fully cooperated with social services about that?
Yes, sir.
Did they investigate that issue?
Yes, sir. They was there this Monday.
Have they placed you all under any restrictions regarding that?
Nope. The supervision of Jeff was lifted actually this Monday.
Are you comfortable if the court does order Paisley to be in your home more than she currently is?
Yeah, I want her back home more than she is now.
Is there anything else you want to make the court aware of?
No, just that. I mean, Paisley has suffered enough, and this is enough. I mean, these families need to get along and let this little girl have a life instead of fighting this in court.
Thank you very much. You may have more questions.
Oh.
Well, Mr. Ford, you said you were aware of the cigarette burn. Are you aware of the multiple cigarette burns?
No, I'm only aware of this one.
Which one are you aware of?
The one that was on her face.
Face. So you're not aware of the one where Lou Ann was discussing about Paisley running into a cigarette of yours with it burning between her fingers?
No, I don't recollect that, no.
And are you aware of cigarette burns that Paisley had to her arm?
No, it wasn't from us, no.
Even though Lou Ann has sent messages acknowledging it happened while she was.
And do you have the
she had Paisley.
messages?
I actually do, yes.
Oh, okay. Well, I don't know about them, no.
So you don't dispute if Luann sent messages to Jacob explaining these cigarette burns that,
Well, the thing is I don't get in their personal business because this is between their two children and I provide for Paisley, but as far as them talking between themselves, that is between them.
but you're here today to testify
Yes, ma'am.
in their personal business.
Oh, because I'm here. Yeah, I have to.
And during that time when Luann went to jail for abandonment of a minor, you were actually required to supervise any interaction she had with your children for a time period, weren't you?
She was at her mother's for 4 months, I think. Yeah.
So there were some restrictions in place about her ability to parent her children.
No, just no. As far as I didn't see no problem with it. Everybody makes mistakes, and she paid greatly for this. She lost a child because of it.
She has joint custody of her child, doesn't she?
But why is she paying child support if they have joint custody?
And that's one of the issues that you all are not happy about, isn't it? That she's
I
paying
don't have a
child support.
problem providing for my child. I just don't think I should have to pay for a child that I raised. Cause as a man, I never told Jacob that, you need to pay me child support or there's gonna be consequences.
But you're aware that Jacob was paying child support to Luann when she had Paisley.
As far as I know.
No further questions.
No regulation.
You may be excused, you extend the court. Call your next witness.
Judge, I would ask him to be subject to recall.
Okay, you can back out to the room and wait in case you get called back.
I have no more witnesses.
Okay, do you have any witnesses? You don't?
I do, Judge. I would like to call Jacob Ray.
You raise your right hand, please. You swear the testimony about gives the truth, full truth, and nothing but the truth.
Yes, sir.
Have a seat. Lean toward the red microphone, state your point.
Jacob Austin Ray.
And Jacob, you're the same person that is the biological father of Paisley,
Yes, ma'am.
okay? And did you go through paternity testing to prove that?
Yes, ma'am.
Now, you've heard Ms. Cowan's testimony that you were not involved in this child's life up until September of 2023. Is that accurate?
No,
All right. How long have you been involved in Paisley's life?
from the beginning, and a lot of it was with my father because she would allow my father to keep her, and then I would see her there with my father.
When Paisley was born, were you experiencing financial difficulties?
No, ma'am.
Okay. Did you have the means, I guess, to go and hire an attorney and to fight this action in court?
I was young, and no, not really, because I was young.
So at that time, did you let Luann kind of dictate when you got to have Paisley, when your involvement was with her?
Yes, ma'am.
All right, so you said that with your dad, what did you do as far as getting to see Paisley since she was born?
I would go, and get food for her and stuff when she was at dad's, and and just take care of her. And then I paid child support, and then there would be times that they would text needing extra stuff, and we would ensure that they would get any extra that they needed. Like if she needed pull-ups or anything like that, we'd ensure that she got that.
So you have been involved in trying to financially
Yes.
care for your child.
Yes,
Now, you got temporary custody of Paisley back in 2023.
yes.
When you got custody of Paisley, how did she appear? Or tell us about the circumstances, what you had to go through to pick her up at school.
When I went to school to pick her up, I asked to get Paisley Cowan, which is her legal name. And then the principal, not a teacher, the principal come out and was very stunned and shocked and very tore up that her.
Your side and your elements.
I'm just asking, was Paisley Cowan registered?
Impression.
No, Paisley was not registered as Paisley Cowan. She was registered as Paisley Ford.
And that was after you had had your paternity test?
Yes.
Okay. And when you checked with the school, were you listed there to be
No.
able to get any information or anything?
No, ma'am.
Did you have to have law enforcement to go with you so that you all could try to get information about your child?
Yes, ma'am.
All right, at some point you were able to get her physically with you.
Yes.
When you got her, What was her physical condition as far as her hygiene and anything you noticed about her?
She didn't have a shirt on. She had pants and she was very, very, very skinny.
And so did that prompt you to be concerned about the well-being of your child?
Yes, ma'am.
Did you do anything as far as taking steps to get your child examined and to have any checkups done to see what her health was like?
Yes, and that's when we started going through the process, because when we took her down to the school, that's when we'd found out that she had not had any of the stuff she needed, like going to the eye doctor. And then when we got notified about her dental, I mean, it was just thing after thing. It just kept laying out and laying out in front of us. So yes, when we first got her, that's when we had to start bringing her health back up.
Okay, so when you first got her, you found out she had not been to a dentist?
Yes,
You found out she had not been and had her vision checked?
yes,
When you got her vision checked, what were the results?
that she had to have glasses.
Is she still having to do some things or having some problems with her vision because of that?
I'm not for sure. I mean, we need to do another checkup on her.
Okay.
That's for sure.
And did you go about trying to find out if she had seen a pediatrician or anybody?
Yes, and then when we went to find that out, we'd figured out that she hadn't ever even seen a pediatrician. She had seen the one in Glasgow. It was like that follow-up checkup when you first have a child. And that's all that I know of.
So did you go and ask for copies of records and ask to
Yes.
see her records?
Yes,
And in her medical records, you found that she had not had any other follow-ups after
that's
that?
correct.
And have you continued to make efforts to try to co-parent with Luann?
I do. And the past, since we started court, well, since about the past 2 weeks, she has talked to me in more respect than she ever has ever. But before this, you couldn't, because she always wanted to pick a fight. Everything was a fight. It was, and you would ask simple questions and then she'd automatically go to defense mode. Just like that. Just want to start an argument. And I'm not doing that. I'm not arguing.
And we've raised the issue of child support here. And don't testify what Paisley said to you, but has your child come into the home and brought up child support to you?
Yes, ma'am.
And then at that point, did you try to have conversations with Luann about why is your 5 and 6-year-old asking you about child support?
No, I haven't. I've left it be.
Okay. Did Luann have conversations with you about child support?
Yes, yes, she has.
And what was she telling you?
She was telling me how I needed to spend the money and that it was her money.
Now, going back to the dental visit, when you took Paisley for her dental exam, what were the results?
She had 16 bad teeth and quite a few that had to be removed, and she had to be put to sleep for this procedure. It was that bad that he couldn't just do it over time. He had to do it at one time. She has crowns, caps, a bunch of missing teeth. It was bad. And then I was indicated pain. She would tell me pain, stuff like that was coming from her mouth. So we had to get it done quick.
And is she still seeing or getting treatment for those dental?
Not now,
Procedures not
no,
now?
she has a perfect mouth. We go to Dr. Miller in Edmonton and she goes for a cleaning. She don't have to have cavity work done now because it's all done. And her teeth are perfectly healthy.
Now, when you got Paisley, she was in kindergarten, right?
Yes, ma'am.
When you went to Monroe County, did you find out there were any issues about Paisley's attending school?
Yes, they was showing me that she hadn't went half the time that she'd been enrolled there, and it was a short window. I mean, I forget exactly because how long it's been, the window, but it was short, and she hadn't been to school hardly at all in that short window. She was there.
And then when you got her started, you started her here in Cumberland County?
Yes,
in
ma'am.
school. Did she have difficulty keeping up with children of her same age when she started here in Cumberland County?
Yes, ma'am.
What all did you all have to do to get her caught up to where she's at now?
We worked with her hard and effortlessly. And then at the end of the year, the teacher recommended we hold her back because where she hadn't had good help with schooling. And then she had to repeat kindergarten again. And now she's excelling and graduating and good to go.
So she had to do kindergarten all
Yes,
over again
ma'am.
because she was behind?
Yes, ma'am.
Do you have concerns about Paisley when she's in Luann's care?
Yes.
And why so? Other
Because-
than what we've already presented today?
I don't know where she lives. I don't know where she's at. They're constantly going up down the road. they've been times that people have come to me and told me that she's riding in the front seat of a vehicle, and we all here know that that's not how that's supposed to be. A child should never be in front of a vehicle. Regardless, seatbelt, no seatbelt, it don't, I wouldn't want to put my child there as the airbag.
Each time that your child has come back with these cigarette burns,
Yes.
did Luann notify you beforehand?
No,
So how did she become aware of it?
I'd have to text and ask.
And did she ever, to your knowledge, advise that she had done anything to treat those cigarette burns?
No, ma'am.
When you picked your child up and she had those burns, did she have any bandages or creams on those?
No.
Did you have to take her for medical treatment?
Yes,
for
ma'am.
those?
Yes, ma'am.
And did you have to have medication that was prescribed?
Yes, saline, and we'd have to keep it bandaged and wrapped, that one on her hand and on her face, same thing, an antibiotic ointment. You have to keep that on there.
Have you had any times that Paisley has gotten burned by a cigarette while she's in your care?
No, ma'am.
Do you think that it would be in Paisley's best interest, giving all this information and the condition that she was in when she came to you, for Luann to have more time?
No, ma'am.
Are you concerned about Luann not being monitored when she has Paisley for the time she has now?
Yes, ma'am.
And to your understanding, is there still ongoing cabinet investigations?
Yes, ma'am.
I don't have any questions this time, Judge.
What would the cabinet investigation be about? What would the cabinet investigation that you're aware of be about?
The cigarette burn to her face, that one there, and then the bruising that is on her, that one's open. And I think all the rest of them are closed, but I think those two that are more.
Mr. Ray, I'm Nick Carter here on behalf of Luann Cowan. You stated that you treated these burns. Where did you take her for treatment at?
Cumberland County Hospital.
Do you have any of those records?
I think so.
I think I provided those to you in the stuff I sent you. Copy if you want it.
And a couple of things I just want to touch on briefly.
Yes, sir.
You're saying that you found out that this child had not been to a pediatrician.
Yes, sir.
And how do you know that she had not been to a pediatrician?
Because the school started getting, where they give us a time limit that we had to have some stuff turned in.
Which school? I'm sorry.
Cumberland County here.
So this is after you got her to Cumberland
Yep,
County?
Yep.
Okay.
This is when we was, and then we asked her what her pediatrician was, and she told me some Vicky or something, and we went up there and they didn't have a shot record or anything.
Did you follow up with Luann when they didn't have a shot record or anything?
I'm not for sure. I don't believe so.
So did you follow up with her about any kind of dental records or vision records?
Yeah, and then that's when I knew something about Barbie Dental. I heard something about Barbie Dental, and we went up there, and we got up there and she'd already missed 3 prior appointments or something another. And then they wasn't gonna accept her. And we finally got her, I talked to the dentist myself and convinced him to please one more time. And he did.
So just briefly, you got this child in September.
Yep.
So she had only been going to kindergarten for a matter of weeks at that moment, at that time.
Yeah, and then she'd missed most of it.
Okay. And you're telling me that when you got this child in September and you transferred to Cumberland County Schools in that September,
yes, sir,
that come May, she was still so far behind from that 1 month that she had to do school over?
Yeah, because she never got to go to Head Start.
Okay. No further questions this time, Judge.
Can you redirect?
No, Judge.
Turn your seat. You have another witness?
I would call Lisa Corbin with the Child Support Office.
Lisa Corbin. Raise your right hand. You swear the testimony about to give us the truth, the whole truth, and nothing.
Yes, I do.
Take a seat, lean toward the red microphone there. Tell us in your outside voice your name and with whom you're employed.
My name is Lisa Corbin. I'm an employee of the Cumberland County Child Support Office, Cumberland County Attorney's Office.
And Ms. Corbin, have you been in that position for a number of years?
Yes,
And as part of your job duties, do you work with parents when there's child support obligations?
yes,
And do you have a system where you keep track of payments that come in and the
Yes.
timeframes and court orders when it's ordered?
Yes, we do.
All right, if you would you tell us, when was Luann Callan ordered to start paying child support?
She was ordered, the order was entered the 21st of November 24, but her payments were made effective July 1st of 24.
And between July the 1st to November, when the separate, I guess it was a separate child support order, is that correct?
It's one order is what I have, yes.
When she was ordered to pay that up until January, had she made any payments?
There had not been any payments that went through until January,
Okay. And what was the date of her first payment?
January 15th of 25.
Okay. And was that a payment she made herself?
Yes.
And what amount?
$225.
All right. And then when was the next payment?
We get the records to speak for themselves, but just ask what their arrearage is.
Well, Judge, I think we need to know what her payment is because she's only made 2 payments.
What's your payment supposed to be?
Payment is supposed to be $198.50 per month, and then $25 extra anytime she has an arrearage.
How many of those payments on her own has she made?
She has made 2 payments on her own.
And when was the second one? We know the first one was in January.
The second one was April 24th, 25.
So today.
Mhm.
Okay.
What's the arrearage?
Right now, her arrearage is $172.
And is that because there was an involuntary payment that was seized?
Yes, that's correct.
Okay. So
What was that?
The amount of that payment was $1,363.
Where did you seize that from? Income tax?
Yes,
So prior to that seizure, though, she had a substantial arrears.
yes.
And when was that intercepted?
It posted on our system on April the 11th of 25.
But it's not been released yet to Mr. Ray.
No, they place a brief hold on those.
I don't have any other questions, Ms. Porter.
You have any questions? Should be excused?
I would ask that she be excused, Judge.
Okay, you may be excused. Thank you. Take the little sidekick with you there. Okay, you call your next witness?
I would call Michelle Ray.
She already. You raise your right hand and you swear the testimony that against the truth, whole truth, nothing but the truth.
Yes, sir.
Sit there, state your full name, sit down there. Lean toward the red microphone, use your outside voice to tell us what your name is.
My name is Michelle Ray.
Go ahead.
And Michelle, are you related to either Luann or Jacob?
I am Jacob's stepmother,
And how long have you been his stepmom?
13 years.
So longer than Paisley's been alive, correct?
Yes.
All right. And are you familiar with Paisley?
Yes,
And how long have you been involved in Paisley's life?
since she was 6 weeks.
And at some point prior to September of 23, were you getting to have regular contact with Paisley?
Yes, I've always had it.
Okay. Explain to us how much contact and why you were getting that contact.
From the first 3 years of her life, I had her at least 3 or 4 days a week. Thursday to Sunday most of the time. I'd get off work on Thursdays, go get her.
And during those time periods, was Jacob involved?
Did you keep her overnight during those time periods?
Yes,
Talking about full days. you're not
yeah,
talking-
full days and nights.
So I guess with that, is it safe to say you had her about as much time as Luann had Paisley?
Yes, ma'am.
Okay. And was Jacob involved during that time period of Paisley's life?
Yes.
How was Jacob involved to your personal knowledge?
he would come up and see her, or if she needed something, I'd call him and he would get it for her. Or if Luann would ask me to get her something, I'd call Jacob and he'd either bring me the money or he'd go and get it and bring it to me.
What would be things that Luann would ask for you to get for Paisley?
Everything. Clothes, shoes, juice, milk, diapers, wipes.
When Luann would bring Paisley to you, would she always bring the things that Paisley needed when she was staying with you?
In the beginning, she did.
When did
But-
that stop?
Probably when she was about 6 months.
So is that the stuff that Jacob was helping you provide then after that point?
Yes.
Now, what happened whenever you would, or did you ever ask Luann if Jacob could take Paisley?
No,
Okay. Why not?
because I knew the answer.
How did you know the answer?
Because it was well known.
Well, I mean,
Uh,
tell us,
well,
we weren't there, so you
I
gotta
mean,
tell us.
okay, like if she come in and they had went on vacation or they went here or there, she'd say, look,
Who's she saying?
Luann would say, they went on vacation and they didn't take Paisley or asked to take Paisley or anything. And Josh was her daddy, not Jacob wasn't.
So Luann told you that Josh was Paisley's daddy?
She just let it be known that Josh was her daddy. Which Josh was good to her.
Now, did you have any issues or notice anything about Paisley's hygiene or any health problems when she was bringing her to you?
She always had head lice. I always had to get it out.
Right? When she would come to you, how would you find out that she had head lice? What did
Paisley
her
would
hair
tell
look
me.
like?
Well, I would brush her hair. Well, once she got hair, she wouldn't let them brush her hair. So when she would come back to me, 9 times out of 10, it wouldn't be brushed. And we'd comb it and I'd get the lice out of it.
Did you ever have any discussions with Luann about her having lice?
Yes.
Repeatedly?
Yes.
And what was Luann's?
Luann has called and asked me to get the lice out of her head.
Okay. What was Luann's response when you would ask her about why is Paisley having lice?
She didn't know. She didn't know where it was coming from.
And so this wasn't just one instance.
No. This was like her whole Head Start year.
Now, we're here today because Luann is asking for more time with Paisley. Do you think that that would be in Paisley's best interest on what you've seen in the interactions with everyone?
I think Paisley, she was so worried about not knowing her numbers and her letters and her colors. She knows them now. She goes to school. And she's happy. She don't miss school. She gets to do what she knows. If she gets something, it's not going to be gone, or she's happy. But she loves her mama. But I think she's better where she's at.
Do you see a difference in her stability
Yes.
between the two
Yes.
places? Did anything ever happen while you and Luann and Paisley were together that makes you feel concerned about Paisley if she's in Luann's care? A specific incident when you all went to go pick up some stuff?
Yes. When they had visitation at my house, she had asked me if I wanted to go to the dollar store to get snacks for all the kids for when they come there for visitation. And I said yes. And she said that we would go to the dollar store, but
And she's Luann.
yes. And Luann said she had to wait
until she got a call back that she had to meet a man at the dollar store that he owed her money. Well, we went to the dollar store. She met the man. She got back in the van and I asked her if he paid her money and she said yes, but not all of it. Well, little did I know when we got back home, got back to my place, it was found on Paisley's tablet that Luann had left there for her. Well, Luann was still logged into her Facebook, her messenger. And it was plainly stated on there that the man we went to meet was a drug deal. And me and Paisley was with her.
So were they specific in those messages about?
Yes, yes.
You said this was while you were supervising visits. Was this
Yes.
while that issue in Monroe County with her being charged was going and she was
Yes.
required to have supervised visits?
Yes.
Okay. And did you take pictures of what you saw on that tablet?
Yes.
And was that individual Tammy Fairley's husband?
Yes. Come to find out, that's who it was.
I'm gonna show you some photocopies. Do those, if you look at those, do you
Yes, that's-
recognize them?
Yes, that's her tablet.
Are those the pictures that you took at that time?
Yes. I can't see him. I ain't got my glasses, but I know that's it. Yeah, that's it.
Judge, I would move to introduce those on the record. So as we sit here, you're saying that you see a marked improvement in the way Paisley is
100%. And I'm not out for my stepson or Luann or anybody. I'm for Paisley.
Judge, that's all the questions I have. Correct.
Well, I'm Nicholas Carter. I'm here to represent Miss Cohen. God, what was your last name again?
Ray.
Right, Miss Ray. You just told the court that the gentleman that my client went to meet that day was in fact her cousin, right?
I don't know if it's her cousin or not.
Okay. Is he in the courtroom right now?
I didn't see him. I just seen the vehicle.
So how do you know that she was messaging the person that you said she was gonna meet? If you didn't see him, how do you know that was him?
Because on the messenger, it said that they were gonna meet at the dollar store and what was gonna happen. She got in the vehicle.
How many times are you alleging this child had lice?
Well, her whole kindergarten year, she had it.
Her whole kindergarten year, she lived with
No,
your son.
Head Start, sorry.
How many times?
Every weekend,
You had her every weekend?
yes,
Every single weekend?
yes,
Okay, and you're saying every single weekend she had lice?
yes.
Did you call a doctor? Did you call social services? Did you look
No.
into if there's some problem with this child that had lice once a week for a year?
I didn't call nobody. I wasn't gonna lose Paisley.
So. How did you treat the lice every single weekend?
Well, at first I went and bought the shampoo and then I'd comb it out and comb it out. And then after a while, I'd put conditioner in her hair. Because she started getting sores. So I wasn't putting that shampoo on her. So I just combed her hair until they were gone.
Has anybody in your home used drugs or dealt drugs?
No,
Okay,
we take Suboxone.
okay. Why do you take Suboxone?
I take Suboxone because I was on pain pills from the time they started prescribing them to me when I was 9 years old.
Suboxone?
No,
Okay.
pain pills. And I went to a Suboxone clinic to get off the pain pills
When did you go to that?
5 years ago. And I ain't had pain pills since.
Was it due to an arrest or a charge or anything, or you just went on
No,
your
I've
own?
never even had a speeding ticket.
No further questions, Joe.
May this witness be released?
I'd ask that
Stay
she
in the
be
courtroom.
released, Judge.
They stay in the courtroom, man. Our next witness,
Judge, I would call Jimmy Don Abney.
Jimmy Donahue. Would you raise your right hand, you swear that this one back, Mr. Tree,
Yes, sir.
take a seat there. So I believe for the red microphone and use your outside voice to tell me what your name is.
I'm Jimmy Don Abney.
Alright, and Jimmy, is Jacob Ray your son?
Yes.
Okay. And have you been involved with your granddaughter Paisley?
Yes.
When did you actually meet Paisley and get to be involved with her?
When she was born,
So were you there when she was born?
we tried to be, but Luann had Jacob kicked out of the hospital.
And so up until the point Jacob actually got legal custody of Paisley, did he attempt to continue to try to be in Paisley's life?
Yes, we did.
Okay. And were you present when he was trying to do that?
Yes, I was.
Right. And have you tried to be involved in Paisley's life?
Yes,
What has it been like for you trying to make sure you were involved in your granddaughter?
very hard.
How?
Well, I would try to see her, but then they wouldn't come pick her up when it come time for me to go to work, when I'd have her for visits. And it was just bad. When I tried to go to work at the nursing home down here, I'd have to try to find Luann and give her back. And then sometimes she wouldn't show up till like 10:30 at night and try to say we didn't open the door to give her back. And it would just got to be so hectic.
And so let's now move forward to the point that Jacob gets custody of Paisley. Were you there whenever Jacob was trying to make arrangements to get her enrolled in school here? And did you help him with any of that?
Yes.
What did you all have to go through to get Paisley up to date and ready to go to school?
Well, she had to get all her eye exam done. She had to get her, all those physicals and stuff done. She wasn't up to date with any of that stuff at all.
And if you would tell us, what's your profession?
I'm an LPN nurse.
So are you familiar with what's required and medical treatment and things along those lines?
Yes.
And have you been involved in helping Jacob with exchanges with Paisley?
Yes, I do the exchanging so he doesn't, well, he's at work at dark because they made that, on their weekend off, they want Paisley. And then Luann gets her on the weekends and he's at work.
So have you been doing the majority of the exchanges? for
I've
that
done it
reason then?
all.
Right. What have those exchanges been like between you and Luann?
Very chaotic.
How so?
Well, I get the cops called on me. She'll call, she's been burnt 3 times. And every time she's burnt, it's right before I get her. And it's really chaotic because she's crying and they're saying
When
she
she's
wants,
crying, you mean
she's
Paisley?
crying, Paisley's crying. And they want extra time.
and all that. And then when I get her home, I find the burn area. I'm not notified that she's been burned or the situation that's happening at that moment. Because the first burn was in May of last year, and I let them have the extra time to take her to Columbia to buy her cupcakes and stuff to go grocery shopping without Jacob's consent. And I know I shouldn't have done that, but I did. I got fussed about. But when she come home, she had the blisters in between her finger.
So you're saying that happened when you allowed extra time with Luann?
No, it had, yeah.
Okay. And we all know accidents could happen.
Yes.
Did you give her the benefit of the doubt that maybe that was an accident at that time?
Yes.
Okay. Since that time, has she come back with other burns?
Yes. In December, she had one on her arm. And I wasn't notified. I found that as soon as.
When you say you weren't notified, when you went
By
to the
Luann,
exchange?
yeah,
she
at the
didn't tell you?
exchange or nothing, because I had to ask her what happened.
And have there been times that someone else has showed up for a visit that's not a licensed driver to your knowledge?
Yes. I have the text messages to prove. She asked me to let Josh Ford have her. And he does not have driver's license or could not produce a valid driver's license for me.
At that time, was anybody with Josh when he was coming to pick Paisley up?
He was driving a vehicle, which was Luann's. And then Jeff's all I saw, so that's the grandpa, Benny Cowan. And he parked at the gas tanks in his vehicle, and
So he was in a separate vehicle than what
Yes,
Josh was driving?
yes.
Okay. And did he get there simultaneously, or did he come after you were aware that Josh was there with no license?
They were waiting when I got up there.
And was Luann there with them?
No,
Who is usually the person that meets you for exchanges?
Luann and Josh. Josh usually gets out and gets her though and puts her in my car.
And since that order's been in place and you've been doing these exchanges for a while, did something happen back last month when you went to pick Paisley up from a visit?
Yes.
What happened?
The cops was called on me because they didn't want me to get her at 6:00 p.m.
Who's they?
Luann and her sister, Whitney.
And in that process, did Luann tell the officer that was there that you were not allowed to pick Paisley up?
Yes.
Did you have to contact me after hours?
Yes,
on
I sure
Sunday?
did. Me and Seth Stockton.
Okay.
We both
So-
talked to you.
The officer had to have somebody else verify that you were actually there.
Yes, I had the paperwork on my phone, but we had left it in the folder.
So you had to show him the paperwork?
Yes.
Did you also have to have him get in contact with Jacob?
Yes, I did. He called him at dark while he was working.
Have you noticed a change in Paisley since she's been spending more time with Jacob versus Luann?
Yeah, I can tell she's just done so much better.
Okay, tell us how.
She's more loving. She don't throw tantrums. The first time I took her shopping at Walmart in Tompkinsville, it was a disaster. But now she goes shopping with me. She's like a different little girl.
Do you ever help her with her homework or
Yes, I do.
schoolwork?
Yes, and they have tablets and we have all that educational stuff downloaded. We've bought like the little educational stuff for her to do her like numbers and her ABCs, because when we got her and tried to enroll her in school, she didn't know any numbers or couldn't recognize any of the alphabet, couldn't say them or anything.
And can she do that now?
Yes, and can count by tens.
And you all just actually got her full-time?
Yes,
I
and we
guess.
did Century 21 last year with her also for extra help.
Do you think it's in Paisley's best interest to go over to Luann's house more often?
I don't, because every time she comes back, we've got a burn or there's always, there's something happens.
And who is the person that takes Paisley to get medical treatment if she has to have that for these burns and things? Is Luann doing that or telling you about any of that?
No. I'm usually the first finder. I text Jacob and send him a picture. And then when I ask him if, because I'm a nurse, it's not life or death. we're going to ER because it's on a Sunday evening. And we wait till he gets home and then we'll take her to ER to most usually it's Dr. Flowers Senior at Caesar.
And there's been a report, an investigation with Paisley having bruising. Were you present when that was discovered?
Yes, I was cooking supper and the child came to me with that.
Did she point it out to you?
Yes, and I had which she's a CNA at work with me, but she was also there. And we took her in the bathroom because she said she was hurting. And I was like, what in the world, Paisley, like that? I'm grandma. And then she said, I'm hurting. And she pulled her shirt up and I seen those areas. And I'm a nurse, so first thing I think bad. But I take her in our bathroom at the house and I pull her little shirt up and then I pull her pants down. And then there's discoloration.
And was there discoloration around the area where the kidneys?
It was mostly right up here, and then there was one over on this side, but it was mostly on the right side, like 3 or 4 areas.
But did you see bruising that was up around the area of her lower
Yes,
parts of her
yes,
kidneys and things?
yes.
Okay.
It was above the waistband.
And did you or Jacob, or did you have Jacob or assist him in taking her to get her treated?
Yes, Jacob was there because they did a police report.
Okay. And did she go to the hospital?
Yes, Dr. Flowers Senior seen her.
And to your knowledge, is Dr. Flowers the one that made the report to the cabinet?
Yes, which I knew he had to.
And did you see, was it actual bruising of your experience as a nurse or was it suntan lotion?
I don't think it was suntan lotion because her hands would have been orange and it would have been other places of her body, not just in those marked areas as a nurse.
And Paisley actually told you she was.
Yeah, she told me that she had got a spanking it.
That's all that I have, Judge.
No question. Hey, you may stand down. You can stand quickly and be like, call your next witness.
Judge, I think that would be all the witnesses we're gonna call, and I'd ask our other witnesses to be released.
They can be released. You'll have rebuttal evidence.
Your Honor, I'd briefly like to call my client about to be saying.
You take a stand. You raise your right hand, you swear the testimony about gives the truth, the whole truth, you know.
Yes, sir.
You're still under oath to advise.
You heard some testimony about you meeting a gentleman at the dollar store.
Yes, sir.
All right, can you explain to the judge what happened there?
What happened, I had met him, it's actually my second cousin, Daryl Fairley.
Who was?
Daryl Fairley.
Is he here today?
Yes, sir. And he always helps me with money or if I need to borrow money. And he met me at the Dollar General. That's the only thing that ever happened. And that iPad was left at Michelle Ray's house. That's where the iPad was left.
Do you believe if there's messages that look different that somebody else sent those messages?
Yes, sir. Yes.
Would that iPad been unlocked or somebody could log in?
Yes.
Do that? Were you buying or selling drugs?
Nope.
Have you ever bought or sold drugs?
Nope.
How far into kindergarten?
Wait a second.
Sorry.
Who allegedly were those messages to and from?
What messages?
On the iPad we're talking about.
They never said the names on the iPad. Yeah.
Oh, there's names in the iPad.
Well, I didn't ever see them names.
Daryl's name is in the iPad.
Yeah, but I didn't meet him for that though.
I didn't ask you, you met, I said, who do you think put that in there?
I don't know.
Who knew that you were gonna meet Daryl Fairley?
Michelle Ray. Mm-hmm.
So that's who you think put it in.
Yes, sir.
Go ahead.
How far into kindergarten did Paisley go while she was in your care?
Maybe a half a year, not even that.
Right. When you got arrested, as in September, right?
Mm-hmm.
Was that September of her kindergarten year?
Yes.
School starts in August,
Yes.
end of August?
Yes, something like that, yeah.
Okay, so a few weeks maybe.
Yes.
To your knowledge, how many times has Paisley had lice?
Once, that I've known of, yes.
And was that Did Miss Ray help you with that or help?
Yes,
with
ma'am. Yes, sir. She sure did.
that? Nothing further, y'all.
Judge, I don't have any other questions.
You may stand down. Mr. Carter, you want to make your argument?
Yes, Your Honor. First and foremost, I have nothing to justify, and my client doesn't either, cigarette burn of the child. It's just inexcusable, and she knows that and is aware that that's going to have an effect on your decision today. That aside, the allegations that keep getting pointed to against my client have not been proven. There's been no, there's been accusations that she's abused the child or let the child be bruised in her care. Nobody apparently reported that to any authorities. If they did, nothing was done about it. There's really nothing proven that anything other than a child being bruised, that a child can be bruised, occurred. There's been a lot of testimony that since this child has been in Mr. Ray's care, that it's improved. And I would twofold say, I'm sure that's the case, Judge. My client is not trying to convince you she's Mother of the Year. She recognizes mistakes she made and was making. There's a reason he got the custody he did. But on the other side of that, Judge, this child was a mere matter of weeks, less than a month into kindergarten at the time. She's gotten.
Let me ask you something.
Yes.
It's unrefuted that she didn't go to Head Start, right?
I'm a little bit confused on that because I thought there was testimony that she did.
She didn't go to Head Start.
I thought Miss Ray testified that she did go to Head Start, so I maybe misunderstood that.
Don't say anything back. You need to be quiet back there.
I understood that she did go. I may be wrong.
Maybe I misunderstood. Well, let me ask you about the dental situation.
Yes, sir.
Lack of a pediatrician, the lice, the cigarette burns. The bruises are questionable, might have been, might not, people get bruises. The lack of academic progress, all those sort of things collectively appear to me. And the inconsistent statements that your client made concerning what happened with the other child are troubling to me. I'm not going to ask you to explain those inconsistent statements because you can't be as counsel expected to change the testimony of your client. Those are troubling. Now, what kind of visitations is your client getting now?
Your Honor, my understanding is every other weekend, alternating weekends with the child.
From what, Friday till Sunday?
I believe that's the case, Your Honor. I could be correct. That's my
Okay,
understanding.
continue with your argument.
Judge, I would think that at this age, regardless, the child is going to show improvement in their maturity, in their learning. I mean, kindergarten is where you learn a lot of the things that she's learned in the last year, that since she's been there. And I'm not taking anything away from what Mr. Ray has done with this child. Sounds like, by all accounts, he and his family have done a remarkable job with this child. We're not saying anything about his care. And Judge, we're asking simply for more time with this child. There's been obviously carelessness that led to the cigarette burns, but there's been no evidence, there's been evidence that she is a good mother, that she's a capable mother, that my client's raising children with Mr. Ford in their home. They have a loving home. It's been pointed out by Ms. Capps that it's not the biggest home and there's a lot of people living in it. I'm not asking you to grant my client primary custody of this child, Judge. She's simply asking for more time. And to go further, we're not asking that the kid be made to get up every morning in Monroe County and drive to school in Cumberland County or anything like that. But there are breaks, there's summer breaks, there's fall breaks, there's Christmas break that she could have more time with this child than she has and garner a chance to prove herself as a mother. There's a reason that custody is right now or visitation is right now the way it is. We're not here to dispute that, Judge. Simply asking for an opportunity to to show that she can do better. And Your Honor, I would like to point out that through all this allegations and investigations, social services has not taken her time or limited her time with Paisley, and she's fully cooperated with them. Not argue as bad as those burns are, and there's no justification for them that it is, for lack of a better word, very poor timing for something like that to happen when she sat here and filed a motion, and then for that to go down. But Judge, she's simply asking that a lot of the issues that led to this situation have fixed themselves, and she's asking for more time with her child. And I do think the law favors each party having as much time as good for the child. So that's what we're asking for. Yes, Your Honor.
Favors equal, but
When-
so that can be overcome. A lot of people think that's an automatic. But as you and I both know, it's not an automatic.
I agree.
Make your argument.
Judge, first to address simply, she has holidays in the agreed order. They split breaks. She's got extra time in the summer. So, they're asking for more time during the week when this child is at school. I think given the testimony that's been shown today, along with the documented evidence of the photographs, we understand accidents could happen, but we're not talking about something that's just minor. We have a child that is repeatedly coming back with burns. We have questionable bruising. And not only do we have that, but we have a person that's supposed to be a joint custodian that doesn't communicate any of that. Doesn't take the steps to seek any type of treatment for the child, even though when she's confronted with it, she acknowledges, yeah, that happened, and she's explaining away what happened. But she didn't do anything for a child to take care of her child.
She didn't admit it until she was caught.
Until she was caught. Because initially.
I've heard enough here. It would appear to me that at this time, the overwhelming evidence in this case would indicate that in the best interest of the child, because of all these things that have happened, that this agreed order that is in place should stay in force. I will say, Mr. Carter, you make some really valid points in anything about her not having been represented at the time, but she has been ably represented now. You vigorously cross-examined witnesses and brought witnesses on. I quite frankly just don't believe her on the things she says. She was contradicted too many times. I don't doubt that she loves this child or her other children. And I really think that the father of her other children loves this child and the other children also, and that he's doing the best. But I just don't see that it's anywhere near the best interest of this child. The other thing I'm going to do is I absolutely don't believe it is incredulous that your client would try to make me believe that somebody else got on this iPad and created these messages because someone was responding to the messages. I mean, it would take a master criminal mind to send these messages out and get a response back and forth. And that sort of way, I'm actually going to refer that email chain to the state police and ask that they take a look at that, because, ma'am, if that's true and somebody did create that falsely to try to damage you, that's criminal activity there. And if you did it and you lied about it, that's criminal activity. Somebody has done something wrong when something like that happens. We'll get to that. We'll get to the bottom of that. And after counseling with your attorney, I would suggest that you not say anything else to anybody about it until you consult with him and you are Mirandized. If anybody questions, I'm not interfering in your business. So I want a judgment keeping the visitation and child support the way it is, knowing that the ultimate goal in all of these cases is to work toward equal time, more time. I just don't think it's been long enough yet. I don't think the trust has been established. I think the child is well established. And it appears to me that when she does come, that she and her other siblings are developing a good relationship. Every other weekend is not a whole lot, but considering that, I'm actually surprised we gave that at the time. But I remember I wasn't sure of some of the allegations, and I think that decision was a correct one, and I'm gonna leave it in place because I believe that's in the best interest of the child. And at the same time, we're gonna have to lay down, both sides are gonna have to lay down the fact that this is an adversarial hearing and y'all both said things that hurt each other's feelings. You know, that one or the other of you might not think is true, and continue to have enforced a status quo order where neither one of you has said anything bad about the other parent. And I haven't heard any testimony about that yet, where either party has said something to this little girl disparaging. This little girl needs both of you. And sometimes later on, she'll understand why these things happen to the family, but she can't understand it now. And she's got a stepdad that loves her and would take her as his own. That's worth the weight in gold right there. And evidently, the stepdad is someone that the biological dad trusts. You don't know what that's worth. So many times I see these little girls put in a situation where something happens to them. And that has not been, I'm very proud that has not happened in this case. So if you'll draft an order and circulate it to Mr. Carter, and saying, Mr. Carter, nothing in this order here will keep maybe a few months from now for y'all bringing that back up, and we'll get some reports and some trust is built up and everything, we expand it. And if the agreed order, I want, Ms. Capps, I want y'all to look at the agreed order about the holidays and make sure the holidays are expansive enough. Because the holidays are important, spring breaks are important to bond with kids and that sort of thing. And I want to make sure they get that time where these siblings especially can spend time with their older sister. Thank y'all for the way you all conducted yourself here today. The attorneys, both sides should be proud of the job their attorneys did. They were very good advocates and didn't even snap at each other, which happens sometimes. So thank y'all very much. And that concludes business of the Cumberland County.
Talk to y'all. You're go get rid of it.
Copies.
Good luck. I'm going to all the food. Y'all just wait.
Yeah. Keep them water.
But she's gonna get there.
Probably get paid big money for extra family work.
Yes.
At least in Oregon,
It's not all the.
Can you imagine being a family? All this stuff. Can you imagine a family?
I had